Let's say the pledge this morning, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. All right, good morning, ladies and gentlemen. Hope you all enjoyed a nice weekend. Thank you all again in advance for your conduct and not making any distractions while you're here in the courtroom. That helps out very much. It's just not the best room for sound. It's a beautiful courtroom, but that helps out a lot. I understand the jury's ready. Anything we need to take up from the state's perspective before we start this morning?
Hang on.
Ms. Merchant?
Yes.
Okay.
Judge, there were a series of questions when Agent Shadell testified that the state asked in regards to this photo. And I don't think the Elmo's up, but it's the photo of Miss Grinstead's door.
Right.
This photo.
What number is it?
It's Defendant's Exhibit 1 and it's State's Exhibit 76.
All right.
There were a series of questions posed by Ms. Hart about how you can't see this part of the door jamb. And
that might match up to the top sliding lock. Is that what you're?
Yes,
yeah,
Judge.
I remember those questions. Sure.
Those questions, yes, and about how it could, a public bathroom, the lock could be broken, how you can't see it in the picture, things like that.
Right.
And so I left on Thursday and I went back through all of our photos and discovered that there was, so when we got discovery, every single picture we had was in color except one. And that picture, so what we did when we got discovery is we printed all the photos out, and everything is in color except for one photo. Okay. And so in this photo, I couldn't tell that it was that same door, but it's the only one that's in black and white. So this weekend, I took the hard drive that Ms. Hart gave us on the first day of trial, where she copied her file, and I found that picture in color. And that picture shows clearly that lock is completely functional. It's a picture that the state did not put into evidence, but it is evidence that lock is completely functional. Right. And so that line of questioning, we believe, was in bad faith. There was no good faith basis to ask those questions because the state has a photo that shows that lock is completely functional. And so, trying to figure out what the remedy is, the only thing I can imagine is, since there was no good faith basis for the questions, and now we've discovered that, is if the jury is instructed to disregard that line of questioning. It's the only thing I can think of to cure the issue.
Anything further? Have you marked that new photograph that you produced today?
I did, and in response to this, I contacted Detective Bars and I asked him to come testify during our case, and so we plan on admitting this photo. It's the only one that wasn't admitted through the state's case in chief.
You satisfied he took that photograph, I guess?
He can identify this photograph as one of the ones that law enforcement took that night. I think actually one of the GBI agents took it, because how it came to us, it came in a file.
What's that guy's name, Rossler or something like that?
Rossler, yes.
Yeah,
yes.
The crime scene guy? Yeah.
And I'm happy to have Agent Rossler come back, but he's coming from Atlanta, and I don't know that he wants to. So Detective Bars can authenticate this photo. It's a photo that we received in the state's discovery, along with all the other photos that they.
How many photographs were there total? Do you know? Ms. Hart will know that.
I don't know.
Approximately know. A bunch of them.
A bunch of them.
All right. Thank you.
Thank you.
Ms. Hart, what to say to the state?
As it relates to whether or not there was a good faith basis for my question?
Yes.
Your Honor, and I believe I even objected to this at one point. He was being asked to testify as to pictures that he had only ever seen in the case file, and he even, I believe, went so far as to say...
Now you're talking about
Jason Shadell. No, Jason Shadell.
Right.
And so my purpose in questioning Agent Shadell was to show that he had no personal knowledge, and all he was being shown was a picture. I will let the court know. I actually went back through our pictures as well to see if there were any more before I asked those questions, and I did not see the picture they're looking at. To state that all of our pictures were printed, but that one's completely inaccurate. There were other pictures that were duplicates or similar pictures that we chose not to use because they didn't seem to prove any case. So I do believe I had a good faith basis to ask the question, because the whole point was to show that he was being asked to speculate on things that he knew nothing about. And so
from the pictures that he was presented at that time, is that what you mean?
Yes, Your Honor. They've shown a number of people that picture who have testified that they have no knowledge of what that door actually looked like, but they've asked them to speculate about it.
Did you present that picture to Mr. Shadell or Agent Shadell on direct, you recall?
I believe it was redirect, but I wouldn't.
All right.
I don't recall, Judge.
Anyway,
As to the picture being tendered, I will indicate now, Mr. Rigby spoke with Mr. Bars, or excuse me, with Officer Bars. He did not take that picture. It was taken by Agent Rossler, and I don't know that he is going to be able to say that that is a true and accurate depiction of what was taken by law enforcement. We don't object necessarily when the proper foundation is laid, but I don't think that Officer Bars, similar to the other pictures he was shown, because the GBI took their pictures afterwards. And so I don't know that he's going to be able to authenticate it, but certainly Agent Rossler could.
It was within 24 hours, wasn't it?
It was, Your Honor. And again, if he's able to say that, I'm just repeating what sort of came through third channel since Mr. Rigby handled Officer Barr's testimony, but I'm not sure that he is going to be able to authenticate that. But again, I've looked for it in our pictures as well and didn't see it previously, but it's very low foundation.
Well, he can authenticate it without having taken the picture.
I agree. If he can say that that's what a true and accurate depiction of what it looked like on that date.
I got you. You were, and you'd spoken to him, is that right?
I did. I spoke to him, and he did not take the picture. Agent Rossler took the picture, but he can identify it as a fair and accurate description. But we are happy for Agent Rossler to come on back down and testify about this picture. That would even be better than Detective Barr's doing it. I was trying to save Agent Rossler a trip, but
I can't remember if he's been released or not. But you intend to present it in your side of the case?
If the state does not present it, yes. And so just so I'm clear, is the state objecting to this photo? That once I don't really understand if...
I'm not objecting. I'm just letting you know what's been indicated to us is that I don't know that Officer Bars can authenticate it. But if he can, of course not. I don't object to any pictures from that day that have been shown so far coming in.
I bet he can authenticate it. We'll see. All right. Anything further? I don't believe there are hundreds, looks like, photographs of these of the scene. I'm not going to find any bad faith undertaken on behalf of the state in that regard this morning. All right. Anything further, Ms. Merchant?
No, thank you, Judge.
Okay. Ms. Hart, you ready?
Yes, Your Honor.
Or is your next witness present?
Yes, Your Honor.
All right. Ask the jury to join us, please. Thank you. I got your request to charge. Thank y'all. Got both sides. All right, good morning, ladies and gentlemen. I hope you all enjoyed a nice, relaxing weekend. But Monday morning gets here inevitably, doesn't it? So it's back to work. We left off Friday with the state still presenting its case in chief, so that's where we'll pick up again this morning. Ms. Hart, please call your next witness. Mr. Rigby's going to call the next witness.
Yes, Your Honor. Thank you. State call Todd Crosby.
Good morning, sir.
Good morning, sir. How are you?
Good. Before you're seated, if you'll give your attention to Mr. Rigby there, he'll swear you in and then direct your testimony.
I solemnly swear from the testimony about people who report in this case with the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated. Thank you. You want some water? You got one?
Thank you,
All
sir.
right.
Introduce yourself to the jury, please, sir.
My name's Todd Crosby. I'm a special agent with the Georgia Bureau of Investigation.
And Mr. Crosby, if you'll spell your first and last name for the court, please.
Toddcrosby.
And with regard to being a special agent for the Georgia Bureau of Investigation, how long have you been employed with the Georgia Bureau of Investigation?
21 years.
And part of your what you currently do for the Georgia Bureau of Investigation.
I'm an agent in the Thompson, Georgia office.
And throughout your years of experience with the Georgia Bureau of Investigation, have you been a part of crime scenes?
Yes, sir, and still am.
All right. And will you give the jury the benefit of your training experience regarding crime scenes?
I've been processing or working crime scenes since 1998. Have over 1,800 hours of training in forensics and advanced forensics. I've attended the National Forensics Academy, which is a 10-week program in Tennessee Some people call that the body farm training because there's a week in there where we spend a week at the body farm. I actually teach for the National Forensics Academy now. I teach crime scene management classes as well as latent print processing classes as well as bloodstain pattern analysis classes.
And have you testified regarding the results of your crime scenes in courts of law in this state?
Yes, sir.
All right. I want to direct your attention, Agent Crosby, back to February of 2017. Did you come to a location in Benil County known as Fitzgerald Farms?
Yes, I did. On Monday, February 27th of 2017.
Now, with regard to that area and location, did you meet with a person you came to know as Randy Hudson?
Yes, I did.
All right. And with regard to meeting with Randy Hudson, did you go to a location near a pine thicket on that day?
Yes, I did. Mr. Hudson carried us into some standing pine trees, down a logging road to a second logging road that was off the main logging road, and showed us an area where a burn had occurred in 2005.
And with regard to that particular area, what, if anything, did you do at that point to begin searching for remains?
Yes. Mr. Hudson pointed out an area to us, and he said that there had been a burn there of households. He said he remembered seeing household trash in the area. When he pointed out that area, I used a search technique, witching or dowsing. You've heard of witching for water. You can also do that for bone. After a person dies or an animal dies, the bones start giving off a magnetic field. That magnetic field will cause the metal rods to cross or react, and you'll get a hit or indication that there's bones in that area. I started walking in the area that Mr. Hudson pointed out, and I actually got a reaction with the bones being in that area. So I marked that area, started just walking around looking, and I started seeing remnants of household trash, like some broken glass, the screwed metal end of a light bulb, a fork, a broken plate. So I started walking in that area also, using that search technique with the rods, and started getting indications for bones being in that area. Now keep in mind, this search technique, the rods doesn't discriminate between animal and human. It just says there's bone here. It also reacts with running water, because people have used this technique to find underground water lines, but it also reacts with quartz. If quartz is in the area. And so I would walk in the area, started getting an indication that there was potentially bones in that area, started marking the area, and so now we got two different locations that we've identified, the one by Mr. Hudson and then the one I found just walking around and looking. The area we found that Mr. Hudson pointed out, we marked as Pit 1. The area that I found, we marked as Pit 2, and that was it for today, on that particular day. Because we knew we were going to need a lot of logistics, a lot of manpower to excavate those areas. So we left for the day and started getting together the resources to come back the next day and excavate there.
Now, you talked about this search tool or this technique that you use called the witching technique. Is that right?
That's correct.
Now, did you bring something with you to demonstrate how you did that and what you used with you to court today?
At your request, yes, I did.
And what did you bring with you to demonstrate this particular technique?
I got some non-human bones here. It's just, I think it's a deer tooth and then some fragments of a deer remains. The metal rods here, these are nothing more than clothes hangers. Just uncoated clothes hangers. And then I hold these into a straw. A lot of folks will say, oh, this doesn't work, this is hocus pocus. And I put them in the rods, that way people won't say, well, he's twisting them. So I just let them swing freely.
Okay. And with regard to this, is this the technique that you used out there at the site when you had, went to the locations that you found, Pit 1 and Pit 2?
Yes, it is.
All right. And with that, demonstrating this, assist the jury in showing them how you did that?
Yes, it would.
All right. So at this time, I would ask Agent Crosby to step down and be able to demonstrate this for the jury, please.
Any problem? No. Thank you. Agent Crosby, you welcome to step down.
Yeah.
Sure.
Agent Crosby, again, this This box that I have here, what is contained in this box?
Bones from a deer.
All right. And where would you like for me to put
If
it?
you would, just hold on to them real quick. So,
Okay.
first I'm just going to walk this area right here before we put them down. This is kind of a control. I want to make sure there's nothing up under here that's going to react with the rods. So it's just a steady pace, not in a hurry. And so you've seen they have not crossed. So Mr. Rigby, if you would.
Y'all need to stand up, of course, ladies and gentlemen, in the jury box.
Would you like me to move it out this way, maybe?
Mr. Murray, if y'all want to.
Well, pick it up and walk that area, then just where they'll.
Okay.
You'll see that there's no reaction in this area. And then, and I tell you what, I'll come straight toward you, that way you can see. And then once you get over the rod, and when the rods get over the bones, they cross. And that's the magnetic field coming off of them. I'll do it one more time. Now, this technique we can use in a general area. If you walk me out in there, into an area and say, it's here. This would be what I would use, is I would just walk a grid using this. Now, if you said no, if you give me a 100-acre field and you say it's somewhere out here, there's also, you can stagger them, and whenever they get in line to the source, the top antenna turn. You'll get a reaction. So that's technique, that walking the grid more or less technique is the technique I use over where, in both the area where Mr. Hudson showed us as well as in the area where there was household trash.
Thank you, sir. Agent Crosby is going to show you a series of photographs, those being State's Exhibits 190 through 196, and ask if you'll look at those, please, sir. And once you've had a chance to review them, if you'll just let me know.
Yes, sir.
Are you familiar with what's shown in each of those photographs?
I am.
And generally, what do each of those photographs depict?
Shows household garbage that was out there at the site.
Now, do each of those photographs truly and accurately depicts the pit areas that you described for us earlier,
Yes, it does.
and items that you found there in those locations?
Yes, it does.
Judge, at this time I would tender State's Exhibits 190 through 196.
Would this be dig site 2 that you?
Yes, sir. This is in pit 2. Yes, sir.
All right, Mr. Murphy, any objection?
Okay.
Thank you. Those are admitted without objection, 190 through 196 included.
Crosby, are you able to see the screen before you there?
Yes, sir, I am.
And I'm showing you State's Exhibit 190. Are you able to describe that photograph for us, please?
It's the bottom of a broken bottle that we had found there in pit 2.
And State's Exhibit 191.
I'm just some more glass that was laying around. And so the area where this all was found and where pit 2 was, and we got to hit with the rods, it was a fire break that had gone through there. So there was a lot of broken glass and all, down that fire break where the tractors had come through and drug the plow and broke the glass. So we could see a lot of this debris on top of the ground.
And State's Exhibit 192.
Again, broken glass. Appears to be from some type of beer bottle, or it was that color.
And State's Exhibit 193.
This is a bunch of glass, broken plate. There's a bunch of household debris in this. So once we've identified this pits, we grid them out. So like the one that Mr. Hudson has shown us where we got to hit, we just made it a 10 foot by 10 foot, split that down into 4 different quadrants, and then started sifting through the dirt and all. And so this was out of the second pit where we were getting indications with the search technique. And we started out with a 20 foot by 20 foot grid area. And we broke it down into 4 different quadrants. And each quadrant is assigned a number or a letter. In this particular case, we use letters. And each quadrant has 3 or 4 buckets assigned to it. So, and this is not like your typical with a shovel dig. This is hands and knees, removing it with small spades and dustpans at a time. Then that bucket is carried over to a sifting station. And we started out sifting with a 1/4-inch screen, and then once the dirt had gone through it, and we were pulling debris out, so a lot of this debris was under the ground, under the dirt, we would sift it once again through that 1/8 of an inch screen. Just that finer screen, that way we're not losing evidence. This was a long, very tedious process. This was 3 days of 57 GBI agents out here digging, sifting, and this is what we were finding under the dirt in those quadrants for that second pit.
Now, with regard to this item that the trash is contained on, what is that item?
That's one of the sifters. That's one of the sifters that we would use. So this would hang from a tripod, and we also had commercial ones out there that were made out of white plastic with the 1/8 of an inch screens, and you would just literally put the dirt in, shake it, dirt falls through, and you would start picking out whatever evidence is there that you would find.
And State's Exhibit 194.
Again, some of the debris, the household debris that we were getting out of the pits, out of that pit number 2 that we got to hit with.
And State's Exhibit 195.
Just a closer up picture. Some of the bigger pieces that we were finding, that up there in the white, and I think that's green colored, that was a piece of plate, that broken plate that we found.
And State's Exhibit 196.
And again, more of that household debris that we were pulling out of pit number 2.
Show you another series of photographs, that being State's Exhibits 197, 198, and 199. 205, 206, 207, 208. 209, 10, 11, skips 212, but then 213 and 214. Now,
Yes, sir.
are you familiar with what's shown in each of those photographs?
Yes, I am.
And generally, what do each of those photographs show?
This actually shows the dig process in pit number 2. Shows us removing dirt, sifting through the dirt, and then if we found an item we thought may be bone, We would then take it over to Dr. Alice Gooding, and she would identify it as human or animal remains.
And do each of those photographs truly and accurately show the excavation and the dig process of looking for the remains of Miss Grinstead?
Yes, it does.
So at this time you would consider State Exhibits 197 through
Looks like 197,
199,
199.
205 through 211, and then 213 and 214.
Right. Any objection? Thank you. Those are admitted without objection. Thank you.
I'm going to show you State's Exhibit 199 and ask if you're, whoops, I think I hit the wrong button there. Uh-oh. Sorry. I hit a shutdown button. Cancel. Maybe that'll work.
That will. Probably have to double click it.
Thank you. Are you able to see State's Exhibit 199 on the screen there?
Yes, sir.
And tell us about State's Exhibit 199, please.
This is pit 2, and this is where we've excavated this area, or getting ready to. So the first step in all of this was to remove the ground debris, the leaves, the pine straw, and you can see how clean this ground is. Now, we just don't remove it. We put it on the tarps, take it to the side, and actually go through that debris by hand, looking for evidence, looking for remains, whatever may be there, we want to try to find. So that's what we've done here. We have removed it, all that ground debris, and now we're starting to mark out our quadrants.
And I think I got them out of order. I should have showed you 197 first, and State's 197.
All right, so this is where we've removed the ground debris, and you can see the 5-gallon buckets there. All of those, the letters on those correspond to the quadrant we're digging in, and they're actually removing dirt from those quadrants to be sent over to the sifters to be gone through. Again, just part of the dig process. You can see the tarps there. You can see the 5-gallon buckets, and we're just removing dirt, removing that top layer of dirt. And when we do this, we're not digging down real deep at first. We're taking off a 1/2 inch of each quadrant at a time. And so it's a slow, methodical process, and then this is all taken over and gone through with the sifters.
And State's 205.
And now you can see here's some of the sifting process. You see a tripod down at the end. That's one of our sifters, as well as these 2 white sifters right here that are commercially bought. So we had some of each out there. We actually made a bunch of the 2 foot by 2 foot sifters with the 1/4 inch hardware cloth in it. These white sifters are 1/8 of an inch. So as we go through it with 1/4 inch, and then we do it again with that 1/8 of an inch, just being real thorough.
And State's Exhibit 206.
Again, just digging, removing dirt, and going through it, looking for evidence, looking for bone.
Now, you mentioned earlier the lettered quadrants. Is that what's depicted here on the photograph?
It is. So the first quadrant that Mr. Hudson pointed out, when we broke it down to a 10 foot by 10 foot and then broke it down into 4 different areas, that was A, B, C, and D. And once we got finished with that, we did find bone there, but it was animal bone. It was non-human. That's when we move over into this second pit area, and now we're starting with G, and going on up.
And And states 207.
Again, marking out the quadrant, and you can see this is a good example of how deep that we're going a little bit at a time. We're not digging with a shovel, we're not in a hurry, we're just removing that dirt a little bit at a time, putting it in the bucket, taking it over to the sifting station.
And states exhibit 208.
Same thing, just another quadrant. So what we do is we work a quadrant, and we'll dig down, take it to the sifter, go through it. If we found, remains in it, bones in it, we'd go back to that quadrant, we'd do it again, go down another ½ an inch, and continue that process until we didn't find anything. And if let's say in quadrant G, we're digging, we find something, we don't go down another ½ an inch, we take it over, sift it, we find something else, we don't go down again, and then when we don't find anything, we're going to do it one more time, just to make sure we're being thorough with that. And once we have not found anything 2 times in a row, we just stop in that quadrant and move on. Remember I told you earlier that this was in a fire break. And so we went out, we probably went out 40 or 50 feet from that original site, and we're still finding bones where it had been drug along with the tractor as it went through cutting that fire break. So that's why you don't see that this keeps on getting longer and longer and longer, and all we did was we just kept on adding quadrants to it.
And states exhibit 209.
Again, digging. We've done a triangle pattern here, and we're digging down, and so we start on the inside and just working our way out, because they'll finish digging this quadrant down all the way level. It won't be a diamond anymore.
States exhibit 210.
Same thing, just digging down, taking it to the sifter.
And states exhibit 211.
Just a further back view of what you've already seen of us digging down and doing the excavation of that area.
And states exhibit 213.
Same. That's that in the middle that you're seeing there. That was the first quadrant we've done, and then we're starting to expand it on out.
And states 214.
So this is Dr. Gooding and Dr. McClung, and as we found bone, we would take it over to the table. They would wash it off, and she would identify it as human or non-human.
Well, when Mr. Hudson directed you to a certain location to look, how close was that to the area where human bones were actually found?
20 yards. He was within, so the first area he showed us, 20 yards away is where we found the debris and started getting an indication with the search technique.
I don't have anything further to make problem.
All right, Mr. Murphy, any questions for Agent Crawford?
Good morning, sir.
Good morning.
All the work you did was in Van Hill County, is that correct?
Correct. No, yes, Ben Hill County, I'm sorry, yes.
All right, thank you, Judge Sullivan.
Yes, sir. All right, anything further for Agent Crawford?
No, Your Honor.
Any reason he shouldn't be excused?
No, Your Honor.
Thank you.
Thank you, Your
Agent
Honor.
Crosby, thank you for your testimony. You're welcome to stay go. You'll be released from your subpoena. The only thing I'll ask you is don't discuss the testimony you've given here this morning with any other witness in the case until the case is concluded, okay?
Yes, Your Honor.
Thanks
Thank
so
you, Judge.
much. To be excused. Call your next witness, please.
Second call, Romy Franco to the stand. Romy Franco, I think she's in our office. We don't need it, Madison Holland, we need Romy Franco. Thank you, Judge.
morning. Is this Ms. Franco?
Yes.
All right. If you'll step up right there, please, ma'am. But before you're seated, please give your attention to Ms. Hart here. She'll administer the oath and then direct your testimony.
I'll get you to raise your right hand for me, please. Do you swear or affirm the testimony before this jury will be truth, whole truth, and nothing but the truth? Thank you. Okay, have a seat for me, please, ma'am. Can I get you to introduce yourself to the jurors and tell them what you do for a living?
My name is Romy Franco, and I'm a senior forensic analyst at the UNT Center for Human Identification Laboratory.
Okay, now, where is that? You said you...
Speak up a little bit, please, ma'am. Thank you.
Where is it that you said you work?
I work at the UNT Center for Human Identification Laboratory in Fort Worth, Texas.
And what does UNT stand for?
UNT stands for the University of North Texas.
And what do you do at the UNT Center for Human Identification?
As a senior forensic analyst, I examine evidence such as skeletal remains. I perform DNA testing on those samples. I analyze genetic data. I write and review DNA association reports, and I provide expert witness testimony.
Okay. What sort of education and training do you have to be able to do that type of work?
I have a Bachelor of Science in Genetics from Texas A&M University and a Master of Science in Forensic Genetics from the University of North Texas Health Science Center. And in order to do our job, we have to receive on-the-job training, and it takes around 6 months to a year to actually become a qualified analyst.
How long have you been an analyst at UNT?
I've been at UNT for almost 7 years, and prior to that, I was a senior forensic analyst at a private DNA testing laboratory in Dallas, Texas for 10 years.
Now, as it relates to UNT, is that an accredited laboratory?
Yes, we are an accredited laboratory.
Can you tell the jury what we mean when we say that you're accredited?
To be accredited means that our laboratory has been audited by an accrediting agency called ANAB, and they review our documentation such as our standard operating procedures, our quality manual, review our personnel binders to ensure that all the analysts in the laboratory are proficient and have the proper training and education background to perform the work. And they do external audits, or they visit our laboratory every year, and they make sure that we are in compliance with FBI quality assurance standards.
I think I understood you to say that part of your job assignment is to do expert testimony. So let me ask you, have you ever testified in courts before?
I have.
And have you ever testified as an expert in different courts?
I have.
Could you estimate for the jury how many times you've had an occasion to testify as an expert in court?
I've testified more than 20 times.
And that all in Texas, or have you testified in other states besides Texas?
I've testified in other states, including Georgia.
And in Georgia, were you deemed an expert?
I was.
You know, at this time, I would move to tender as an expert in the field of DNA analysis.
Okay. Any objection or board action for qualification? Ladies and gentlemen, this next expert witness has been tendered and accepted by the board, and both parties is now qualified in her field of DNA analysis. As I've instructed you before, you give whatever weight of credibility you believe to this testimony is appropriate. Thank you. Go ahead, Ms. Hart.
Was UNT requested by the Georgia Bureau of Investigation to attempt to collect DNA related to bones in this case?
Yes, the laboratory was.
And specifically in your job as a DNA analyst, have you often worked with human remains of this type?
Yes.
Now, to be clear, are you the original analyst who extracted or attempted to extract the DNA from these bones?
I was not the analyst that examined the evidence or performed the DNA testing on the samples. However, I did review all the work that was performed in this case.
Okay. Did you review that work just to come testify today, or did you review it back in 2017?
I did it back in 2017.
And what was the purpose of reviewing that evidence back in 2017, or the work back in 2017?
So all the casework that goes through the laboratory is performed by an analyst. They process the evidence throughout the laboratory and do what is called first analysis, We then have what is called a technical reviewer that goes behind that analyst and reviews all their work and documentation, and also performs another independent analysis and verifies that the conclusions the first analyst drew are the same as the second analyst.
What happens if the technical analyst does not get the same results as the original analyst?
If there's a discrepancy between the first and the second analyst, we then discuss that, either come to a conclusion, and so that the data that we report is concordant. If we cannot come to an agreement, then we go to our technical leader in that case, where they make the ultimate decision. But in this case, the data that the first analyst concluded was the same as what I concluded.
And what was the name of the original analyst in this case?
Her name was Barbara McCarty.
And Ms. McCarty, does she still work for UNT?
She's no longer employed at UNT.
Where is she? Do you know where she's working now?
Yes, she is a quality manager at the Tarrant County Medical Examiner's Office in Fort Worth, Texas.
And are you familiar with that medical examiner's office in Fort Worth? Somewhat?
Somewhat, yes.
Do they do similar work to what you do at UNT?
Yes, they also provide DNA testing. However, she is no longer an actual DNA analyst.
In her job assignment now, would it be fair to say she's been promoted, I guess, or gotten a job at the higher level?
Yes, it's a more of a managerial position.
Okay. So in this particular case, as part of the case file that you reviewed and making your own analysis, did you have pictures of the bones or human remains that were submitted to UNT?
Yes, pictures were taken during the time of exam.
Additionally, did you have descriptions of those bones as well?
Yes.
Can you tell the jury how many different bone fragments or human remains were tested in this particular case?
May I refer to my...
Sure, yes, that'll refresh your recollection.
At the time of testing, the analyst at that time selected 2 bone fragments for testing.
Okay. And so the jury has an idea of what we're talking about here. Does it document in your report how small or big those bones were?
It was described as a possible tooth and a possible bone fragment, and then based on the pictures that were in the file, they were pretty small fragments. I would say approximately 1.5 centimeters long.
Exhibit it to the jury. I'm going to show it to you. This has already been admitted into evidence. It states 238. I'm going to ask you to take a look at these items and compare them to the items that you have in your case file for me. Chance to look at those. Do those appear consistent with the items that were submitted for testing in this case?
They do.
Okay. Now, the items that were submitted for testing in this case, specifically the 2 that were tested, the bone and what was the other one you indicated? Or excuse me, the tooth and what was the other one you indicated?
A possible tooth and bone fragment.
Were those specifically consumed in the testing, or was just a portion of those taken for the testing?
Those samples were consumed for testing.
And when we say consumed for testing, how do you actually go about attempting to extract DNA from a possible tooth or bone fragment of this nature?
Well, these samples prior to DNA extraction were prepared by decontaminating the outer surface In this case, because of the condition of the samples, the technician at the time, she just wiped it off with what's called Turgizyme, which is a soapy detergent, just to remove anything on the exterior surface. And then that sample was subsequently washed with water and ethanol, and then it was crushed into a fine powder, and it is that fine powder that is then used for DNA extraction.
I'm looking for Unit J, Item 1, if you happen to see that. That's Unit J.
Okay. I think it's this one.
Thank you. Showing on the screen, it's been previously tendered as State's Exhibit 267. Can you see that on the screen in front of you? I'll stop. Your Honor, I apologize. Oh, thank you. Sorry. Can you see that on the screen in front of you?
Yes.
Okay. And then I'm going to show you one of the bags that came out of this exhibit that we will label in just a moment. Do those appear to be the same bone fragments? Based on the labeling and the way they appear?
If that's Unit J, Item 1, then yes.
Sorry, okay. I just realized it is difficult to see up there, isn't it? Let me zoom in a little bit more. You see it better now?
Yes.
Okay. Your Honor, at this time I would like to be able to pass around, and again, we'll mark this specifically since I intend to pass it around, the actual bone fragments so that they can compare the size to what's in the picture.
Mr. Merchant, any objection? No objection. Okay. That'll be fine. That's a sealed envelope, right?
It is, yes, Your Honor. We'll mark that, Judge, as State's Exhibit 285A.
Be fine.
Okay, so back to the actual testing that was done on the bone fragments or the possible tooth that have been consumed. In this particular case, what sort of DNA were you looking for from those fragments?
We were attempting to test what is called nuclear DNA, which is the DNA that is inherited from both your mother and your father. And in addition to that, we tested what is called mitochondrial DNA, which is DNA that is found within the mitochondria of our cells.
Okay. You've sort of given us a very quick synopsis of those, but when people traditionally think of DNA, what type of DNA are we normally talking about in that sense?
You're most likely familiar with the DNA that is inherited from both your mother and your father, the DNA that is found within the nucleus of our cells. And that DNA is, everyone's DNA is different with the exception of identical twins. And because we can find it in our cells, it is a useful tool in trying to determine the source of DNA, especially from biological material.
Okay. When we talk about mitochondrial DNA, is that something that all labs test for as they would traditional DNA?
Mitochondrial DNA testing is a more specialized form of DNA testing. Not all laboratories have that procedure available to use. It is a much more sensitive technique, and so there are very few labs throughout the country that actually perform that type of DNA testing.
Okay. However, were both of those types of DNA testing done on the samples that were submitted and consumed in this case?
Yes, both testing methodologies were attempted.
Now, what is the purpose of trying both mitochondrial and for traditional DNA?
Well, all samples that come through our laboratory, we attempt the traditional DNA testing and mitochondrial DNA testing, especially in this case because the samples were very compromised and were decomposed essentially. Mitochondrial DNA is most often used in cases where samples have been compromised or where there is limited amount of DNA present in the sample.
When you use the word compromised, what do you mean by that?
Where the DNA or the sample has been damaged, and in this case they were described as being charred or burned remains, and we're looking at a limited amount of probably viable DNA in that sample.
Why does the fact that it's charred or that it's been burned affect your ability to gather DNA from the bone?
As the sample is exposed to like thermal conditions or heat, the DNA becomes damaged, it becomes fragmented, and in our testing we're looking at specific size fragments of DNA, so as that DNA becomes chopped up, our testing can't recognize those specific areas on the DNA.
Have you had an occasion in your job to work with charred bones or charred remains previously?
Yes, we have tested charred remains in the past.
And what has been your experience with your ability to obtain DNA, whether it's traditional or mitochondrial DNA, from items that have been burned?
In my experience, it's sometimes really unlikely to obtain a DNA profile, but sometimes we do. It just all depends on how long that sample has been exposed to heat and that type of, and fire or those extreme conditions, including environmental factors as well.
In this particular case, based on having reviewed the testing that was done, did you form your own results as to whether or not there was any reportable DNA found in the samples taken?
I did.
And what was your opinion on that?
Well, due to the low level amount of data that was obtained and just the poor quality of the data, it didn't meet our criteria or thresholds for being able to report any profile. Therefore, the data was deemed inconclusive and no results were reported.
Okay. So to be clear, is there any way for us to know if the bones that we've actually looked at belong to one single person, a specific person?
It is not.
And why is that?
Well, due to the low level that was obtained, and we cannot clearly identify that an actual profile was obtained just from one person or another person. The data was just too damaged and degraded for us to report any viable results.
And in this particular case, what caused the damage that limited your ability to obtain a result, and who these bones would belong to?
Well, because the DNA looked to be very degraded and just low level, and the fact that it was described as being burned or charred, I would think that had a lot of factors that caused the DNA to become damaged.
Thank you. Can I have just a moment?
Mr. Burton, any questions for Ms. Franco?
We have gotten to this witness, Judge.
Ms. Franco, thank you for your testimony, ma'am. You're welcome to stay, go whatever you'd like to do. The only thing I'll ask is don't discuss the testimony you give me this jury this morning with any other witness in the case until the case is concluded, okay?
Yes, sir.
Thank you. Have a good day.
I apologize. She's actually on a flight back to Texas this afternoon. I know you're excusing her, but I just want to make sure that that's okay for us to get her on back to Texas.
Sure.
Yeah.
Have a nice flight.
Thank you.
Try your next witness, please.
State calls Madison Holland.
Everybody all right? Go ahead. Good afternoon, or good morning, excuse me, Mr. Holland. Before you're seated, please give your attention there to Mr. Griffey. We'll swear you in.
Raise your right hand, please. You solemnly swear from the testimony you're about to give before the court in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Have a seat.
Please be seated.
All right. If you'll tell us your name, please, sir.
Madison Holland.
If you'll spell your first and last name for the court report, please.
Madison Holland.
And Mr. Holland, how are you employed?
I'm a real estate broker and own a real estate brokerage.
Now, how long have you been in real estate brokerage?
Well, full time since December of 2020.
Prior to December of 2020, how were you employed at that time?
I was a special agent with the Georgia Bureau of Investigation.
And how long were you a special agent with the Georgia Bureau of Investigation?
About 5.5 years, I believe. I started July 1st of 2016.
And prior to becoming an agent with the Georgia GBI Investigation, how were you employed prior to becoming employed with them?
I was a deputy at the Houston County Sheriff's Office.
And how long were you a deputy with the Houston County Sheriff's Office?
About 5 years.
And did you also were you also a jailer at some time at the Houston County Sheriff's Office?
Yes, I was.
And how long were you a jailer there at the Houston County Sheriff's Office?
For about 2 years. So I was a detention officer for about 2 years, and then I worked on patrol as a patrol deputy for about 3.
Now, I want to direct your attention back to February 21st of 2017. Actually, are you familiar with a person known as Jason Shadell?
Yes, I am.
And who is Jason Shadell?
Jason is a special agent with the Georgia Bureau of Investigation.
And was he also employed in the same GBI regional office as you back in February of 2017?
Yes, sir. We both worked at the Region 13 office, which was in Perry, Houston County.
Now I want to direct your attention to February 21st of 2017. Did you accompany Agent Shadell to a location here in Irwin County, Georgia?
Yes, I did.
And what was the purpose of you accompanying Agent Shadell on that day?
We were going to attempt to make contact with Ryan Duke.
And the person, were you able to make contact with Ryan Duke?
Yes, we were.
And the person you're referring to is Ryan Duke. Is he in the courtroom?
Yes, he is.
And can you identify him by article of clothing, please?
He's sitting at the table wearing a blue shirt and sports coat.
All right. Now we just let the record reflect he's identified the defendant, Ryan Duke. Now, Agent Holland, you were there with Agent Shadell that day, is that right?
Yes, sir.
Now, where did y'all go to make contact with Mr. Duke on that day?
It was his house. I believe it was like Pleasure Lake Lane or something like that.
And how did y'all go and how did y'all make contact with him?
I believe I rode there with Agent Shadell. We knocked on the door and Ryan answered.
All right. Anyone else around?
Nobody was in the house with Ryan, but his mother came and made contact with us. She was at a separated house, but it was on the same property.
At the time that you interacted with this defendant at that occasion, did either you or Agent Shadell do anything to threaten this defendant?
No, not at all.
Now, did y'all make any promises to him at that time?
No, not at all.
And as a result of that interaction, did y'all set up an interview with him the next day at the Osceola Police Department?
Yes, we did.
All right, and I want to direct your attention to the following day, which would be February the 22nd of 2017. Did you accompany Agent Shadell again to Irwin County to the Osceola Police Department?
Yes, sir.
And what was the purpose of you accompanying Agent Shadell that day?
To conduct an interview with Ryan Duke.
And where did you go that day?
We went to a room in the Osceola Police Department.
Now, with regard to, was any other agent besides Agent Shadell there with you?
No, it was just us two and Ryan.
And does the defendant come to the Osceola Police Department?
Yes.
Were you aware of how he arrived there?
I believe his parents dropped him off, or his mother, at least.
All right. And prior to the interview being recorded, were you aware of anything that took place outside in the foyer of the police department?
No.
Okay. Where were you at that time?
Sitting in the room, waiting.
And you say sitting in the room, what room are you referring to?
I don't know if they would call it a conference room. It just was a room with a table and some chairs.
And were you aware when Mr. Duke arrived there at the police department?
Yes, sir.
And how long after he arrived before he came back into the room?
Not long at all. I don't even think it had been a minute.
And prior to the recording coming on in the room, did you promise Mr. Duke, this defendant, anything if he chose to speak with y'all?
No, not at all.
Did Agent Shadell do that in your presence?
No, sir.
Did y'all threaten him or coerce him in any way to get him to speak to you?
No, sir.
Did Mr. Duke appear scared at any point?
No, not at all.
Did he ever express that he was scared to you in any way?
No, sir.
Now, during your time as a law enforcement officer working at the jail, working as a deputy, and as a GBI agent, have you had an opportunity to observe persons that are under the influence of alcohol or drugs or other narcotics?
Yes, many times.
Now, I believe during this time that you, this interview that's on the video, that you had a long time to observe this defendant. Is that right?
Yes, sir.
Did you observe any of the any factors that would indicate to you that he was under the influence of any drugs, alcohol, or other narcotics?
No, sir, none.
Was he responsive to the questions that were asked?
Yes.
Now, with regard to that, I believe that Agent Still asked him about having taken medications. Is that right?
Yes, it is.
And did this defendant indicate something in that regard?
I believe he said he had taken one pain pill.
And I believe that was taken in the morning hours. Is that right?
Yes, before he came to the interview.
All right. With regard to that, did you notice any signs of impairment regarding a pain pill of Mr. Duke at that time?
No, I didn't see any, and he, it was asked, and he said that he was fine and was able to answer questions and understand what was going on.
And from your observations, was he able to hear the questions and understand the questions and respond to those?
Yes.
Now, following the interview with Mr. Duke, did you accompany this defendant, Mr. Duke, as well as Agent Shadell, out to a location in Fitzgerald?
Yes, I did.
And you were able to observe him walking around, is that right?
Yes.
And that took place over some span of time, is that right?
Yes, that's right.
And during that time, did you make any observations of him having any signs of impairment as he was walking out through the location in Fitzgerald?
None at all.
I don't have anything further. Agent Holland.
Any cross, Ms. Murphy? No, thank you for your testimony, Ms. Holland. I'm going to excuse you at this time. The only thing I'll ask is don't tell any other witness in the case what you've testified here to this morning until the case is concluded, okay?
Yes, sir.
Okay. Have a good day, sir.
Thank you.
Excused.
Yes, we've asked that you remain under subpoena, though. We don't anticipate anything right now, but we might have something.
Anybody, everybody got his number or need his number?
I don't get in touch with him, Judge.
All right.
Thank you.
We'll track you down if anything comes up.
Yes, sir.
Thank you, sir. Call your next witness, please.
State calls Jesse Worley.
Good morning, ma'am. You'll step up right there, please. But before you're seated, please give your attention there to Mr. Rigby. He'll administer the oath and direct your testimony.
You raise your right hand. Do you solemnly swear from the testimony you're about to give before the court in this case will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right. Thank you, ma'am. Have a seat. If you'll tell us your name, please, ma'am.
My name is Jessie Worley,
If you'll spell your first and last name for the court reporter, please.
Jesseworley.
And Ms. Worley, how are you employed?
I am a latent print examiner in the impressions evidence section at the Georgia Bureau of Investigation's Division of Forensic Sciences.
How long have you been a latent print examiner for the Division of Forensic Science at the Georgia Bureau of Investigation?
Almost 15 years.
If you will, give the jury the benefit of your training and experience that allow you to do your job as a latent print examiner.
I have a Bachelor's of Science in Forensic and Investigative Sciences from West Virginia University. I graduated there in 2007 and was hired by the GBI, started working in the latent print section or impressions evidence section in November of 2007. I completed the latent print examiner training program at the GBI. It took about 2 years roughly to complete. The GBI also has continuing education requirements, and I'm required to meet those hours every year. But I completed roughly, I think our training program was like 17 different topics of training, broken down by type of task required to do latent print work, and completed all of the tests as required by the agency.
Now, with regard to your time there at the Division of Forensic Science as a latent print examiner, have you had opportunities to examine latent prints?
Yes, I have.
And how many times have you done that?
Daily since probably 2008.
And with regard to examination of prints, have you testified about the results of your late print examinations in courts of law in the state?
I have.
And how many times have you done that?
It's over 60.
And have you also testified in other courts not in this state?
Not outside of the state of Georgia.
All right. And a better question, let me do it this way. Have you also testified in federal courts?
Yes, I have.
All right. And how many times have you done that?
3.
Judge, this time we would tender Ms. Worley as an expert in latent print examination.
Any objection? Okay. All right, thank you, ladies and gentlemen. Ms. Worley has been tendered and accepted by the court and the parties to the case in her field of expertise of latent print examination. Give her testimony the same way, the credibility you believe it's entitled to, and as you discern every other witness. Thank you. Go ahead.
Now, Ms. Worley, I want to direct your attention, file here, sorry. Back to November of 2018, were you employed as a late print examiner back in November of 2018 with GBI?
I was.
And were you asked to examine latent prints involving this case?
Yes, I was.
All right. And let's see. Now, with regard to, I want to direct your attention to your item 50 and those within that to your report. Let me direct you to your report. How about that? Got a lot of information to talk about. So your report of November the 26th of 2018. Actually, let me first do a couple of things I probably should have done first. My fault. If you will, kind of tell us about the science of fingerprints and what is unique about fingerprints.
The theory behind being able to use fingerprints as a means of identification is that the friction ridge skin, or the skin that covers the palms of the hands and the soles of your feet, the formations that are found within that skin are unique to each individual. The fact that they are unique, they can be recorded and used to compare against latent prints or prints lifted or collected from crime scene evidence. And the second part of that is that those features remain unchanged over the course of an individual's lifetime. The formation of the points of comparison or features within a latent print, or the friction ridge skin specifically, are formed before an individual is born, and then they remain the same throughout that person's lifetime, with the exception of growing larger, barring any kind of injury or certain disease that can affect the way the skin replicates and reproduces over your lifetime. In recording those impressions, or that the formation of your skin onto cards, they can be used for comparison and identification.
And that would be the importance of using them in forensics, is that right?
Yes.
Now, were you asked to do latent print examination in this case regarding fingerprints recovered from the vehicle, that being your items, item 50, and then those that flow from 50, A through O?
Yes, I was.
All right. Now, with regard to those fingerprints taken from the vehicle, were you able to? All right. Let me talk about. I guess first, when you first look at a fingerprint, what are you looking for, and what are you trying to find in the first part of the process?
So the first part of the process that we use at the GBI Crime Lab is referred to as an analysis. During this part of the examination process, the examiner examines and observes the impression, or each individual fingerprint or palm print, and determines the amount of detail and the clarity of the detail present in each of those prints. At the end of the analysis, and the examiner has to make a decision whether the print is suitable or unsuitable to be used for a comparison. So during this analysis phase, I try to determine whether I can tell anatomically where the print is from, whether it's from the fingers or from the palm, if I can tell which direction is up or down if I were trying to compare it to a set of knowns, in order to have them in the same orientation to facilitate a comparison. And then if the detail that's present is clear and can readily be observed again in the latent print as well as a known print if I were to attempt to compare it.
And is that the steps that you took in comparing these print lifts from the vehicle, which is your item 50?
Yes, I did complete an analysis for those
those lift cards or those items. And then at the end of the analysis, I did the comparisons for the impressions or latent prints that I determined to be suitable for a comparison.
Now, with regard to the vehicle, I believe you had 15 prints to analyze. Is that right? In that item 50?
There were 15 lift cards, yes.
Now, with regard to that, of those 15 lift cards that you analyzed, were you able to find any prints suitable for comparison?
From item 50, yes, I was.
Okay. Can you tell me how many were suitable for comparison of those 15?
From item 50, there were 3 latent lift cards that I determined that contained latent prints that were suitable for comparison. It may have been more than 3. But from item 50, there were 3 suitable latent prints.
Now, with regard to those 3 that were suitable for comparison, were you asked to compare those that were suitable for comparison to exemplars for certain individuals?
Yes, I was.
Now, when we say an exemplar, what do I mean by the word exemplar? What is that?
Exemplars are recordings of the friction ridge skin of a specific individual for the intention of using that recording for a comparison to latent prints. They can be just the fingers, they can be fingers and palms, they can consist of what we refer to as major case prints, which would be an attempt to record every single piece of friction ridge skin, including the lower joints, all the way down to the bottom of the palm and possibly the wrist area as well.
Now, whose exemplars did you use to compare to the 3 prints suitable for comparison from the vehicle?
The exemplars that I had for the report that I issued in November of 2018 were described as finger and palm print cards bearing the name Bo Dukes and finger and palm print cards bearing the name Ryan Alexander Duke.
All right. Now, when you compared the exemplars for Mr. Bo Dukes and Mr. Ryan Duke to the 3 prints suitable for comparison from the vehicle, were you able to come to a conclusion or results from your latent print examination?
Yes, I was.
And what were your results?
For the latent print from item 50I, I was able to exclude both individuals. And for the latent prints from 50J and 50O, my results were inconclusive.
All right, so let's talk about those things first. You talked about that from 1, you excluded both individuals.
Yes.
What does an exclusion mean?
An exclusion is the determination that the exemplar records and the latent prints were made by different individuals, that they could not have come from the same source.
And so from that determination, you excluded both Bo Duke and Ryan Duke and Bo Dukes from that particular print. Is that right?
Yes, the one from 50I.
All right. Now, I believe you said you analyzed or you compared the exemplars of Ryan Duke and Bo Dukes to another one, and you came to an inconclusive result. Is that right?
Yes, for 50J and 50O.
Now, if you explain to the jury what you mean by an inconclusive result.
So an inconclusive can be there can be a number of different reasons why an inconclusive conclusion is reached. As I've explained, an exclusion means that the latent print and the known prints are from 2 different people. They're not from the same source. The other end of the spectrum would be an identification, where the determination is made that the latent print and the known prints were made by the same source or the same individual. Inconclusive is basically anything in between. It's not enough to exclude, it's not enough to identify, or it could be that the records that were submitted weren't clear enough or complete enough. In this instance, my notes indicate that the inconclusive was just that there wasn't sufficient detail to be able to exclude. So I was getting towards being able to make an exclusion, but there wasn't enough detail present in those latent prints to say for sure that it is a true exclusion. So the conclusion I have to give in my report is an inconclusive.
Now, with regard to that, it may be that when the print was left in the vehicle, it just didn't give you enough information to make a conclusion. Is that right?
We have pretty strict criteria in our policy at GBI for what has to be present in a latent print in order to make a exclusion decision. We have over the years changed our procedures in terms of continued improvement in quality to our customers, being the state of Georgia. And one of the things that we require in making an exclusion decision is that we have to be confident in the anatomical source and orientation of the impression, and that it also has to contain what we refer to as a focal point or an anchor point within the impression, so that we know where we are looking for that detail when we compare it to the known prints. So what ended up being the case with the latent prints from item 50J and 50O was that those latent prints did not contain a focal point. So while I didn't observe any detail that were similar between the known prints and the latent prints, I didn't have that focal point or anchor point present, so I'm not able to make an exclusion decision.
All right. Let's move to your analysis regarding your item 55 being the 7 latent lift cards from the interior front door. And let's discuss that. Were you also asked to examine and make latent print examinations for item 55 being the 7 prints from the front door?
Yes, I was.
And were you able to find prints that were suitable for comparison?
Yes, I did.
All right. And how many of those were suitable for comparison?
There were 8 from 55 that were suitable.
Now, were you asked to compare those 8 prints that were suitable for comparison against known exemplars for certain individuals?
Yes, I was.
And what individuals, exemplars, did you compare those from the interior of the door to? Who were those?
They were the finger and palm print cards bearing the name Bo Dukes and the finger and palm print cards bearing the name Ryan Alexander Duke.
Now, with regard to those known or those prints suitable for comparison from item 55 being the front door, were you able to make any determinations or conclusions regarding those prints and Ryan Duke or Bo Dukes?
Yes, I was.
And what were those?
7 of the latent prints from items 55A, 55B, 55C, 55D, 55E, and 55G, I was able to exclude both individuals as the source of those latent prints. There was 1 latent print from item 55F where my comparisons were again inconclusive because the latent print did not contain a focal point that I could use to make an exclusion.
Then I want to direct your attention to your item 49 being lift cards from the screening door.
Yes.
And were you asked to analyze those prints to find suitable for comparison?
I was, yes.
And were you able to find prints suitable for comparison from this door?
No.
Right. So there were none even to compare to anyone else?
No, there weren't.
Okay. And what would be the reason for that, not even making them suitable for comparison?
My notes indicate that I performed a visual examination of those lift cards from item 49 and that the results were negative. So what this means is that there wasn't even any ridge detail present on those lift cards, or it was so limited as to be insufficient to even analyze it.
Okay, so because it wasn't suitable for comparison, you didn't try to even compare it to anybody else's known prints. Is that right?
That's correct.
All right, I want to direct your attention to your item 1, which is the latex glove.
Yes.
And were you also asked to perform a fingerprint analysis on the latent glove?
I was asked to look at the photographs that were taken from 2005 for the latent print development that was done for that glove, and that the photos had already been documented in our case file at GBI.
Now you mentioned, I apologize for interrupting you. You mentioned that photographs were taken of the glove in 2005. Are you familiar with Timothy Small?
Yes.
And who was Timothy Small?
He was another examiner that worked at the GBI. He was working there when I started in 2007, but left before I was assigned to work this case in 2018.
Now, were you working with the photography that was used, that was taken back in 2005 for your analysis in 2018?
Yes, I was.
Now, did you make attempts to go back and look at the glove to take your own photographs?
I did.
Tell me about trying to do that.
I did take possession or custody of item 1, which was the latex glove from this case. It had been stored at the GBI during this time, since it had been worked by Examiner Small. However, due to the application of various chemical reagents and the fact that latex and that type of glove, it did tend to dry out over the years being in storage. When I removed it from the packaging, it was starting to break down and more or less disintegrate, and was starting to become very small pieces. So I was unable to be confident in being able to handle it in order to try and photograph it without doing any additional damage to the item itself. At that point, I made the decision that photography wasn't going to be an option for me to do over in this case, and that I would need to rely on the images from 2005.
And so when you we're going to make do your analysis, you're going to use the 05 prints, although you preferred to get your own photographs, you use the 05 photographs,
yes.
Is that right?
I would have liked to do my own photography in a case like this, and the other benefit of this would have been in being able to see the latent prints as they were situated on the item. I think would have added some context to what I was looking at doing my analysis of the latent prints that were developed on the glove. But that option didn't really exist for me in 2018. So I was limited to what was available in the photos from 2005.
Now, with regard to those photographs of the glove and the fingerprints on the glove, were you able to make the first step in your analysis? If you'll tell us about that, please.
So I went through the images. There were several images available of the glove, different parts of it as it had been cut into pieces, from what I could tell in the images in the case file. And what I was able to find is there were 3 photographs that contained different portions of ridge detail. I could tell by examining them that it wasn't 3 photographs of the same area. They were 3 different pieces from presumably the palm of the hand. In analyzing those images, I was able to determine that there was sufficient detail in each of those 3 images to say that there were 3 latent prints that were suitable for comparison. And because the images of these latent prints exist separately, there was no one image where I could see all of them together. I had to treat each of them like an individual or unique separate entity. So in my notes, they're referred to as 3 separate latent prints.
Now, with regard to, we talked about earlier about fingerprints being individualized to each person. Are palm prints treated the same way?
Yes.
And so they would also be individualized to one person?
They could be.
Now, with regard to these 3 prints you found on the glove that were suitable for comparison, could you tell the orientation of those prints?
Not at the time that I was doing the analysis. There was sufficient information in the direction of the ridge flow and kind of the shape of the impressions as a whole to be confident that they weren't from the fingerprint area of an individual and were more likely from the palm, just given the shape that the ridges took and the shape of the impressions themselves. But as far as their specific orientation, I was unsure at that time.
When we say orientation, is that whether it was up or down or something like that? Is that what we're referring to?
Yes. So for doing comparison, the methodology that is used for latent prints is to put your latent print and your known print side by side. So if you can get them arranged in the same direction so that 12 o'clock is 12 o'clock instead of trying to compare 12 o'clock to 6 o'clock, you're more likely to be able to move back and forth between them and make a conclusion at the end of the comparison in a much more reliable manner. For latent prints, when the orientation is undetermined, As an examiner doing a comparison, you're responsible for turning it 360 degrees around and comparing it in all of these different places in order to be sure you've compared all of the relevant detail before you can render your conclusion. So in doing an analysis and being able to determine the orientation is important and helpful when you have to then compare it to a set of knowns.
And with regard to this, the latex glove, you found 3 prints suitable for comparison. Is that right?
Yes.
And were you asked to compare those prints to known exemplars of certain individuals?
Yes, I was.
And to which individuals were you asked to compare those 3 prints?
I compared them to the exemplars bearing the names Bo Dukes and Ryan Alexander Duke.
And were you able to come to a conclusion as to the results of your examination of regarding each of those 3 prints that you found on the glove?
Yes, I was.
All right, and if you'll tell us, let's start, I guess, with the impression 1 or the first impression.
Impression 1, I was able to make an identification decision, but I do want to say that for the 3 impressions from the glove, because I was unsure of their orientation and the limited amount of detail present, I was able to use a computer program that we call AFIX Tracker System, and it is a computer-assisted comparison process. So basically what I did in order to use this computer program is upload all of the images of the 3 latent prints and then also upload the images of all the palm prints and fingerprint cards from the 2 individuals. The computer AFIX tracker basically works like a small database. So instead of having a database of millions of prints, I have a database of 2. What I'm essentially asking is for the computer to find areas of detail that have similar arrangement of features between my 3 latent prints and these 2 individuals. As a result of putting all of these prints into tracker for the 3 latent prints from the glove and the 2 sets of exemplars, I was able to identify what I have in my notes as impression number 1 and then also impression number 3 to the right palm print cards bearing the name Ryan Alexander Duke.
So with regard to 2 of the 3 prints from the glove, you identified them to Ryan Alexander Duke.
Yes.
Now, we talked about there was a 3rd print on the glove, and tell me about that, please.
So the 3rd print, while I did put it into AFIX tracker and do the same comparison process as I did for impressions 1 and 3, the result for that impression is reported as no identification was made because none of the area of detail that was returned on by the computer system matched up or lined up or enabled me to compare and make an identification to either of the 2 sets of exemplars that were supplied.
And so with regard to that impression number 2, you weren't able to say that it belonged to Ryan Duke or to Bo Duke, is that right?
That's correct.
Now, with regard to the impression 1 and 3 that you identified as Ryan Duke, you also compared those to Bo Duke, is that right? Or did you do Ryan Duke and then when identification is made, how does that work?
So the search on the computer system compares the latent against both sets of knowns that I've given it simultaneously, and you get a list of potential areas that are potentially a match. So then the examiner, in this case myself, goes through the list of possible areas that it may be a match to. And in this instance, for this case, I believe, for impression 1 and for impression 3, Ryan Alexander Duke, the full right palm, was the first candidate on the list. So that was the only comparison I did for both of those impressions.
Now, once you get that from the AFIX system, do you do your own comparison as well?
When the system brings up a potential match, it will show what the computer has coded as the features that may be in agreement between the latent and the known. So it's my responsibility as the examiner to look at what the computer has matched as potentially being an identification or potentially being in correspondence, and to ensure that my conclusion is based on good matching data. I'm looking to make sure that if the computer is marking feature A here, feature A over here is in fact the same feature, and that all of the rest fall in sequence and are in agreement between the latent and the known. So at that point on the computer system, if I agree with what has been marked out by the computer, and there's not any other outstanding information that would be contrary to that, then I don't necessarily have to do an additional comparison because I have compared it at that point.
I see. Now, with regard to the lab, is there also something called a peer review process?
Yes.
And tell me what the peer review process means.
So peer review is a requirement lab-wide for all of our disciplines at the GBI Crime Lab. Different units or different disciplines have different requirements for how many cases go through peer review, or the type of peer review that's done. For latent prints, 100% of our cases go through peer review. So that means once I'm done with compiling all of my notes and I enter all of my findings and I write my report, everything gets reviewed by another examiner before the report is released to the customer.
And was that done in this case?
Yes, it was.
With regard to that, is that done a blind review, or how is that process done?
So peer review is not a blind process. They have access, the peer reviewer has access to all of your notes, and it's actually a requirement for them to review all of the documentation you've put into your case file to make sure that your report is accurate and reflects all of the testing that was completed.
All right. Is there something else with called a blind verification?
Yes.
And tell me what a blind verification is, please.
So verification is actually part of our latent print examination process. You heard me say that we do an analysis, we do a comparison. At the end of the comparison, we render a conclusion, and then all of those, or some portions of those conclusions, are verified by a second examiner. We also have two different types of verification that we do. We do a blind verification, which means that an examiner is asked to perform a verification and they're told to complete a task within the examination procedure, but they don't know whose case it was or what the first examiner's conclusions were. And then we also have a standard verification, which is where the verifying examiner knows whose case the latent prints and the known prints are from, and they are aware of the comparison or the results. In this case specifically, there were portions that were done as a blind, and then there were also portions that were done standard.
Okay. And with regard to this case, was the blind verification process done regarding the identification prints of Mr. Duke?
Yes.
And did they come to the same conclusions that you did?
Ultimately, yes.
All right. You say ultimately. Was there an initial part of disagreement?
Yes.
And tell me what about that.
So,
was that as to both identifications you made, or just to one?
Just to one. It was for what's been designated in my case notes as impression 1.
All right. But impression 3, under that blind verification, she agreed with your identification of Mr. Duke. Is that right?
Yes.
All right. And then what about impression 1?
So impression 1, the reason it went for a blind verification was because at the analysis, like I said, I was unsure of the orientation and the amount of detail was a little on the limited side. What that meant was that in saying that it was suitable for comparison, I also had to designate that it was considered to be complex. The policy for identifications, if your analysis result was suitable but complex, that has to go for a blind verification. So even after using AFIX tracker and comparing the results from the tracker search and making an identification, that would have had to have been verified in any case, because we do verify all of our examination decisions, but it was required to be blind because of the level of complexity that I assigned to that comparison. The examiner who completed the verification did not initially have a match on AFIX tracker when she performed the search herself. We were informed by our manager, who acts as more or less the mediator in blind verifications, that our results were not consistent with one another and that we needed to do a consultation and figure out why we were getting different conclusions.
And did y'all do a consultation?
We did.
And following the consultation, was it, I guess, was that person for the blind or now the standard verification? Would they go back and analyze it again?
So the results of our consultation, what we found was that when she uploaded the exemplars and the latent prints into the computer system, she had some of the features marked out slightly differently than how when I uploaded them and marked them up. So there was a little bit of variability between what the computer was searching for between her searches and the ones I completed. Once we realized that that was the difference and where the issue was occurring with the feature placement and the features that were marked in the computer system, we were able to agree that it was in fact an identification and that the limitation became just how they were marked in the computer.
And so ultimately, she agreed with you that impression 1 and impression 3 belong to Ryan Duke.
Yes.
I don't have anything further.
Let's take a break.
Yeah, I was gonna ask you the same.
Ladies and gentlemen, we'll take our first recess of the day. Please leave your pads there in the chairs. Those of you that want to step outside for some fresh air, y'all know where to line up. Otherwise, please adjourn to the jury room. We'll take about a 10-minute recess. Let's everybody remain in place while several of these jurors exit the courtroom. All right, we'll be in recess about 10 minutes. Thank you. We need to wait for Mr. Merchant. Still there? Sorry, you were out of position. Yes, he is. Both sides ready? Ask the jury to join us, please. Ladies and gentlemen, I failed to ask y'all this morning. Anybody try to contact you over the weekend or talk to you about this case or anything? All right, great. Thank you. All right, Mr. Merchant, you can proceed with your cross.
All right, thank you, Judge. Ms. Worley, have you been taught that even careful and honest fingerprint examiners can subconsciously observe what they expect to see?
I'm not sure I understand what you're asking me.
Confirmation bias?
Yes, we cover it in our training program.
Okay, and you learn that confirmation bias can occur even with honest and truthful and careful examiners.
It is possible. There are studies that have been published that show the results of or the effects of bias, and so the goal in including it in our training program is that we hopefully minimize it by acknowledging that it is a condition that can exist.
If you'll speak, please speak up, Mr. Merchant.
Oh.
Thank you.
I'm trying not to scream at you, so I'll do my best here.
Just scream at her.
Maybe if I turn this way a little bit. Okay. So I guess when we spoke on March 13th, 2019, you told me that Mr. Duke may have been listed as a subject on the evidence submission form. That's correct?
I may have told you that, and that may have been the case, but I can also refer to the submission form that I received.
In any event, you had print cards, known print cards, exemplar cards with Ryan Duke's name on it, right?
Yes, I was able to obtain them.
And you knew that he was a, quote, person of interest, is what you told me on March 13th. Is that correct?
Yes, so when I began my examination for this case, because the evidence, the latent print evidence already existed in the laboratory, the request for us to do an additional fingerprint examination in 2018 came through an email that was received by my manager and then forwarded to me that outlined the service request that was being asked for by, I believe it was one of the GBI agents, and it did list both Ryan Alexander Duke and Bo Duke as the individuals that they were asking to be compared to the latent print evidence.
And you knew that before you began your work?
Yes.
And your work, let me just eliminate some things here quickly. You didn't find any identification with any prints for Ryan Duke on the car?
No, I did not.
Okay. You didn't find any prints that matched Ryan Duke from the house?
No, I did not.
Okay. The only prints that you found that matched, in your opinion, Ryan Duke was on the glove?
That's correct.
Any other fingerprints anywhere else on that property that you worked on matched Ryan Duke?
The latents that I was asked to compare were limited to the glove, the house, and the vehicle. So that was the extent of the comparisons that I did.
And with regard to the glove and these three that we've been talking about, one of them was inconclusive, correct?
Yes, one is still inconclusive.
So that did not match Ryan?
I observed similarity, but not enough to make an identification decision.
That did not match Ryan? In your term, identify with Ryan?
I did not make an identification.
And the third one that you agreed on, we'll talk about that in a second, but the one that you had the disagreement with Ms. Harbin, that's the one that went through the blind verification process?
Both of the ones that were identified went through blind.
Okay. And she initially disagreed with you on item 1?
Impression 1 from item 1,
okay.
Yes.
Is that the same impression that Timothy Schmall identified as being suitable?
It may have been. There is a lack of clear documentation between what was done in 2005 and what I was asked to do in 2018. So I did make a note in my notes that it is possible that that was the same impression, but I have no way of knowing for sure.
So the 3 that you looked at, you have no way of knowing whether or not any of those is the same one that Mr. Schmall identified as suitable?
Going off of what was contained in the case notes that he produced at the time of his examination and comparing those notations to what I was observing when I did my examination, that's the best kind of educated assumption I can make based on the notes he kept and what I was observing in the available evidence, but I can't say for sure. We had greater limitations in 2005 with how imaging and documentation were performed that are significantly different from what we would do today and even in 2018. So I'm having to there are some gaps in what I would expect to see in notes taken and generated in today's casework versus what we were capable as a laboratory of doing in 2005.
So as you sit here, you cannot tell the jury which of the ones you identified is the same as the one Mr. Schmall identified.
His notes did not indicate an identification.
So you can't even orient the jury on the glove to the one that Mr. Schmall found.
Other than the fact that there are images that were generated by the photographer in the lab who would have taken photographs of something that the latent print examiner at the time said, please photograph this. No, I don't know for sure what specifically he examined when he made his determinations. I have assumptions based on what's available.
And the one that you and Ms. Harbin disagreed on, the way that works is essentially she does it and gives her own educated opinion based on her training experience about whether there's an identification. And if she disagrees with you, you all powwow, get together, and then decide if you can reach an agreement? Is that how it works?
Yes, that's our procedure.
Okay. And when you use that process in this case for item 1, impression 3, she changed what she had done in terms of her work on the case in order to reach the same conclusion as you. Is that correct?
No. Item 1, impression 3, we agreed initially across the board on all conclusions. It was impression 1.
My apologies. Yes, impression 1. But that's how the process worked for impression 1.
Yes.
Okay. So let's turn to so you got one where you disagreed, but then ultimately she changed her conclusion. You got one that's inconclusive, right? Out of the 3.
Yes.
Okay. So let's talk about the one that you both agreed on, both in terms of suitability and the ridge detail. That's item 1, impression 3.
Yes.
So I think you've testified on direct that all 3 of these prints that you identified were, quote, complex. Is that correct?
I only identified 2 of the 3, but my analysis determination was that, yes, all 3 were suitable for comparison, but all 3 were also complex.
For the jury's understanding, complex means there's a lot of distortion and inability to see clearly, correct?
Not necessarily. It can be clear as day and crystal clear and pristine and just be limited in quantity, or it could have a huge volume of quantity but be distorted or unclear or smudged or somehow obscured. The decision on whether something is suitable is kind of a sliding scale between quantity and quality of detail. There's not any set point like you need this much or you need this clear. But it's the examiner's responsibility and based on our training and our experience to make a decision on suitability taking all of that information into account. But then it's also verified, that decision is also verified by a second examiner. So while I did determine that they were suitable and that they were complex, my verifier also reached the same conclusion that they were suitable and complex.
Right, ma'am. But my question was, in terms of complexity, distortion is a function of that in this case.
It can be. I don't remember for certain if my notes don't indicate that there is distortion present in normal circumstances. If I make a note that I see distortion in a latent print, it usually is a factor of some sort of movement or pressure or other issues that occurred when the print was deposited on the surface, like the hand slid across the window or there's a twist to it. All of these things are evident in a latent print when they exist. This case, The complexity comes more to the imaging quality from 2005, just the fact that they are limited in total volume of detail, and that I can't have ever seen the latent print as it existed on the item of evidence itself.
Right, you told me that the images were not crisp and not clear. Is that correct?
That's a product of the imaging, not necessarily of the impressions themselves. So there is a limitation in what I can accomplish, not having seen the impression in its original state on the item and not having been present when the photography was being done. So there are limitations, and so all of that does play into the complexity decision that I have, because the images are not ideal to what I would have wanted to capture if I could do the photography myself.
But based on the quality of the photographs that you had to work with, you had to give yourself additional tolerance in order to be able to evaluate the ridge detail, correct?
Yes, to some degree.
And tolerance just means flexibility in terms of identifying characteristics?
Tolerance in latent print examinations is how, like if we're talking about a specific feature in the latent print. So one of the things we look for is a feature for comparison are ending ridges, which means there's one ridge that just stops abruptly while the other two on the other side of it keep going. So an ending ridge could just end smoothly and have a very nice curved, like even end. Some of them look almost a little pointy, or some of them have a hook at the end. It's just different morphology of the skin itself. So tolerance in a latent print examination would be how, because of clarity, how exactly replicated can I expect to see that feature when I'm doing my comparison. If I have an image that's not quite crisp and clear, then I have to give myself more tolerance, because it may look different than what I am observing because of the image quality. If it's a situation where there's distortion and there's movement, that movement can affect the way the skin made contact with the surface, and may, instead of it having a hook, it may actually appear in like a straight ridge. So tolerance plays into how exactly the same a feature may look when repeated in other impressions. In prints that are more unclear or more complex, as an examiner, you have more tolerance than in impressions that are clear and clean and very, very well recorded. When you have that kind of a recording, you don't have room for tolerance because it should look the same. So in this case, yes, I did have to have some room for tolerance because of the type of evidence, how it was developed, how it was imaged, and the fact that I'm doing this comparison almost 15 years later.
Yes, ma'am. That was my question. You gave yourself additional tolerance because of the complexity.
Yes.
Okay. So, all this work that you did in terms of identifying areas that you thought were similar between the latent print and the exemplar print, did you document any of that?
Yes, I did. It's part of my case notes.
So you identified each of the features you found similar from the latent and the exemplar, your handwritten notes?
No, they would have been part of my printouts from the computer system that I used to do the comparison.
Right, to do the initial comparison, to find a place for you to look, right?
That is the comparison. The computer brings back a potential area and shows you the features that have been marked similar enough to register as a potential match. At that point, then I mark out additional features or adjust as needed in order to make the identification, and then I print that into my case notes.
Well, aside from printing the AFIS stuff, did you make any handwritten notes about what you thought looked similar?
Not in terms of specific features, no.
So we can't go back and look to see what you were looking at and specifically how you found them similar. Now, we can't do that, right?
I mean, my analysis notes contain the features that I marked in order to determine the suitability, and those would have been the features that I marked in the computer system. But beyond that, no, I don't have any additional notations.
And are you sometimes asked to bring those to court and publish them, show them to the jury?
Sometimes.
So you've been in that seat before in a different courthouse, perhaps, where someone said to you, "Hey, I want to show these pictures to the jury."
Yes.
Okay. Did you bring any of those here today to publish to the jury?
Not in a condition that's going to show very much.
All right, so you weren't asked to bring those photographs that you were looking at to show the jury today? Is there any minimum number of points that have to be similar under the GBI policy in order for you to make an identification?
No, there's not.
That's completely up to your subjective determination based on your training and experience.
It is, but it's also based on the observed agreement or correspondence between two impressions, whether or not that is enough or sufficient to make an identification decision. And then it's also verified by a second examiner.
Right, but again, that verifier is also using their subjective interpretation of what they see as similar, correct?
Yes?
And so I'm clear, none of these prints that you were viewing, none of those were of enough quality to be able to be uploaded into the APHIS database, which is the National Fingerprint Database. Is that correct?
I was not asked to do an APHIS search, so that was not something that I was needing to address, I was only requested to compare to these two individuals. But then again, APHIS is a term for fingerprint databases in general. Whether it's federal, state, or local depends on which type of APHIS you're accessing. GBI has access to a state APHIS database and then to the federal next generation identification, which is maintained by the FBI.
My question specifically, ma'am, was these prints were not of sufficient quality to upload into the National Fingerprint Database, correct?
That determination was not made by myself at any point in time during this case.
I understand that, but when you and I spoke on March 13th, I specifically asked you, are these APHIS quality prints, and you told me no. Is that true or not true?
That's probably what I told you in our conversation, hypothetically, but it's not a determination that was made during this case as part of these notes.
I understand that, but when you and I talked, you made it clear that these were not APHIS quality, correct?
I may have, I don't remember.
And you couldn't orient either of these two prints up or down, right?
That's true.
And you couldn't tell me where they were located geographically on the palm.
Anatomically speaking, no. That was a determination I couldn't make, and that's the majority of the reason my decision for suitability was complex.
And you didn't find any suitable prints in any of the fingers.
The only images that I had available appeared to be from the palm.
And is this, in all the time that you've done your work, is this one of the more difficult comparisons that you've made personally?
This case is difficult as a whole because I'm working after the fact and off of other people's information as well and other people's work product. The comparisons were difficult, especially in knowing that the anatomical position and orientation of the prints, the latent prints from the glove that I was comparing, were not readily obvious. There are some comparisons you do as an examiner and you look at it and you're automatically like, that's a thumb, and you know which direction it goes because you can see the characteristic ridge flow that comes from a thumb impression. This case, these impressions from this glove, they didn't have that. And then the images are less than ideal due to quality and all other reasons. And then not having ever had the opportunity to see the impressions on the evidence, it is a challenge. Is it one of the most challenging things? Maybe, maybe not. It's a comparison. I feel confident in the results that I gave. I feel confident in the results of the verifier and confident enough to have published it in my report.
Ma'am, look at the jury and tell, are you looking at the jury right now and telling them that this is not one of the most complex cases that you've done as an examiner of initially invisible fingerprints?
I don't know how to qualify that. Like, it was a challenge. But as far as it being like necessarily the most challenging, I don't know. But it was difficult, and it was something that I did spend a lot of time working on in order to overcome the limitations that this case inherently had for me to work.
One of the more challenging cases. That's what I asked you. Is that true?
Yes.
All right. That's all I have. Thank you.
Read your record.
Yes, Your Honor. Now, Ms. Worley, with regard to your notes and your analysis for those they asked you about any presentation, you provided all of your notes to the defense counsel in this case, isn't that right?
Yes.
And in fact, in that phone call with defense counsel, y'all went through your notes and your images.
Yes.
And with regard to that, those were all provided to them. Are defense experts allowed to have their own expert look at your data and your analysis?
As far as I know, yes.
Now, I want to talk about, do you know if that was ever done?
I don't know.
But you provided them the information that you looked at and the notes from your case. Is that right?
Yes.
Now, I want to talk about, for a few minutes, with regard to the 3 impressions from the glove that you found that were suitable for comparison. We've talked about the fact that number 3, impression 3, you and Ms. Harbin agreed was identification from the start. Is that correct?
Yes.
Now, impression number 1, you said it was identifiable to this defendant, and Ms. Harbin did not. Y'all got together, and then y'all agreed that it was identifiable to this defendant. Is that right?
Yes.
Now let's talk about impression number 2 just for a few minutes. With regard to impression 2, you said earlier that there were some areas of that were comparable to this defendant's print. Is that right?
Yes.
And in fact, you asked for additional exemplars of this defendant. Is that right?
Yes.
And when you say you wanted additional exemplars, why would you need additional exemplars of this defendant? What would be the purpose of that?
In this case specifically, I felt that the area that was needed for comparison to this specific impression was not clearly or fully represented on the exemplars that were submitted initially. So what I asked was for a set of exemplars that included an area of the palm to be more completely recorded.
When you say it near the palm, in fact, when putting the ink and rolling on the particular card, it just needed more detail or more area? How would you describe that?
So your hand is obviously not flat. It's contoured, it's rounded. You don't have sharp edges as a person. So it's possible when recording palm prints, if you put the hand down, you're going to miss maybe like the areas around, excuse me, the areas around the edges, or as it kind of indents at the base of the fingers and starts to curve away from the flat part of it or flat surface. So one of the things that is asked for is that in order to get a more complete recording, maybe the hand needs to be rolled across the surface or a little more out towards one side or a little more pressure applied in a certain area in order to get more of that friction-rich skin to make contact in the recording process.
And so and you wanted an additional exemplar of this defendant, Mr. Duke, to look at a second time. Is that right?
Yes.
And did you receive that?
I did.
And were you able to make any comparison or identification at that time?
I did an additional comparison, but the conclusion that I rendered after the second comparison was still inconclusive. I still observed similarity, but it wasn't enough in this one area to stand alone as an identification on its own.
All right. But again, with regard to impression 1 and impression 3, who were they identified to?
I identified them to the finger and palm print cards bearing the name Ryan Alexander Duke.
I have no further.
Any follow-up, Mr. Merchant?
Just briefly, Judge. I forgot to ask you this when I was up here earlier. You've taken a class entitled What Makes a Credible Witness, correct, at the GBI?
It was offered as an online course that I took, yes.
And the purpose of that class was to teach you how to testify to the jury?
It was a continuing education class on witness testimony in general.
And it was strategies to make you look, strategies for making you look more believable to the jury?
I don't feel like that was specifically the goal of the class. It was about demeanor and how to act when you are in the courtroom.
For times like this when you're sitting in the witness chair?
Yes.
So I have, Judge. Thank you.
All right, anything further? No, sir. All right, any reason Ms. Worley shouldn't be excused going about her business? Ms. Worley, thank you for your testimony. You're going to be excused at this time. Stay, go, whatever you want to do. Only thing I'll ask you is please don't discuss the testimony you've given to this jury this morning with any other witness in the case until the case is concluded, okay? All right, thank you so much. You'll be excused. Call your next witness, please.
State the rest, Your Honor.
Okay. All right, thank you, Mr. Rigby. Ladies and gentlemen, the state, as you heard, has rested their case, which means they've presented all the evidence they desire for you to hear in what we know is their case in chief. As you might imagine, in every case, this point in the trial requires me to take up a few minutes with the attorneys outside your presence, thinking this could happen sometime earlier than lunch. We've got lunch showing up early today, so we'll go ahead and take the lunch break. We'll start back. We've been going about an hour and 15 minutes for a lunch break. We still anticipate doing that, which means we'll shoot to start back about 1:45 instead of 1:15 like we've been doing. We're stopping about 30 minutes early today. But anyway, same drill. Leave your notepads there in the chairs. Nobody will bother them. I'll excuse y'all to go with the bailiffs downstairs. Enjoy your lunch. Thank you. All right, are you ready to proceed, Ms. Burchett, with your motions? Or, okay. All right, state ready? All right, I'll hear from you then.
Thank you, Judge. Got it. Thank you.
Sure.
Oh, I can move it. Sorry. I just needed somewhere to put all my stuff. Is that better? That was a little too low. Thank you so much, Judge.
Sure.
Judge, I did prepare a written motion for directed verdict that I'm going to file, but I want to argue it orally as well.
Please.
I've got it here orally. Judge, we are moving for a directed verdict pursuant to OCGA 17-9-1B. Specifically, that law says a defendant shall be entitled to move for a directed verdict at the close of the evidence offered by the prosecuting attorney, even if he fails to introduce any evidence at the trial. So at this point, it's ripe for consideration. And this court has a duty to grant the directed verdict where there's no conflict in the evidence and the evidence compels acquittal as a matter of law. Specifically in this case, my client is charged with, and I've got a copy of the indictment here, if Your Honor needs to see it. First count is malice murder. Second count is felony murder during the commission of an aggravated assault. The third count is burglary. Felony murder. The murder happening during the commission of burglary. Yes, Judge. So I want to focus on those counts initially. Judge, as our strongest argument, the law requires in this case that there be corroboration of any statement by the defendant. This is different than the corroboration requirement for statutory rape, for terroristic threats. This is a much stronger corroboration requirement. In this case, confessions of guilt shall be received with great caution. That's what our Supreme Court has said. A confession alone is insufficient to support a verdict, and to authorize a conviction based upon a confession, there's got to be corroboration. So the important aspect of corroboration is corpus delicti. There has to be proof of corpus delicti. What is that here? That's proof that the crime actually occurred. There's got to be proof of each element of corpus delicti. Again, our Supreme Court has said that corpus delicti means body of the crime, and it's made up of two elements. The first element is that a certain result has been produced, that someone has died. That's what's required, the first element here. And this is all from the McVeigh case, which is 205 Georgia 326 1949, and I've got copies for both Your Honor and the state. But in that case, Judge, the first element is that the person actually died. The second element that has to be proven for corpus delicti is that someone is criminally responsible for that death. So they have to prove that the death actually happened by homicide. So there's accidental, natural causes, homicide. There's got to be corroboration other than the statement of the defendant to prove cause of death. Proof that this crime actually occurred is required, and the proof must be independent of the confession beyond a reasonable doubt.
That's from McVeigh, you said.
That's from McVeigh. That's also from several other cases that are cited in the written motion, Judge. There's quite a few cases on point to this specifically. There's also, in the absence of extraneous evidence, this is from McVeigh, in the absence of extraneous evidence of all elements of the corpus delicti, the proof is insufficient to corroborate the confession. So all the elements. Again, the last element is that the accused caused the death in the manner charged. That's from Blackwell v. State, which is 270 Georgia 509, 1999. That also includes, so it sort of breaks it out into almost three elements. Blackwell says that the corpus delicti is established by proof that the victim is dead. First element. Second element is that it was caused by violence or direct criminal agency. And the third element is that the accused caused the death in the manner charged. Applying these dictates to the evidence in this case, there is no corroboration of his statement. Just a couple things that came out during trial, specific questions that were asked. Outside of his statement, there's no evidence to put him inside the house. Outside of his statement, there's no evidence that a crime occurred inside the house. And these are direct questions that I asked Agent Shadell and that Mr. Merchant asked Agent Rothwell. And they apply to all of the evidence when Your Honor's reviewing all of the evidence. Outside of Ryan's statement, there's no evidence that he was ever inside her home. Outside of his statement, there's no evidence she was killed inside the house. Outside of his statement, there's no evidence that the glove was present the day the murder is alleged to have happened. So if the state gets up here and says, well, the glove is corroboration, the evidence that we've heard from the witness stand are from people who say the glove was not there that day. So it's not in conflict. The uncontroverted evidence.
Well, didn't they say, in fairness now, they didn't observe. They
Right.
didn't swear it wasn't there. Would you agree with that?
I would agree with that. I would also agree that not one single witness came in and said it was there. And that's what the state's required to prove. So we did submit evidence that it wasn't there, and there can be an argument made that it wasn't there or it wasn't observed, Judge.
Right.
But the state did not submit one single piece of evidence to show that it was there. And that's their burden. So there's no evidence, again, that it was there that day. I asked Agent Shadell, was there any evidence on the glove to show that Ms. Grinstead was killed? No. Any evidence on the glove that she was murdered? Not murdered, no. When I asked him that, his specific quote, I went back and listened, is, I can't say the glove proves murder. There's no evidence that Ms. Grinstead died in Irwin County. None. Not a single piece of evidence. And venue is something that also has to be established beyond a reasonable doubt. There is no evidence that she died from a hit to the hand, which is how he is specifically charged in the indictment. Agent Shadell stated, it's impossible to say because there's no body. I cannot say she died from a hit from the hand. That's his direct quote. There's no evidence this was Agent Rothwell, to corroborate burglary or assault. Agent Rothwell's answer was, other than his statement, no. I'm sorry, that was Agent Shadell. Now we get on to Agent Rothwell. Agent Rothwell said that GBI believed the glove was involved in the disappearance, but there's no evidence to show the glove was involved. We do not know what happened to her. That's Agent Rothwell. We do not know if something happened at that house. Again, Agent Rothwell. She may have been killed somewhere else. There is no indication of foul play in the house, no evidence that the crime occurred at her house. We do not know if a crime occurred at all. We never knew what happened. We do not know if she was killed. Not one single witness said differently. There are some cases that talk about where there was some corroboration when there's the absence of a body. There's really two cases.
Isn't that typically up to the jury whether there's sufficient corroboration or not?
No, Judge, it's not. And the cases actually, all of the cases that we cite are where a judge did not direct a verdict, like we're asking for, and he was reversed for not directing a verdict. Okay. So all of those cases said that it was improper for it to even go to a jury. And the issue is, and that's a great question, because the issue really is, does it turn on us having to defend? Did they even overcome the burden to make us have to defend against it? Because they have to produce enough evidence to overcome that burden. And so it's a court resources, jury efficiency, all of these types of things. They've had weeks to try and prove these elements. If they did not prove the elements and there's not corroboration, then the case should not go forward. Then the jurors should be free to go, the court should direct a verdict, and this indictment should have the directed verdict. That's the whole point of the directed verdict, Judge. That if the evidence at this point in the trial is not enough, if the jury was to find him guilty at this point, you would have to vacate that verdict because there's not enough evidence to support it. There's absolutely no evidence, actually, to corroborate his statement as to corpus delicti. And so that is why the court is empowered by our law, and it's a statutory right. The court has a statutory power to direct a verdict when there's no corroboration. This is important enough that we actually have a statute that requires corroboration because of the risk of false confessions. And that's in the notes to that statute. It says the reason that the law requires corroboration is because people can confess to things they didn't do. And so if there's no corroboration, you cannot convict someone based just on that statement. And that's something that is for your honor. That's a statutory protection that he has. That's something we can obviously argue to the jury if we have to, but we shouldn't have to because it's a statutory protection and you're emboldened with that power to grant the directed verdict based on that. The few cases that do exist where there's no body, no evidence that someone was actually murdered, the few that have survived have a significant amount of corroboration. Unfortunately, they're rather graphic, but they're cases where one, for example, was where the person was bludgeoned to death in their home and there was brain matter, and they actually had a medical examiner who testified that you could not live from that type of offense. And I can save those for my, when I get to come back up after the state's done. But in this case, Judge, there's no evidence of venue also. They've got to have evidence that she died in Irwin County. They've got to have evidence that she died as a result of being hit in the head by Ryan Alexander Duke. That's what they charged in the indictment.
Is the blood on the quilt, does that lean towards that? Is that corroboration that something happened there?
It does not, and I'm glad you asked that. So one of the cases that I brought, I'll talk about two different cases. One of them is Richardson versus State, and that's a Supreme Court case. And in that case, the court held that when there's no dead body, and the dead body is not required, but the state still has to prove corpus delicti. They have to prove the death occurred, and they have to prove beyond a reasonable doubt that the defendant caused the death in the manner charged. In Richardson, the chief medical examiner testified. He testified that the crime scene had blood spatter evidence, and I think this is important, what he had to testify to in response to your question about the comforter. He said that the blood spatter and the crime scene led him to conclude the victim was repeatedly struck in the head, causing profuse bleeding and skull fractures and resulting in lethal injury. Additionally, the medical examiner testified that the pattern of bloodstains on the ceiling and walls in the victim's bedroom indicated that the victim had been struck at least 6 times by a blunt instrument, and that impact caused blood and brain matter to adhere to the walls.
That's considerably more.
Considerably more.
Yeah.
And they were able to take that brain matter and match it to the DNA of the victim. So in that case, they had confirmed that brain matter was on the wall, and that the medical examiner specifically testified about that. The other case that I would point to is, let's see. The McVeigh case, which I talked about a little bit earlier. In the McVeigh case, there was significantly more evidence. than we have here, since we don't have any evidence here. In that case, they had a tooth. So they had a couple things. They had they were able to identify the victim from a tooth, and they found the victim's shoe at the gravesite. So there was a clandestine gravesite, and they had the victim's shoe. The brother came in and said that was the victim's shoe next to the
Who said that?
the brother of the victim.
Okay, all right.
The brother of the victim came in and identified a shoe that was found at the gravesite. They also had an expert, a dental expert from the state, come in and testify that a tooth that was attached to a fragment of the cranium matched the deceased. So they had both of those. But they also had one more thing. In that case, they had a witness that actually saw the defendant poison, and they had a doctor testify that that drug would have killed a person. So they had significantly, I mean, we don't have any of that here. We don't have anything. We don't have any evidence that the bones are Miss Grinstead's. We don't have any evidence that she died in Irwin County. There is no evidence she died in Irwin County. None. There is no evidence she died in that home. There is no evidence she died from a homicide. We asked the experts that the state brought if they could tell from the trauma to her head if there was any evidence that she was hit. None. There's nothing to corroborate it. There has to be something. There's absolutely nothing to corroborate it. And so we think that the only choice is to direct a verdict, Judge, on all of those counts. Thank you.
Do you have your brief to
Yes, let me
share with me?
And let me give you the cases and the state cases as well. Here's the original. May I approach Ms. Nancy?
Oh, sure.
Do you need her to stamp it in first? Or?
It doesn't matter.
Okay.
I can just write on it, filed in open court. Be
Great,
fine.
thank you.
Good, thanks.
And the two cases in the back.
All right, Richardson and McVeigh I've got.
Those are the two that I,
Thank you.
yes.
All right. Ms. Hart?
Thank you, Your Honor.
Move this so I'm not blocking anyone. Your Honor, I would cite first to Cummings v. State, Cummings v. State, 272 Georgia App 886. It's a 2005 case. I'm going to get to some Supreme Court cases, but that had very direct insight into what this court is to consider when moving for a directed verdict. Defense counsel has tried to conflate the idea of a directed verdict and the idea that there must be corroboration of a confession. And those are not the exact same thing. It is not that we have to, in fact, have other corroboration of every single element of the crime in order to satisfy directed verdict. That's not what the cases say. In this particular case, which again is a 2005 case, it talks about there was an argument that the trial court had erred in failing to direct a verdict in favor because his confession was not corroborated. That's exactly the point that they were looking at. It says that OCGA 24-353 recognizes that a confession alone, uncorroborated by any other evidence, shall not justify a conviction. However, evidence of a confession freely and voluntarily made by the defendant is direct evidence of the highest character, and when corroborated by proof of the corpus delicti, is sufficient to authorize a conviction. Proof of the corpus delicti is sufficient corroboration that a crime has been committed. The corroborating evidence or circumstances need not connect the defendant definitely with the perpetration of the offense. Corroboration in any material particular satisfies the requirements of the law. The finder of fact must determine the amount of evidence necessary to corroborate a conviction. In doing so, the fact finder may consider the confession along with other facts and circumstances independent and separate from it, determining whether or not the corpus delicti has been established to their satisfaction. Keeping all of that in mind, along with the fact that we are looking at the evidence in the light most favorable to the state, in this case, the non-moving party. You take that, Judge, in connection with some of the cases, and in fact, Richardson is one of them that I was going to cite to the court as well, but some of the cases in which they have failed to have a body because the defendant was responsible for destroying the body, as we have here. Let's see. In Thrift v. State, 310 Georgia 499. That's actually a 2020 case, Judge. This particular
310 499.
310 499 Supreme Court case. And in this case, they had a similar situation in that there was no body. He admitted over various times to different people that he had murdered the victim and had disposed of the body in the swamp, actually, so there was no body left to be had. There was some discussion about whether the statements he had made to other people were considered confessions, and the court held that they were. And then they went on to determine whether or not they were sufficiently corroborated in order to determine whether or not there was sufficient evidence for which a jury could find the defendant guilty. Here's the things that they had in that case in Thrift. Thrift's confessions were corroborated by evidence that Rouse, R-O-U-S-E, was having an affair with Rhonda. That would be, I believe...
Rouse was the victim, I guess.
Rouse was the victim. Rhonda was the wife of the defendant, is my understanding. Rouse and Rhonda met up the day before his disappearance. Thrift and his wife got into an argument the early morning hours of the day, and Rouse and Thrift did not ride to work together, although this was their usual routine. Evidence showed that Thrift knew about the affair and even believed that his daughter was actually Rouse's biological child. Rouse was seen at the Thrift house on the morning of his disappearance, and Rouse's car was later discovered abandoned outside the entrance to the swamp where Thrift said he dumped Rouse's body. The state introduced evidence that Rouse had close family connections, yet uncharacteristically had failed to contact his family or appear at any family events for more than 20 years. This, and it says, this and other evidence at trial was sufficient to authorize a trier of fact to find Thrift guilty of felony murder.
How long after the disappearance was that case tried? Does it say? 20. You just said he didn't show up.
So it had to be at least 20 years. Yes, sir. I didn't look to see the exact date, but I'm sure I can do that. Obviously, it was tried under our new rules, so it had to have been tried within just the last few years. I'm looking to see if there's a date.
Reported in 2020.
He was disappeared. Yes, sir. He disappeared in 1991, so it was actually much older than our case. And in that case, Judge, essentially all they had was motive. They had the fact that there was an affair going on, and then they had the fact that he was seen at their house, but that wasn't unusual because apparently they rode together to work. Here, Judge, what the court has in front of it and what the jury has in front of it is that Tara Grinstead, from the evening of October 22nd, 2005, until the morning of October 24th, 2005, is not seen. She's not heard from. She doesn't contact anyone. The evidence would be that the last person she spoke with was Heath Dyke, and that they had made plans to see each other the next day. There was no indication that she was mad at him or that she in any way didn't want to see him the next day. In fact, his testimony was that when he told her he was going to come see her the next day, she acted happy. Despite that, she never returned his phone calls the next day. It's obvious that they were still on her answering machine, as well as the fact that she wasn't answering her phone. They find her house, and the evidence has always been and continues to be the fact that it was a crime scene that could have gone either way. You have teenage girls in and out of the house the day before, and so there certainly is somewhat of a mess before that, but then you've also heard from a witness who was, other than the defendant and the victim, probably the last person in that house before she's murdered, that being Ms. Giddens, and she indicates that it is in a different condition than when she saw it that afternoon sometime around 4 or 5 o'clock. On top of that, you do have the blood on the comforter. Now, certainly there could be an innocent explanation for that blood, and they've always said that. But there also, the jury could look at that and decide that that is evidence that a crime occurred. And based on what the victim confessed, which is that he hit her and that she fell, certainly the jury could believe that that would result in some sort of blood being found. On top of that, Judge, there's evidence from Agent Shadell that throughout the course of this investigation, they knew that both her keys and her purse were missing. We have that discussion that takes place during the confession about him taking the keys and the purse. Now, granted, that comes from Agent Shadell asking him about things that Bo has said, but
my recollection is he never really acknowledged that that was a possibility.
he never said, I definitely did it, but at one point he does say, if it had been on my mind, it would have been on my mind after I disposed of the body, and it just would have been another place for me to put it. He never affirmatively says, I definitely did it, but he also doesn't deny it. And at one point, again, this wasn't played in front of the jury, but the court has heard it. At one point, he did say Bo's memory was probably better than mine. So again, that doesn't go to the motion for directed verdict, but I think that the court can take that into account as it relates to the conversation that goes on about the purse. But that shows the burglary element. On top of him saying...
I mean, I'm limited to what the jury's heard, right?
Well, I agree. What
the competent evidence.
And what the jury has...
Anything that's not in evidence, that can't be part of the consideration. It's not in evidence, and that's not in evidence.
I was just responding to your Honor's question about that you never really heard him, and so I was addressing how that comes in. But what at some point he does say, it would have been, if I had thought about it, it would have been afterwards, after I disposed of the body, and he never denies the fact that he did that, but he certainly doesn't affirmatively say, absolutely, yes, I did it. But he also admits to having gone into her home in the first place.
Phone call's a little more concrete, right?
Phone call's definitely a little bit more, it's definitely a lot more concrete, but he admits to going into her home for the purpose of committing a burglary. He says that when she came in, he was going through her purse. And in fact, at the point where Agent Shadell is asking him, one of the points where he's asking him about the purse, he says, well, I mean, that was what you were doing anyway. That was your intention. And he says, yeah, that was why I was there. And so that certainly, if you combine that with the other evidence that we have in this case, which is that she disappears the evening of the 22nd, no one hears from her again. You have the glove. Now, while defense counsel wants to argue that there's no affirmative evidence putting it there, as your Honor has pointed out, the two people they called have said very plainly, it could have been there and I just didn't see it. One of them was at midnight or a little after midnight. The other was focused on something else. He wasn't looking for debris in the yard. What we do know about that glove is that it contains the DNA of Tara Grinstead and it contains the DNA of Ryan Duke. We also know that it has Ryan Duke's palm print on the glove. That glove that was found on the morning of October 24th in the yard of Tara Grinstead. There has been no other explanation as to why that glove would have been there other than the fact that he gave us, which is that he went back to his house to get that glove, to bring it back to use it to clean up. That's what he said, and that is corroborated by the glove with his prints and with his DNA being on it. The reason that Agent Rockwell indicated that glove was so important, and he actually, I think he referred to as a game changer, is because once they learned that glove has Tara Grinstead's DNA, it's obviously connected. This is not just some trash that's blown up out of somebody else's yard. Clearly this is connected. So it may not have her blood on it, but it certainly has her DNA, which means at some point that glove has touched her. And in fact, you heard from the crime lab witness that at least as it relates to the outside, that it's pretty well 50-50. 50% of the DNA comes from the defendant and 50% comes from
testimony I recall.
From Tara Grinstead. Then you go to the phone call, Judge, which is, again, you've heard from several different people that this was held back. This was kept very quiet. You even heard the district attorney at the time, Paul Bowden, didn't know about it. And in fact, that phone call matches up to what the defendant says he did. Defense counsel has tried to say, well, they gave him the information, fed him the information. That's not true. You listen to it. What happens is he says, well, what about phone calls? Did you ever call? He initially says no. All Agent Shadell says is, well, we know there were some phone calls made that morning.
That's my recollection.
Which is true, and there were more than just that phone call. But then he knows not only that it's a payphone, not only where it is, but that it's a 411 call. Those are very specific details that corroborate his story. And his version of what occurred. So on top of thrift, Judge, if you look at, I think it was actually Richardson, that I was going to cite to the court. So give me just a moment.
Richardson is the 2003 case. Yeah.
Yes, Your Honor. It's older than the one thrift that we've just looked at, but sorry, I'm trying to find it on the one that they printed so I can direct the court to where it is.
Well, it's a short opinion.
It is. Okay, here we go, Judge. It looks like it's subheading 4.
Okay.
In this particular argument, he was arguing that the jury was not properly informed of the burden of proof. In that case, they said that the trial transcript shows that the trial court told the jury that the state was not required to produce a dead body in order to prove that a death occurred, but could establish the corpus delicti by circumstantial evidence. The jury was then instructed that the state is required to prove beyond a reasonable doubt. And again, they talk about the corpus delicti in this case not being that we have to prove that the defendant himself actually committed the crime. Just give me just a moment. Probably going to be quicker for me to find on mine, but so under subheading 2, they talk about the evidence in this case to prove that the missing victim in the case at bar was dead and had died as a result of the criminal act of another. The state presented evidence that the victim had not been seen since the August 15th fire, that he was a man with personal relationships that uncharacteristically he seemed to have abandoned, and that he had acted out of character in leaving a car repair job unfinished that he had not reported for work since the fire. We certainly have at least that much, if not more, Judge. You've heard from multiple witnesses who've indicated that Tara Grinstead was not the type of person who would just not show up to work. She was not the type of person who would just leave her family and not give them information about where she was, her family, and her friends. And now in that particular case, they do go through the blood spatter and the other information. But when it comes to the fact that the victim was missing or the victim was deceased, they start with the fact that the victim just disappears. And if you compare that with Thrift, which is a much newer case, then it shows you specifically that the evidence in our case is sufficient for the court to deny their motion for directed verdict. And again, remember, the defendant has confessed to every single element of the offense that's been charged in this indictment. The question isn't whether or not there's sufficient evidence. The question is whether or not there's sufficient corroboration based on what you've heard in order to find to deny the directed verdict. Because each and every element that's charged in this crime, the defendant confessed to. And in fact, the indictment was drawn based on his confession. However, there is more than sufficient evidence for this court to find that there is sufficient corroboration. Pointing to one, of course, the glove. While they want to say that it wasn't there those 2 days, that's actually not what the evidence is. The evidence is no one saw it there those 2 days, but neither of those persons were exactly looking for it. There's also evidence, at least from Joe Portier, that he didn't even see the glove in the daylight hours until he was leaving the house. He didn't see it when he was coming in. He saw it when he was coming out because he was making a phone call and sort of looking around. And then, of course, the call itself is extremely strong evidence. There's other evidence that we've heard, obviously, as it related to the fact that her room looked like it could have been a struggle, that her bed was made when Miss Giddens went there, and then it wasn't made later. Obviously, in the pictures, that it's sort of everything's thrown about. There's blood on the comforter.
Is there anything in the record related to where the defendant took law enforcement that same day to the orchard in Fitzgerald Farms, as opposed to where later on the dig was done and the fragments were found?
Yes, Your Honor. I actually asked that specific question of Agent Shadell. I can't tell you the exact amount of... He indicated that it's all in the same area, and I can't tell you sitting here. Someone else may have better notes about what Agent Shadell said.
I'll check my notes.
I did ask that specific question, and he did indicate that it was all in the same area. And you actually hear the defendant multiple times talk about the fact in the confession, talk about the fact that everything looked different, but that had been a clearing. That would be corroborated by what you heard from Randy Hudson when you talked about the significance of that place, and that was the spot that they used for hunting and those sorts of things. If we can get the answer to the question about what Agent Shadell said, I'll give that to you in just a moment, Judge. But I did ask that specific question.
Thank you.
Thank you.
You familiar with thrift, Miss
I'd love to have a person copy of
Merchant?
I'm happy to let her see it on my computer. That's the only place I have it.
Yeah, I don't have the copy either. I got 310 Georgia 499. Is that right, Ms. Hart? On thrift?
Yes, Your Honor. Or I
And
can
then-
ask someone to print it for me.
I don't need it.
I have my notes from thrift.
Okay, Cummings 277 886 or 272. I can't read.
277 Georgia at 886.
All right, 88. Thank you.
I did not look at Court of Appeals because the corroboration requirement was so different in homicide cases, so I specifically excluded Court of
Well, it
Appeals cases.
sounds like, at least, and I'll read the cases, of course, but it sounds like sometime between McVeigh and thrift, they sort of lessen the burden as far as getting past summary judgment.
I don't believe
No?
they did. So
Okay.
what I do know about thrift, and again, I don't have a copy, so I can't cite specific sections, but I read it quickly on Mr. Gibbs' computer when the state cited it. And so the things that I did point out about that is, first of all, that's not a directed verdict case. So that was a motion for new trial case as a 13th juror. So it wasn't whether or not the state could overcome directed verdict, where Richardson specifically was a directed verdict.
So it wasn't based upon the trial court's denial of a motion for...
It was not, Judge.
Okay.
No. So it's in opposite to the situation we have here. But also in thrift, there's a couple of other things that I think are important to note. In that case, they found the victim's car at the scene of where her body was alleged to be dumped.
Something about a swamp, she said. Is that where the body was found?
Yes, Judge. Okefenokee Swamp.
But
So-
they never found the body.
I don't believe they found the body, but I did note that one of the things that the court found was corroboration was the fact that her car was found at the scene that the defendant Thrift said he dumped the body.
Right.
So he said he dumped the body, and he told a lot of people that he dumped the body there, and they went to that location and they found her car there. So that was some evidence to corroborate that she had been dumped there. That was just one thing, though. So the other evidence that they had in that case was they had significant evidence of an affair, so much so that Thrift was, there was evidence that Thrift was the biological father of the victim's child. So there was evidence, extensive evidence of motive.
Now, what she recited was that the defendant thought that there was not. Are you telling me that was conclusive? I mean, that they...
The evidence was
that he knew that fellow
yes.
fathered the child he'd been raising.
Yes.
Is that what you're saying?
Yes,
Okay.
that's what the evidence
Well,
in the
I need
case
to
was.
read those.
There also was a witness who, on the day that she went missing, saw the victim and the defendant together. So that was the other corroboration. And that, again, that was within my 3-minute read. Unfortunately, I don't have a copy of it here. But those are things that we don't have in this case, Judge. The state has argued that the phone call is proof, but I'm not quite sure what the phone call corroborates. Phone call does not corroborate cause of death. And remember, this is not corroborating his statement. This is corroborating corpus delicti. So it's a different requirement. They want you to believe that they just have to corroborate his statement. That's not true. They have to corroborate corpus delicti. They have to have independent proof outside. The statute says they have to have independent proof outside of his statement to show the cause of death and to show that Mr. Duke caused the death in the manner that it was stated in the indictment. That is a significant difference than corroborating his statement. Whole different ballgame. The phone call does not corroborate cause of death. We have no idea what the cause of death was. There has not been one single witness to testify what the cause of death was. Not one. Not one piece of evidence. Not one witness said that she died in Irwin County. Phone call does not corroborate that Ms. Grinstead died in Irwin County. Phone call doesn't corroborate she died at all. We do not have any proof that the bones that they found where Randy Hudson led them in the orchard are Ms. Grinstead's. Ryan did not lead them to the location of the dig. The testimony that you asked about with Agent Shadell, he was not able to lead them to that. That would be evidence that in Ben Hill County of concealment, which is not what we're here for. We're here for Irwin County. We're here for crimes alleged to have happened in Irwin County. The glove, the state, outside of the phone call. So the phone call, what does it prove? Proves he called 411? No one saw him call it. It proves that for the phone call to be relevant, you have to take into consideration his statement. And what the law says is you can't take into his statement to corroborate. Like, his statement can't corroborate itself, if that makes sense. So the only evidence they have that he made that phone call is his statement. So back up. They're saying that the phone call corroborates that he did this and that she died in Irwin County and it was a murder. The phone call, the only evidence that he made that phone call is his own statement. There's nothing to corroborate that he made that phone call.
There's no video on the payphone.
Right. There's no witness, there's no video, there's nothing. There's just his statement. His statement can't corroborate something. That's what the law says, it can't corroborate something. But regardless, it's not corroboration of the corpus delicti. Then the glove. So the glove could have been there. There is not one single witness who said it was there. And again, what is the glove proof of? Is the glove proof of the cause of death? Is the glove proof that she died in Irwin County? Is the glove proof that she died at all? No. It does not corroborate corpus delicti. There is absolutely no evidence in this case. And it shouldn't go forward at this point. The case needs to be dismissed. It needs to be a directed verdict. There's not enough evidence for this court to even entertain another week or two of trial. Thank
Good.
you.
Thank you, Ms. Merchant. All right, I'll let y'all know as soon as I make my decision. But we'll go in recess at least another 45 minutes. But as soon as I'll have the bailiffs tell you what my decision is before we come back and open the court. We'll be in recess at least 45 minutes. Thank you. Y'all enjoy your lunch.
Court is back in session.
Yeah, please keep your seats. All right, Ms. Ross, let me hand you this motion for the, you'll include that in the record, please. That was the motion for directed verdict. Hope you got the message. Your motion for directed verdict is timely made, overruled, and preserved for the record, okay? Mr. Duke, let me have your attention for a moment, sir. I want to make sure that it's clear in your mind that in the trial of this case, you have the right to testify or not testify, okay? I'm confident you and your attorneys have discussed all of this, but it's important that it be on the record. If you choose to testify, sir, you would first be examined on direct by one of your attorneys, okay, who would ask you questions. You would testify, and then the state's attorneys would have a right to cross-examine you if they chose to do so. You understand that? You likewise have the right not to testify. You have the right not to testify in the trial of this case, of course. And if you choose not to testify upon request by your attorneys, I'll tell the jury that they couldn't hold your failure to testify in the case against you in any way, shape, or form in reaching their verdict of guilt or innocence. You understand that? All right, I just want to make sure those rights are clear to you. All right, state's rested, of course, right before lunch. Mr. and Miss Merchant or Mr. Gibbs, do y'all know if you want to present any evidence at all?
We do, Judge.
You do? Okay, thank you. I'll ask the jury to come on in at this time and inquire again in their presence, and then you can know your presence.
Before we have the jury.
All right, excuse me, Miss Watkins. Yeah, I jumped the gun on it. Yes, sir.
Apologies. Judge, we had a copy from the court filed. This is me filing it, actually. Just served it upon defense counsel. A motion in limine to prohibit defense counsel from calling Bo Dukes as a witness. I spoke with Ms. Mullis last night, who is representing Mr. Bo Dukes in both his Bentonville County case that's pending before Bentonville County, as well as his pending court appeals case in Wilcox County.
Sabril Davenport, mother of fallen Second Lieutenant Jared Lloyd. Fallen Second Lieutenant Jared Lloyd of the Spring Valley, New York Fire Department repeatedly rushed into a burning nursing home to carry out elderly residents who couldn't escape in their wheelchairs and walkers. Along with his team, Lieutenant Lloyd rescued all 112 residents. As flames engulfed the building, Lieutenant Lloyd ran back in one more time to make sure no residents were trapped, ultimately sacrificing his life as the building collapsed and demonstrating heroic actions to protect innocent civilians. Firefighters John Calandro, Michael Rosero, and Chad Titus. Firefighters John Calandro, Michael Rosero, and Chad Titus of the Stamford, Connecticut Fire Department drove into freezing water during a blizzard to rescue two trapped occupants of a truck that was rapidly sinking below the waterline. After rescuing one victim, the truck fully submerged and facing strong offshore winds, the rescuers then broke a glass window while underwater and successfully pulled the remaining passenger out to safety. All three men demonstrated extraordinary courage to save accident victims. Officer Anthony Giorgio. Officer Anthony Giorgio of the Pensacola, Florida Police Department, while on a beach vacation with his family, heard screams coming from the water as swimmers were pummeled by tall, crashing waves. Officer Giorgio ran into the dangerous rip current and brought a child back to shore. He then jumped back into the water several more times and in total swam approximately 300 yards and successfully rescued 2 children and 1 adult in distress, putting himself in grave danger to save lives.
Vacation he'll never forget. I'd like to give one last round of applause to the recipients of the Medal of Valor. Thank you all for your service and sacrifice. And may God bless you, keep you safe, and may God protect all firefighters and all police officers. Like I said, you're the character of the country, and you're the best of all of them. Thank you all for being here. Appreciate it.
President Biden honoring those who go above and beyond in our law enforcement there, helping and saving the lives of so many across the country. You're watching Live Now from Fox, always with you here as we bring you top stories, headlines from all over the country. We're going to take a quick 2-minute break, everyone. When we come back, we are going to take you out a little bit later to the White House infrastructure meeting that'll be happening. It's happening right now, but we'll get to it a little bit later here on Live Now from Fox. We're also awaiting in about 90 minutes the formal White House news briefing as well, with updates from across the country as well.
It's a great time to get connected to what's going on in your community. Sign up for Fox 5's daily email newsletters like the Morning Brief and get contest updates and breaking news alerts sent straight to your inbox. Sign up now at fox5atlanta.com/email.
Well, what kind of assessments do you do that are not forensic assessments for court?
Let me clarify your question. You said not forensic assessments for court. And so none. So anything I'm going to do for court is a forensic assessment.
So my question is, how many assessments that do you do that are not these forensic assessments for court?
Okay, I got you. So probably, I would say 70% of the evaluations I do not anticipate they're going to go to court.
And for whom do you prepare those assessments?
Yeah, so typically I provide those assessments for DFACS, Department of Family and Children's Services, and those assessments cover a variety of different issues. Sometimes they go to court, but most of the time they don't.
But those assessments themselves actually can be used in court as well, correct?
Yes, they can, yes.
Outside of your work for DFACS, it would be fair to say the majority of your work is done as a defense expert, correct?
I'd say about 10% or so.
You don't maintain a contract with the Georgia Public Defender Standards Council to assess people on their behalf?
I don't have a contract, no.
How often do you do work for the Georgia Public Defender Standards Council?
Probably, since COVID, pretty infrequent. Before COVID, fairly frequently. During COVID and since COVID, I think I've had a few cases, not that many.
Well, you did this evaluation back in 2019, correct?
Correct.
And now you only evaluated this defendant one time?
That's correct.
Judge, I thought this was not cross-examination, but his qualifications.
Judge,
How's this relevant as to his qualifications?
Judge, the only reason I was asking about when he interviewed this defendant is he's just differentiated from post-COVID to pre-COVID. And so I was just going into the fact that I want to talk about his work pre-COVID, not his current work.
What's that got to do with his qualifications? I understand it may impact his credibility for the jury, but what does it have to do with his qualifications?
His qualifications as it relates to the type of work he does, they have tried to tender him just generally in the field of psychology, which is a very broad field. And so I'm going into specifically the types of forensic interviews or forensic assessments he normally does for the Georgia Public Defenders Council.
He was tendered as an expert in psychology and forensic psychology, is that correct? All right, well, I'll overrule that objection. Keep it on his qualifications
Yes, Your Honor.
for the time being and experience in those areas.
Yes, Your Honor. So we're going to talk about the time period in which you interviewed the defendant, which would have been pre-COVID. At that time, how many assessments were you doing regularly in the field of forensic psychology or forensic assessments?
How many per week?
Whatever category you want to give us.
Okay. So before COVID, I was conducting far more evaluations than I am now. So in any given week at that point, I was conducting evaluations with DFACS frequently, many a week. Now, how many had to do with like case review or like pretrial competency or those kinds of things? Probably a couple a month, a few a month.
A few a month.
Yes.
Okay. And so I want to differentiate because you've just talked about two different things.
Right.
So competency to stand trial is different than criminal responsibility, correct?
Correct.
And you're saying that
I'm sorry, this is cross-examination, this is not voir dire. And she's entitled to cross after I actually question him about his work. This is just about his qualifications right now.
Again, the field of forensic psychology is incredibly broad. So what he has actually done in the field of forensic psychology, I don't know if I'm going to object until I know what he's actually done in that field.
I overrule that.
So in the field of forensic psychology, how often have you had an occasion, again, pre-COVID, how often were you evaluating persons for pretrial competency to stand trial?
So probably a 1 or 2 a month.
And how many times, period, at this point, have you testified in the court of law as it relates to pretrial competency to stand trial?
I can't give a hard and fast number, but probably 20 or so.
And as it relates to criminal responsibility for the crime, how many times have you had an occasion to assess someone for that?
To assess, probably 50, maybe more.
How many times have you actually testified as an expert as it relates to criminal responsibility?
20, maybe.
Now, you talked about that you have done, you have testified in areas of what you called sub-areas of psychology. One of those that you listed was addiction.
Yes.
Have you ever testified in a court of law as it relates to addiction issues?
Frequently.
Okay. And what is it about your experience in psychology that enables you to testify about addiction?
Sure. So my pre-doctoral internship at the University of Tennessee had a specific area regarding addictions. One of my internship placements was at the University of Tennessee Hospital in the addictions unit, where I assessed people who were inpatient addiction patients. When I was at Charter Lake Hospital, the Charter Lake Hospital in Macon had an addictive disease unit. At one point, I was the psychologist working with that unit, and I evaluated every person that came into the addictive disease unit. With the Department of Family and Children's Services, I frequently conduct evaluations about addiction, about substance abuse. It's called the substance abuse evaluation. And if I estimated how many substance abuse evaluations I've conducted, it would be over 1,000.
And in that nature, you would agree with me that there's a difference in assessing someone for an addiction versus assessing whether someone is under the influence at any given time.
Yes.
No, I do not. Well, actually, I have one more question, possibly more. Do people with PhDs in counseling psychology in the state of Georgia, is there a board certification for that?
One, it has nothing to do with the state of Georgia, but there can be board certifications.
Okay. And since you did not mention it, I would assume that you are in fact not board certified?
I am not board certified.
Your Honor, I do not object to him in the specific categories of addiction and also forensic assessment of pretrial competency and criminal responsibility. I do object to him being allowed to testify just overall in the general field of psychology. That is an incredibly broad field, and there has not been a foundation to show that he has the expertise related to the entire field as it relates to developmental psychology and those other things.
I'll hear from you.
Judge, he's been qualified in hundreds of cases in Georgia alone, federal court, as an expert in forensic psychology.
All right,
most of them from the state.
Ladies and gentlemen, Dr. Taliski has been offered as an expert in his field of psychology and forensic psychology. The court's going to accept his qualifications in that regard, give his testimony, whatever weight and credibility you believe it to be entitled to, just as you will any other witness and any other expert witness. All right,
Thank you, Judge.
That's overruled, Ms. Hart.
Thank you.
You can proceed.
Thank you. So, Dr. Taliski, how did you get involved in this case?
You gave me a call.
Okay. And what did you review?
So you gave me a call and asked me to get involved with this case. And with that, I reviewed the key documents available at that time. That included the indictment, GBI interview. There were audio interviews as well as a video, as well as a transcript of the interview, as well as Mr. Duke's handwritten statement.
And did you meet with Mr. Duke?
I did.
Did you conduct any evaluations or assessments on Mr. Duke?
I did. So I came down to the jail and met with him and did a broad interview, about a little over 2-hour interview, and I also administered the NEO 5-factor personality inventory, and I wrote a report of the results of that.
Okay. Let's talk about that personality inventory for a second.
Sure.
Your findings.
Sure.
What were your findings in regards to neuroticism? And first, can you tell the jury, I'm sorry, what neuroticism is? Because
Well, maybe I'll talk about the test first, just to set it. So the NEO 5-factor personality inventory is a measure of personality. And decades ago, personality, the Big Five theory of personality became widely accepted. And Big Five means boiling down personality into these 5 general, broad categories. And this test was designed to measure those 5 areas, and so that's what I administered. One of the areas you asked about is neuroticism. So neuroticism is a scale. On the high end, it measures people who are have a lot of neuroticism, and to fill that out, what that means is have a lot of anxiety, have a lot of negative emotions, anxiety, fears, being antsy, those kinds of things. On the low end of neuroticism is people who are really just, they don't get upset about stuff. Maybe a firefighter would need low neuroticism. They can go into a fire, feel comfortable, maybe not comfortable, but they don't get too freaked out by that situation. So that's neuroticism. And he scored on the very high end of that.
Okay. And when you say he scored on the high end, what does that mean?
That means high neuroticism, so a tendency to have high emotions. And he told me that he...
Objection, Judge. I'm objecting to testifying. Is anything the defendant told him during the evaluation? Specifically, Judge, the courts have held that while he may give an opinion as to an opinion based on what the defendant told him outside of court, that evidence will actually, he said, is not admissible in court.
Judge, they've admitted his statement, several hours of his statement, and this is his analysis of what he said in response to certain questions in the personality. It's not, doesn't violate any evidentiary rules, Judge.
Just specifically Rule 24-7-703.
That's a statement.
Thank you.
Without telling me what Mr. Duke told you,
Sure.
But based on what he told you, what did you find as far as neuroticism?
Right. So the test had a high level of neuroticism. So a test score is one thing. So he also, it was my understanding, there's corroboration to that test score. So there was other information that would corroborate, that is, increase the validity. That's probably a valid or accurate measure of his personality.
Okay. Great, thank you. What about extroversion? Can you tell us what that is and how Mr. Duke scored on that?
Sure. So extroversion is another scale on a continuum between social extroversion and social introversion. And social extroversion is a bubbly person. They like people. They go to a party, they meet everybody, they talk, they feel comfortable. Introversion, down at the other end of the scale, they might not talk too much at a party. In fact, they might not like so much going to a party. They might like to have close friends, but they're not really much of a talker. And so on that scale, he scored on the low end, more towards social introversion, not being so much of a people person.
How does that relate to social anxiety? Or did you find anything, I'm sorry, let me rephrase. Did you find anything in regards to social anxiety?
So the combination of those scales, that is high neuroticism and tendencies towards introversion, would a person like that would typically have some anxiety in social situations, and maybe a great deal of anxiety.
Okay. What about agreeableness?
So agreeableness on this test has to do with how much a person is hard-headed on the low end. Hard-headed is my opinion. I'm right. Versus on the other end of the scale, people who will just kind of agree. They might not really agree, but they'll say okay because they want to get along with people. And so agreeableness can be high or low. And on this scale, Mr. Duke scored on the higher end of agreeableness. So on the low end, lots of spine, stand up for things. On the high end, maybe not so much spine, or maybe no spine.
What, as far as agreeableness, how does that play into how he would respond to a conflict?
So in terms of a conflict, if confronted or in a conflictual situation, more likely withdraw or not push his point, or even kind of agree with whatever was going on.
Great, thank you. I want to talk to you about a little bit more, not just about his personality test, but more about the factors, how that applies to this case and your review of this case. As far as mental illness, how do you believe his mental illness has affected him?
Yeah, so there's a great deal of research about factors that affect what happens in interviews in general, but in police interviews in particular. And mental illness is one of the identified factors that can affect what happens in that interview. So a person with mental...
I'm going to object in testifying specifically as it relates to any connection between mental health and police interviews, unless there's a foundation laid that he has personally any experience with that, or if he's going to actually provide any research that we can look at.
I'm happy to do that.
Good. All right.
If that is permissive.
That'll be fine.
No, I'm saying I want to see the research he's basing it on, Judge. If he's going to talk about things that are beyond his scope, because psychology does not include police interrogation. So now we're beyond that into police interrogation, how people respond to that. And so I don't believe that's within his expertise that the court has allowed him to be. So I would object to that. And again, if there's a psychological report related to that, then I think the state would be allowed to look at that as to what he is basing that opinion.
Judge, the state received that psychological report in May of 2019, and we were trying to remain within certain parameters.
I don't mean the report he did, Judge. I mean if there is a psychological test, psychological study that has been done on which he is basing his opinion, then we would like that. I have a copy of his report.
I'm happy to go into that.
Yeah, let me have a couple of things outside. Thank you. It's hard to understand your objection. Is what kind of expertise does he have in this field of police interrogations? Is that right? Okay. I'll hear from you as to his qualifications to testify and give an opinion on police interrogations.
Judge, he has been qualified as an expert in false confessions, and I was being
But
very...
that's not been accepted in the state of Georgia. We all know that.
But Judge, the reason that
And
I
I've
haven't...
already entered an order specifically keeping that out.
And I agree, and that's why I wasn't asking him those things. And I was not planning on asking him any of that stuff. But the state objected, asking what his qualifications were, and the response is that his qualifications are about research and false confessions. So
Which has
I don't
not been
plan on-
accepted as
And I'm not
an
going
area of
there.
expertise in this state.
But the only way I can answer their question is by going into that. So, and I'm not planning on going into that, but that's what they're asking.
So you're not going to ask him about anything to do with police interrogations then?
No, I'm going to ask him about the psychological factors that are present in Ryan's, with his personality.
Well, I think your question was, what are, please restate the last question. Hang on a second. Go ahead, Ms. Coffey. Please restate Ms. Merchant's last question.
Question. I want to talk to you about a little bit more, not just about his personality test, but more about the factors, how that applies to this case and your review of this case. As far as mental illness, how do you believe his mental illness has affected him?
That's it?
That was the last question, yes.
Well, where am I getting this about the question about the police interrogation? Is that just how you responded? Did you say there was a ton of information or research out there on police interrogations?
Really
is that what you're?
Yes, sir. There really is.
Okay. Well, I don't dispute that.
I
It's
got
just that it's not.
was
The
in
topic about false confessions is not admissible in the state of Georgia.
And I didn't ask about it. He's been instructed not to testify about that. But that if they're going to question what he's read, like I need to know the limitations on what he's read.
Apparently, his answer was not responsive to your question.
Okay.
Apparently, I don't think it'd be appropriate to go into that any expertise or opinions as regard to police interrogations from this witness. So, otherwise, we'll just move forward. Anything further from the state?
Your Honor, may I ask for some direction from me?
Your direction is to listen to the question and answer the question.
Yes, sir.
I instructed him that he cannot talk about false confession theory, that's what the court had ruled, that he couldn't talk about false confession theory, and that he couldn't talk about anything that Bo said. Those were my instructions.
Okay.
So,
anything further, Ms. Hart?
Just to clarify, before we bring the jury back in, I'm also objecting to any statement, any opinion he's giving as it relates to the setting of police interrogations, because he's not been tendered as an expert in that field. Now, if he wants to comment...
Right, that's what I'm saying.
If he wants to comment on what he saw of this defendant and how he believed that affected the specific interview...
No problem.
That's different. But the general idea of confessions or interrogations...
What happens in police interrogations,
yes,
I think is appropriate. Right. We on the same page?
We are.
Dr. Tilitsky?
This interview. I can talk about this interview.
Exactly. Isn't that right?
Is that?
You have no objection to this interview?
Generally. I'm not saying I'm not objecting anything, but generally yes.
Okay, so this interview, so we can talk...
I can talk about factors I see in this interview.
But not opine anything about...
Generally
or the credibility of the statement, whether it's true or false, those kind of things.
I understand.
You understand
Do you
that?
understand that? Is
I
that
believe
clear?
so.
Okay. All right.
I'll try to stay in the guardrail.
We'll hear from the state if you don't.
Thank you.
Ask the jury to join us. Thank you.
I've got some, sir.
You got some?
Appreciate it.
All right, we got everybody in. There we go. Thank you. Thank you for your patience, ladies and gentlemen. We're ready to proceed. Go ahead, Ms. Merchant.
Thank you.
So how did Ryan's mental illness play into this interview?
So,
I'm sorry, I'm going to object to characterizing it as a mental illness. That's not what the testimony was from the judge. He talked about personality ranges, but he's never said that Ryan has a mental illness.
I'll ask that first then.
Yeah, I will ask you to please rephrase your question. I'll sustain that objection.
What mental illnesses does Ryan suffer from?
yes. So my impression is that he suffered first from addiction, and he had a long history of anxiety, even close to agoraphobia, where he was not leaving his house, depression. He had suicide, at least one suicide attempt, a psychiatric hospitalization. He was treated with a number of psychiatric medications.
So now, how did those mental illnesses factor into his interview in this case?
Right. So it's my impression that his mental status, his mental illness and conditions increased his chances of being vulnerable to pressures that occurred in that interview.
Okay. And as far as you mentioned suicide, was there anything that you noted about the interview and Mr. Duke's suicide risk?
So at the end of the interview, he was placed on suicide risk.
How do you think the personality traits that you described earlier, how did those correlate to his police interview in this case?
Sure. So one of the things is that I believe they correlate in terms of that get along, go along attitude, and that so the interview had a certain amount of pressure at times, and I believe in response to that pressure, I believe there was a tendency to acquiesce to the pressure.
Okay. And is that how you saw this personality trait affect the interview?
I believe so.
Okay. What about minimization? Did that play into the? Did you see any minimization affecting Ryan's mental health or emotional state? I'm sorry.
I think I have your question. So in the interview, I was alert to what is sometimes called minimization, and I believe that probably interacted with his personality and his mental status at the time, and again was a factor that affected the interactions that he had during that interview.
What about sleep deprivation? Did that have any impact on
Yeah.
this interview?
So it's my understanding and that he was sleep deprived. And beyond that there were drugs involved in his system, and that he was his mental status was degraded in the sense that he also had he had problems with his organs because of the drugs, and that those all coalesced to create, along with sleep, a lack of sleep, less focus, attention, and would probably exacerbate other tendencies in his personality during that interview to acquiesce.
Can you tell us what a guilt presumptive, what you would classify as guilt presumptive?
Yes. So in the context of this interview, and I'm being very cautious. Let me be careful about these words. But in this interview, it appeared to me that Mr. Duke responded to what is sometimes in the field called guilt presumptive types of questions, Sure.
As it relates to any discussion about what he's referred to as guilt presumptive, he's referenced, there's lots of stuff in this field. The field which he is discussing, I believe, is in fact interrogation techniques and not psychology. And so I'm going to object at this point that it's beyond the scope of his expertise, unless they want to lay a foundation of how they're getting that from psychology.
All right, see,
I can rephrase it.
let's do that as it relates to that, his specific field.
Thank you.
Ms. Murphy. Yes.
In regards to
I sustain that objection.
Thank you. The personality trait where you talked about him being agreeable early on.
Yes.
How does that relate to guilt presumptive interview? The interview in this case.
So his agreeableness in response to questions where there is a guilt presumptive air, he's more likely to acquiesce or to go along with that presumptive impression.
Great, thank you. You talked about his personality of avoiding confrontation. Did you see anything in this interview about denials triggering confrontation and how he dealt with that? Can you explain that?
I did see that, and I can explain it. So my observation was that when certain information was presented, it was confronted in different ways, and his response many times on many issues was to change and progressively move toward the information that he was confronted with.
Great, thank you. Just one moment, Judge.
Sure.
Nothing else, thank you.
Ms. Hardy, any questions for Dr. Talitsky?
I do. Dr. Schlitz, let's start with, you have never yourself done a police interrogation, correct?
I'm not a police officer, that's correct.
You've never been trained to do police interrogations, correct?
I've had continuing education about police interviewing and interrogations and the factors involved with those interviews that create psychological conditions that either increase or decrease the validity of what happens in those interviews.
Well, I appreciate that. And my question was, you've never had specific training on how to conduct an interrogation, correct?
An interrogation?
Yes, sir.
No, I don't conduct interrogations.
And in fact, you've not had any training on how to conduct interviews with suspects either, correct?
With suspects, I've had tons of training about how to conduct interviews.
You've had tons of training about how to conduct an interview in order to get a statement related to whether or not somebody's charged a crime, a charged crime.
So I've had a great deal of training about the factors in interviews that produce more or less valid information.
Again, appreciate that, but my question was, you have never personally been trained in how to conduct an interview with a suspect, correct?
I've not had the Reed training, no.
Okay. You would agree with me, though, that Reed training, as you've referenced, is not in fact just interviews. That is an interview and an interrogation technique.
Well, you're distinguishing between interview and interrogation.
Yes, sir, I am, because they're two different things. So you would agree with me that Reed has both an interview and an interrogation technique.
There are many techniques, yes.
So that's a yes, it has
Yes.
both. Right. And in fact, it never gets to be what we refer to as a Reed interview if you don't get to the interrogation part, correct?
The techniques are somewhat overlapping, so the techniques can be used if you don't interrogate anyway.
No, sir, you just said you've had extensive training in Reed, and in fact, Reed has a point at which you stop an interview, leave the room, and come back to start an interrogation, correct?
I'm not going to go there because I don't know about the stop point you're referencing.
Okay. But you said you've had extensive training in Reed technique.
I did not say Reed technique. I said interviewing.
On how it can affect persons when they're being interviewed, correct?
You mean police interrogations?
No, I'm talking about how the Reed technique can affect persons who are being interviewed.
I have continuing education training in that, yes.
How many hours?
I can't tell you specifically.
More than 10?
Yes.
More than 20?
No.
Right. And you've been doing this how long?
30 years.
And in those 30 years, when did you get those less than 20 hours on Reed technique?
I don't know the first time. I know specifically in the, I think 2017 is a specific workshop that I remember with specificity.
And that specific workshop, who put on that workshop for you that you attended?
The American Academy of Forensic Psychology.
And the truth is, based on your training and your expertise, you can't even tell this jury if the defendant's interview was a Reed interview, can you?
Bits and pieces of Reed techniques were used.
But it's not a Reed interview.
But the techniques were used.
But again, it's not a Reed interview.
Well, if you use if it's a duck, it's a duck, right? If it walks like a duck, it's a duck. The techniques were used in that interview from Reed.
So based on your limited knowledge of what you believe Reed is, you're saying that's a Reed interview.
I didn't say that. I said the techniques of Reed were used.
So there's a couple of questions that may incorporate Reed, is what you're saying?
No, I'm saying Reed techniques were used extensively.
Extensively?
Yes.
Okay. Now, when you interviewed Ryan and gave him this personality evaluation, he was already in jail, right?
That's correct.
And in fact, he'd already been in jail for about 2 years, right?
He'd been in jail a while. I didn't nail it down to 2 years.
Well, what's the date in which you interviewed him?
I don't have it in my mind. I can find it.
Would looking at your report help with that?
Yes, it would. So I saw him February 28th, 2019.
Okay. So this jury's already heard he was arrested on February 22nd, 2017. It's a little over 2 years, right?
Yes.
You would agree with me that most people who've been sitting in jail for 2 years are probably pretty depressed.
By the time I see somebody, there's a cause for them because I'm a mental health expert, but I don't know the statistics about how many people sitting in jail for 2 years are depressed or not.
Wouldn't you be depressed if you were in jail for 2 years? I'll move on. You would agree with me that most people who've been sitting in jail for 2 years awaiting a murder trial would probably be pretty anxious about that.
There'd be a lot going on emotionally, yes.
And that would include causing this general anxiety that you're talking about.
It could include general anxiety, yes.
And now, I've not heard it, so you correct me, but you haven't actually diagnosed him with any specific anxiety disorders, correct?
That's correct.
So you did you personally diagnose him with any disorders?
I did not diagnose.
Okay. And why did you not diagnose him with any disorders?
Because it wasn't my job to diagnose him. I wasn't there to diagnose him.
And in fact, you didn't even do all the testing that would be required to diagnose him with a general anxiety disorder, did you?
Many times a clinical interview is sufficient, and especially the case history I did. So a diagnosis could have been created based on the history and on the clinical interview.
So did you just not get paid to do an evaluation, or a diagnosis on him?
That wasn't the purpose to generate a diagnosis.
So I'm taking that as a yes. You didn't get paid to do a diagnosis of him.
So the implication of that's incorrect about what happened. So I didn't go in with the intention to create a diagnosis. Whether I got paid a lot or a little wouldn't have changed whether I went in for a diagnostic assessment.
And that's because defense counsel didn't ask you to do a diagnosis, right?
I don't think we talked about creating or not creating a diagnosis.
But are you telling the jury that you have the training and the ability with your degrees and your certification to diagnose people with mental health disorders?
That's correct.
But you weren't asked to do it in this case.
I did not do that.
Okay. And you were acting at the behest, you've already told us, of Miss Merchant. She's the one that called you, right?
Yes.
I mean, to be clear, the state didn't get to give you any questions to be able to ask him, right?
You didn't give me a call.
So the answer is no. We didn't get a chance. You'd already been hired by then, right?
Right.
And you would agree with me then that everything that you're talking about with this anxiety disorder is based on self-report. Is that right?
Give me a second. First, you said anxiety disorder. And so let me step away from that because that implies diagnosis.
Well, you've referred to it as mental health. That was the
Right.
mental illness. That was the question that was asked when you talked about anxiety. So that would be a disorder, correct? I mean, people who are anxious don't get diagnosed with as having a mental illness.
Day in and day out, anxiety is not a mental illness.
Okay. So again, you're now saying he actually doesn't. You don't know if he has an anxiety disorder.
I believe his history is replete with anxiety disorder, agoraphobic symptoms, depression, suicide attempts, psychiatric hospitalization, lots of psychiatric medications.
And that's all self-reported, correct?
That's self-reported and is corroborated in the testing.
In the testing?
Testing.
Okay. Again, though, you never actually reviewed any medical history to corroborate what he was telling you about what mental health medications he was allegedly prescribed.
That's right. So I did not see the prescription history. I did not see the psychiatric records. I did not see a psychiatric hospital record. I did not.
So sitting here today, but for what Ryan Duke told you, You have no reason to tell this jury he's ever been diagnosed with even a general anxiety disorder.
Correct.
And to be clear, these things that you talked about, extrovert versus introvert, that's not a mental health illness, correct?
So no, those are not mental health illnesses.
I mean, someone can be an introvert and function just perfectly fine, correct?
Right. So you keep going further, and it does become perhaps mental illness, agoraphobia, and things like that. So on the extremes, there can be mental illness, but those categories themselves are not mental illness categories.
And now you keep referencing agoraphobia. You actually heard the defendant self-diagnose himself with agoraphobia in his confession, right?
So I have, we talked about his history of symptoms.
No, sir. I'm talking about in his confession that you said you've watched and listened to. He had already self-diagnosed himself back in 2017 with agoraphobia, hadn't he?
I don't know that he self-diagnosed himself.
Well, do you not remember that part where he tells the officer, I think I'm a little agoraphobic?
Well, yeah, okay.
So that is there, correct?
He had social introversion is what he talks about and not going out.
No, sir. He specifically uses the word agoraphobia. Do you not remember that?
I do remember. He told me the word agoraphobia too.
And that's because he's an intelligent guy, isn't he?
So you're trying to imply because he used the word agoraphobia, it means he's unusually intelligent?
No, sir. I'm asking you. He actually is an intelligent person. When you speak to him, he comes off as an intelligent person, correct?
Objection, Judge. He didn't do an intellect test.
He's been tendered as an expert in the field of psychology.
And he didn't, it's outside of the scope of what he did. He didn't do an intellect test. He didn't test for that.
He doesn't have, I'm going to allow the question. He doesn't have an opinion. He doesn't have an opinion.
Do you have an opinion as to whether or not he's a pretty intelligent guy?
I can form one. So my interactions with him did not suggest to me that he had some sort of low IQ or had a impaired intellectual functioning.
And now at the time that you met with him in 2019, can you tell the jury what mental health medications he was taking?
You mean?
Objection, Judge. It's outside the scope of what he's been asked to do. And she specifically asked him if he prescribed any medication, and he said he didn't. So he's already covered that.
I didn't ask about him. I asked what he was. He said he got a full history from the defendant about his mental health history. They talked about in 2019 during the interview certainly whether or not he was taking medications would be relevant, especially since there were questions asked about whether or not he had taken his medication the day of the interview.
Let me look at my report.
Sure, take your time.
So if you can refresh the question for me, please, ma'am.
Yes. In 2019, when you interviewed him at the jail in Irwin County, what medications, mental health medications, was he taking?
I have a strong history of the lead up to the arrest and the substances he reported then. I don't see the medications on the day I saw him.
So to your knowledge, you don't have any information that he was taking mental health medications on the day you saw him, correct?
Right, that's right.
Okay. But he was perfectly cognizant at that time, correct?
When you say perfectly he was alert, he was oriented, he could speak.
He understood your questions.
He understood questions.
And you felt comfortable going forward with this psychological examination, even though you don't know whether he was on these mental health meds he's supposed to take, right?
So I did feel comfortable going ahead with the evaluation.
And maybe I'm missing it, but at any point in your report, did you indicate that you felt like the interview was compromised or the assessment was compromised in any way by his failure to be medicated?
My interview, no.
Okay. Now, let's talk about that. You made a very general statement earlier about it was your understanding that he was under the influence of medication at the time he was interviewed by the police, correct?
Correct.
Now, to be clear, you've listened to the interview where he says he took one pain pill earlier that morning, right?
Correct.
He told you something totally different, didn't he?
He told me that and other things, yes.
And your opinions in this case are based on what he told you in addition to what you observed in that interview.
Yes.
And your interview with him is not recorded audio or video for us to play for the jury, right?
That's correct.
Defendant told you that at the time he was interviewed by law enforcement that he had taken one Percocet that morning, correct?
Correct.
He also told you that he had taken one Vicodin, took one, maybe two pills.
Correct.
For anxiety, is that right?
Correct.
Now, you would agree with me, even though you don't prescribe medications, you're familiar with what these drugs are used for.
Yes.
And Vicodin is, in fact, a pain pill, not an anxiety medication, correct?
Correct.
And the reason that somebody might take Vicodin for anxiety would be because it's going to make them sleepy and they might not be anxious anymore.
It'll kind of take care of that anxiety.
And Percocet's the same thing, right? It's going to make somebody sleepy.
Yes.
Morphine. He took one morphine pill, a little purple pill, right?
That's what he said.
Again, morphine is a central nervous system suppressant, is that right?
Yes.
And so again, suppressant, that means it's going to make them sleepy.
Yes.
So now we've got at least one Percocet, 1 to 2 Vicodin, and morphine on top of that is what he told you he took that morning before the interview.
And smoked half a joint.
And smoked half a joint. He also told you he took Valium, or what we refer to as diazepam, correct?
Yes.
And that is an anti-anxiety medication, correct?
Yes.
So he said that he took, make sure I get it right, he normally had a prescription, probably took 2, usually took one in the mornings, but he'd been up all night and likely took 2. Is that right?
Yes.
And then he said that he smoked half a joint because his nerves were shot out. Is that right?
That's right.
Now, you would agree with me that someone taking all of these medications within, let's say, a 12-hour time period, they're going to interact with each other, right?
Yes.
One makes you sleepy. If you take 2, you're going to be real sleepy.
Correct.
If you take a third one, you're going to be even more sleepy. That's how it's going to work. You're going to keep getting suppressed, correct?
Correct.
And each and every one of these, other than the diazepam, is in fact a central nervous system suppressant.
Yes.
Correct? And the diazepam, what is that?
Valium.
Valium. But what kind of drug is it? What class of drug is it?
Anti-anxiety.
Okay. And that is a benzodiazepine?
Yes.
Sure about that?
I believe so.
You didn't seem real sure about it.
I had to look in my head.
Okay. And again, that's because you don't really prescribe these drugs
I do not prescribe these.
Okay.
Not a lot, not at all.
Tell the jury what a benzodiazepine does to your body.
Calms you down as a depressant, smooths things out.
Okay. So again, that is also a central nervous system suppressant.
Right.
Okay. You only met with the defendant for 2 hours that day, correct?
Correct.
That's what you told the jury. Okay. And you would agree with me that law enforcement interacted with him for at least 3 hours based on the videos and audios.
Quite a long time, yes.
And you would agree with me that while a video can be great, it's a two-dimensional way to project a three-dimensional world, correct?
Yes.
So there are things that happen in a room that you just can't see in a two-dimensional video.
Correct.
For instance, the example, if I'm swaying back and forth this way and the video is straight on, you probably can't tell if I'm swaying, right?
I understand your metaphor.
Okay. So again, the whole point is The best and highest evidence about what the defendant was doing that day would actually be the observations of those officers, wouldn't it?
I don't know that I would agree with that because there are good reasons to video record what happens.
Well, I don't disagree, and they
Okay.
did that. But my point is, they can observe things that a video can't show us, can't they?
People can see things or hear things that a video doesn't see or hear.
The medications that the defendant told you he took that day, Percocet, we've already talked about. That's going to suppress your central nervous system. That can cause you to slur your speech, right?
Could.
Can cause you to be unsteady on your feet.
Could.
Same thing for Vicodin. That can cause you to slur your speech.
Correct.
Can cause you to not understand what's going on around you.
Correct.
Can cause you to be unsteady on your feet.
Absolutely.
And with each drug you add on top of that, it's going to exacerbate the results of that, correct?
Except for one thing.
Except for one thing. What's that?
Tolerance.
Tolerance.
So addicts, as you know, build tolerance. All these medications, the more you take, the longer you take it, your body builds tolerance. And so if a person with no history of taking drugs or substances took all those drugs, they'd be flat out.
I mean, they'd be dead.
I don't know about dead, but they'd be in trouble. But if a person is used to taking their body, those kinds of medications on an ongoing basis, they will develop tolerance. The body will be able to tolerate more and more and more of the drug. And that's why addicts take more and more, because one pill that used to do something, well, the body got used to it. Now you got to take 2 to do the same thing. Well, then the body gets used to it, so now you got to take 3 or 4 to do the same thing. And so my only point being, and I agree with your implication, that's a lot of medications.
Yes,
if
sir.
he really took those, that's a lot of
Did
stuff.
I just hear you say if he really took those?
If he really took those.
Okay.
And that was the gist of where you're going. If he really took those, that would be an awful lot to take. With addiction, addicts can take an awful lot of medications, and because of tolerance, it doesn't have all of those effects.
Well, let's talk about that then. Because
Okay.
what tolerance actually does is it takes more to get that high or to get the result they want, correct?
Yes.
It doesn't actually stop the physical manifestations that are caused by the drugs though, right?
That's not right.
Right?
So the dopamine receptors and all that kind of,
Yes,
and
sir.
we're not going to get too far, but you know.
Well, we'll see. Go ahead. I'm listening.
So your question is, does it change the physiological reactions?
Yes, sir.
And the answer is tolerance. The physiological reactions is what tolerance is. It's not just the psychological reaction. It is physiological.
Okay. You heard the defendant in his confession talk about his drugs of choice, correct?
I believe so.
When's the last time you watched this confession?
It was years ago, a couple years ago.
So you're testifying about a confession you haven't even watched in years.
That's right.
Okay. So you probably don't remember this, but I'm going to ask you anyway. Do you remember him talking about that alcohol and cocaine were his drugs of choice?
Yes.
Alcohol is a central nervous system suppressant, correct?
Correct.
Cocaine, however, is the exact opposite.
Correct.
And so if cocaine were his drug of choice to get him high, that's what you just talked about. The tolerance would not affect a central nervous system suppressant on the body. He's not going to have tolerance for a downer when he's been taking uppers.
Let me make sure I've got your question.
Sure.
If a person is codependent on 2 different drugs.
Now I'm talking about cocaine only right now.
Okay, well then let me hear the question again.
Sure.
Okay.
Based on the fact that he was addicted to cocaine, that was what he referred to as his drug of choice. A tolerance to cocaine does not equal a tolerance to these sorts of pain medications that he's claimed to be on.
Judge, I would object. That's not evidence. There's no evidence he ever said he was addicted to cocaine.
Yes, actually, Judge, he specifically refers to it as his drug of choice and then goes on and says that meth can do it in a pinch.
Yeah, I'm going to overrule that objection. The jury will remember the video. That's up to the jury.
Okay. So I think if I follow your question, you're asking me if a person has cocaine is a drug of choice.
Yes, sir.
And they do a lot of cocaine frequently.
Yes, sir.
Does that build tolerance for barbiturates?
Correct.
That's your question?
Yes.
And the answer is no.
Perfect.
Also, you heard in that interview that he refers to that being a time when he used drugs regularly, correct?
Yes.
In fact, during his interview with this agent, he indicated he was no longer a drug addict, correct?
Yes.
He even talks about the fact that he doesn't drink anymore because he says all of his teeth fell out after he stopped drinking, right?
I remember the teeth. I don't remember the exact sequence.
Fine. You would agree with me, though, that if someone says that their teeth fell out after they stopped drinking, that would imply they're no longer drinking, correct?
Yes.
Same thing. If someone is no longer drinking on a regular basis, they're not going to have the same kind of tolerance you talked about a second ago, correct?
Right. So if a person quits drinking alcohol, their tolerance for alcohol goes down.
You're familiar, based on his self-report, that his mental health issues predate the murder of Tara Grinstead, correct?
Yes.
In fact, he had mental health issues as early as high school.
They stretch way back. Yes.
He reports being depressed prior to high school.
Yes.
Or prior to graduating. He reports having suicidal ideations prior to graduating from high school.
Yes.
And you would agree with me that in addition to these things affecting an interview, they may also affect life choices, correct?
Yes.
And if you add the kinds of drugs we've been talking about, specifically alcohol and cocaine, onto someone who already has anxiety and depression issues, it's going to affect their behavior.
Very well. Yes.
It's going to affect their life decisions.
Sure.
And it may even cause them to act in ways that they would not normally have done had they not been high and drunk.
That's true for everybody.
But it's even more exacerbated with people who have mental health issues, correct?
Yes. So if you add together mental health issues with addiction, it's a really devastating for some people combination.
And I think this is my last line of questioning. You talked about the defendant. It's not my last line of questioning. I want to ask you about this first. You referenced the defendant as being sleep deprived. That's, again, based on his own self-reporting, correct?
That's correct.
And that's what he self-reported to you during the interview you had with him.
Correct.
You also heard him, however, in the interview that he did with law enforcement say he never sleeps well, correct?
Correct.
He says something to the effect that it's a good night if he gets 4 hours of sleep.
Yes.
So the idea of him being sleep deprived is actually his normal state of existence based on his self-reporting.
So there's what's called chronic fatigue. So some people with sleep disorders, they have chronic sleep deprivation. And so the pattern you described would be consistent with chronic sleep deprivation. What he told me was more than,
you can say it with me. You just couldn't say it with her.
Okay, I'm sorry. Thank you.
Self-serving when
Thank
she
you for
asked.
letting me know what the rules are.
So what did he tell you about?
He told me he
his
hardly
sleep?
slept at all that night before the interview.
But again, he also said that he never really sleeps well.
Right. So it's.
And 4 hours is a good night, is what he said.
That's what he said.
And then lastly, you talked about that this agreeability factor on the personality exam you gave him, correct?
Yes.
No, before I go into that, you said there were 5 portions of that?
Yes.
What were the other 2 we haven't heard?
So I think, let's see, we did neuroticism. We did
He's anxious.
extroversion.
He's an introvert.
We didn't do openness.
Openness.
Openness. I'll go to would you like me to talk about openness?
Please. What is openness?
Judge, this is, the reason we didn't go into that was your prior ruling, so this is,
I just asked him what openness was. I didn't ask anything about this defendant.
All right.
I think he needs to know that he can answer accurately, though.
I'm asking very generally what openness is
Okay,
generally.
sure. You want me to explain that scale?
Yes, sir.
Okay. So on the NEO 5-factor personality inventory, one of the scales, one of the 5 factors is openness, and it refers to openness to new experience. On a continuum, some people score very low or on the lower end, and these are people who really like things that are tried and true. I mean, if it's the way it's been done and it works, gosh, let's stick with this. On the other end of openness is open to new experience. These are people, man, if it's new, it's right. New and improved, that's what they're after. And so on a continuum, if you push it to the extreme, some people are very interested in anything new information. They get really fatigued or bored with stuff that's just routine and the same. And there's some people at the other end that are really comfortable with routine, things being, you can predict how things are going to go. It's tried and true. It's always worked, so we're going to stick with it. There's no reason to change it. And everything kind of in between is that scale.
Okay. And looking at what you reported of him on that 5 scale, you said that he subjectively reported that he tries new things, new foods, and likes movies, but he's somewhat set in his ways, right? That's specifically what the defendant told you?
Yes.
Okay. And then the last one is conscientiousness, is that correct?
Yes.
And that relates to an adequate level of organization and balance with flexibility, is that correct?
Yes.
And again, looking at what he reported to you subjectively, he reported that he's more of a goal-oriented person, but he's not been this way for 15 years or so.
Yes.
Now, you talked about some of the medical issues that you claimed that you talked about him having. He had actually stopped receiving dialysis at least a year before his arrest in this case, correct?
He had stopped receiving dialysis.
And it wasn't because he just stopped going, it's because he didn't need it anymore?
That's my understanding.
So back to this agreeability. You talked about that people who score high on agreeability are persons who are sort of just go along to get along, I think was your statement, correct?
Something along those lines, yes.
So when you're doing an assessment as it relates to agreeability, you would agree with me that people who are willing to contradict what you say indicates that they, in fact, are able to stand up for themselves.
That shows some spine, yes.
Okay. And in fact, in this interview, Ryan Duke corrected Jason Shadell on more than one occasion when he disagreed with what Agent Shadell said.
There are some exchanges that come to my mind that don't necessarily fit the pattern you're
Okay. But I'm talking about
suggesting.
he does do it, though, at least more than once, correct?
There's at least one issue where he does say no and say no again and then finally says yes.
Okay. Again, I know you're focusing on what they asked you to focus on. My question is, there are times... I'm not testifying, Judge. I'm clarifying the question.
On what they
You would agree with me that there are times where he contradicts Jason Shadell and sticks to his contradiction.
I can't in my mind find what you're referencing.
What about a time, do you recall a time where Jason Shadell actually says, he slips up and says, so y'all go back to her house. And Ryan corrects him and says, no, it was only me. Bo never went to her house. You remember that?
I do.
And that is an example of someone who is willing to correct a person of authority, correct?
Let me try to put that in context. He did do that.
He did correct him, correct?
And
he is in a position of authority, right?
And it's my understanding he did that in ways that he presented information that was not necessarily factually accurate.
Okay. That's based on what you've been told, correct? I mean, you weren't there when Tara Grinstead was murdered, right?
That's correct.
And everything you know about this case is what was supplied to you by the defense in this case, correct?
And the information I generated in my assessment.
That came from what the defense gave you.
And it's the case file,
Well, did they give you 10,000 pages worth of case file? Because that's what it is.
not 10,000.
So they gave you based it on what they gave you to base
I
it
did.
on. Okay. And again, you agree with me. Jason Shadell was a person of authority in that setting.
Yes, he was.
And he corrected Jason Shadell at least one time now that we can agree with, that when Jason Shadell said, y'all went back, he said, no, I went alone.
Yes.
That is someone who is willing to contradict a person of authority.
That is inconsistent with the general pattern of exchanges that I saw throughout the interview.
But you would agree with me it does happen more than once, now that I've reminded you.
He says things that are disputed a number of times.
Again, he corrects Jason Shadell a number of times.
I see him acquiescing with the agent a number of times.
So when he says, no, I went alone, you're considering that acquiescing?
No,
That's him correcting Jason Shadell, right?
he has an interaction with him and says no, he went alone.
And that's just the one time I've reminded you of. You don't really remember the other times?
I really don't. I remember a number of times where it went the other way.
No further questions.
All right, Ms. Merchant, any redirect?
Yes, Judge, but we might want to talk about it before, outside the presence of the jury.
Okay. Let's go ahead and take a break, ladies and gentlemen. Anybody want to step outside for some fresh air, please accompany the bailiffs. Otherwise, if you'll just step in the jury room, we'll be right with you. All right, you can step down, Dr. Talinsky, for a few minutes. I'll hear from you, Ms. Merchant.
Our ruling on false confession was, you said specifically, unless the state opened the door, and their cross-examination opened it wide open.
Why would I say, I don't remember saying that, but how could they
Then we
open?
were able, if they questioned him, it's in your written order, and you also said it when we talked about Dr.
Okay,
Talinsky.
okay, well, good. I don't have the order in front of me.
The order was regarding Dr. Cutler. We had a pretrial hearing about Dr. Talinsky because the state had represented at the motions hearing that they hadn't received a report, and they had received one in regards to Dr. Talinsky. So the written order actually pertained to Dr. Cutler. But then in pretrial, you said that if the state opened the door to false confession, things like that. And while we don't necessarily need to put in evidence of false confession theory, the questions that they asked him, for him to be able to respond and for me to be able to rehabilitate him, goes into his interpretation of how the psychological factors that are present in a false confession. And I can be more specific, Judge. It might aid. So some of the things that we wanted to question him about specifically was how the interrogation techniques, his mental illness made him vulnerable to taint influences during the interview, his personality traits. I know we went a little bit about the personality traits, his agreeableness, but go into a little bit more detail about how that led to him saying something that might not necessarily have been accurate. Same thing with interrogation tactics and how those interrogation tactics.
Well, how has the door to interrogation tactics been opened?
The state asked about the read technique. They asked what it was and if he saw it in this instance, and the doctor testified that there were elements of the Reed technique throughout, and I believe that we should be able to follow up on that and ask what those elements were, and what techniques he saw in Ryan's specific statement. And then based on Ryan's personality traits, how did that affect him in the interview? And I just want to make sure that
I mean, I don't see anything wrong with asking him about the Reed technique.
I don't disagree with that, Judge, but he said read first, not me. I didn't say read until it was brought up, and so then I did follow up on it.
Yeah.
And whatever knowledge he has as it relates to specific knowledge of read, that's one thing. But all of these other, interrogation things that she's talking about, I don't believe we opened.
I think the Reed technique, he said he had some knowledge of it, not had any specific training was my recollection, but I think you can ask him about that if you want to. But that doesn't have anything to do with false confessions. It's my understanding, that technique.
And it does, and that's what
Well, tell me what it does. How does that open the door to anything about false confessions?
So there's two different avenues of theory with Reed technique and false confessions. There's the police interrogation practices, which is what the state questioned him on. Do you know about the police interrogation? Are you trained in police interrogation? All that.
And his answer is no.
And then there's the psychological aspect of it, though, and how
Psychological aspect of what?
of the Reed technique.
Okay.
Of the coercive police practices, of interrogation practices, how that affects a person psychologically, how psychological factors and personality traits play into, like if a person has those traits and then the Reed technique is used against them, how does that affect them? How does it render an unreliable result? So they were able to just ask if he knew about the police interrogation aspects of it. Well, he's not an expert in police interrogations, but he is an expert in false confessions.
But that's not admissible.
It is when they open the door, Judge, and they've opened the door wide. They asked him about that
They
stuff.
didn't ask him whether his statement was true or false.
And I don't intend on asking him that. But
I just don't see it, Ms. Merkin. I'm sorry.
I don't intend on asking him if his statement was true or false. But what I did want to ask him about is the techniques that they asked him about and how those played into Ryan's interview. And I think that that's fair game.
The techniques that they asked him about.
Yes, they asked him about the Reed technique, for example. And he said he doesn't know about police interrogations, but he does know about how the Reed technique plays into forensic psychology. That avenue of research, the forensic psychology avenue. And they were able to ask him those questions. We should be able to follow up on it.
Well, how were their questions related to the psychological aspects of what you want to go into now? I don't see how. I mean, I don't get. Help me understand, please. How the psychological thing. She asked him. My recollection is, he brought up the Reed techniques that he knows that it had.
Right.
What aspects of the Reed technique?
Would it be helpful to have the doctor give a proffer as to what he would testify to in regards to that? Because I'm not an expert and I'm not properly explaining it very well. But I want to follow up on the questions that they asked in regards to the Reed technique, and
That'd
he
be
can
fine.
proffer.
That's a good. That's a fine idea. Where is
Okay,
it?
he's right there. He's there. He's
Hey,
right
y'all, you two guys. All right. Yeah, have a seat.
Okay, great. Thank you, Judge. So, and I thought I was okay to ask these questions, but I didn't want to do it in front of the jury and cause any issues. So I just wanted to make sure I was safe. So doctor, what are the Reed techniques that you saw used here?
So,
And Judge, I understand it's the proper, but I would ask that there be a foundation for how he knows what the Reed techniques are, because he and I obviously disagree on what we believe Reed techniques are based on his answers. So I would ask to start with that.
I can go into detail.
I think that's appropriate.
Okay, let's back up, and we're going to go through some of the false confession stuff then, just since the jury's not here. So, are you familiar with the relevant science on police-induced confessions?
I am.
And the psychology behind that?
Correct. Yes, I am.
And can you tell me some of those things that you reviewed in regards to that?
The defendant's left the courtroom. If he's not going to be here, we're going to need a waiver. I just want to make sure that that's on the record.
We'll waive it, not a problem.
Well, he says you waive. You want to waive.
I said we'll waive it. I'm sorry.
I'm sorry. I thought you said we'll wait on.
We'll waive it. Thank you,
Go
Judge.
ahead. Yeah.
He's read the report. So, can you tell me some of the things that you have reviewed in regards to the relevant science for false confessions?
So beyond the workshops that I've attended that have to do with the Reed technique and the potential psychological impact of techniques in the interview itself, I also reviewed the article, Insanity Defense, Evidence for Forensic Psychologists. I'm sorry, Your Honor, I apologize.
That's okay. I know we shifted gears a lot.
Shifting gears.
Sure. Hang on just a second, Dr. Tillis.
Yes.
While we're doing that, may I review what the doctor's looking at? All I have is this report.
If he testifies before the jury with it, let's see whether we're going to admit it or not. Go ahead. Then we'll do that. You can go ahead, Doc.
Take your time. You can review everything.
Let me get there.
And it's in his.
It's in the report.
It is in his report, just
Okay.
so the state knows. It's at the end of his report.
Hang on just a second, please.
Oh, sorry.
All right, thank you. Go ahead.
He has annotated references in the report that we provided to the state in March of 2019.
As to the periodical type stuff?
Yes, Judge. As to everything that he was going to rely on for his expert opinions in this area.
Okay, thank you.
So can you just walk us through what those are?
Absolutely. So one article that I reviewed in preparation for this is entitled Police-Induced Confessions, Risk Factors and Recommendations. This is published in the American Psychology Law Journal by the American Psychological Association. This has to do with factors, what is known about police-induced confessions. And another one is on the general acceptance of confessions research, opinions and of the scientific community. This is a survey about psychologists and what seems to be reliable and valid enough to be presented in court. So there 80% agreement on a number of effects that can influence those interviews.
Okay, and those effects, are those things like the psychological factors that we talked about?
Yes.
Okay, so those two papers.
When you say the psychological factors we talked about, you mean what he's already testified about?
Yes.
Yeah.
Yes. How those psychological factors are relevant to a police-induced confession.
And not even just confession, but the quality of that interview.
Okay.
So it's not only associated with confession itself.
Okay. And is there another?
Yes. On the psychology of confessions, was innocence, put innocence at risk, and this is regarding the Central Park jogger situation where all the teenagers confessed, and it just identifies different types of factors that tend to be associated with false confessions.
What about the American Psychological Association amicus briefs on false confessions?
Yes. So the American Psychological Association presents amicus briefs on a variety of different subjects, and one of the areas has been false confessions. The APA, American Psychological Association, has sponsored 9 briefs in different cases. I believe they're all appellate cases, but I'm not sure on that. But basically to present the psychological science, how that is relevant for understanding those cases.
Okay. And so that is different than police practices and interrogation training, though, correct? Somewhat.
It has to do with practices in interrogation. It has to do with the way interviews or interrogations are conducted and the impact on the respondent or the interviewee.
Okay. So, but it has to do with the psychological impact and psychological factors
right.
in the interview. Okay.
I'll go over that objections in this setting.
I was just trying to get to the point.
I get it.
So Judge, that in response to the state's objection, those are the items that he's reviewed in these factors, and then I just asked because I know the state objected about what was relevant.
Sure. All right. I'll hear from you. Believe anything about that?
It's his report that we gave you in March 2019.
Okay, but it's
5 minutes ago.
he actually have the reports in front of him. He's referencing, or he's just talking from the report?
You looking from your just from the report, or do you have these articles with you?
I do not have the articles.
Yeah,
okay. All right. Good.
And so, do you want me to continue with my proffer? I was asking him what
You were done
articles.
with your process.
I'm sorry?
You're not done with your process.
I'm not. They objected and asked what he was reviewing, or
Okay.
what he based his opinions on, and so I asked those questions,
Hang
so I
on
want to
a
move
second.
on and go back.
He has a lot more paper than just the report up there. So that's why I'm saying I want to see what he's looking at. I mean, the report's like maybe 5-6 pages long.
They're his notes. I mean,
This is the transcript. That's fine.
oh, the transcript. Yeah, we've given you that.
These are other notes that I have not. That's it.
Just, I do want a chance to ask him about these later, but
Go ahead, Ms. Murphy.
Thank you. So where we were before is what is the read technique?
I'm sorry.
That's okay.
I was looking-
Sorry, take your time and organize your things if you need
Yeah.
to.
What
is the read technique?
So the read technique is a technique for police interviewing. It uses a number of different techniques to help facilitate the interviewee speaking and often giving a confession.
Did you see some of the read technique used in Ryan's interview?
I did.
Okay. Can you tell us, based on Ryan's personality traits, how that affected his interview?
Go ahead.
Can you tell us how, based on Ryan's personality traits, how that affected him in the interview, the read technique?
Now, after clarification, can I say
free to
what
say
I
whatever-
say?
yes.
Can I say
You're free to
minimization?
respond
Can I
fully.
say confronting denial? Can I say those things?
You can say all of it.
Okay.
Right now you can't.
Right now I
We're not
can.
getting to
I got
when
you.
the jury's with
I
us.
got
Thank
you.
you.
We're practicing.
Right now you can.
We're laughing, but serious business. So in the interview, I saw a number of read techniques that I thought interacted with Mr. Duke's personality. So, for example, minimization, confronting denial, and it looked to me like with those techniques, in combination with his personality and the way he presented, that in those situations he acquiesced or moved closer and closer to the information the agent put on the table rather than what Mr. Duke put on the table.
Okay.
Well, he said, haven't you? I mean, he said that in his direct, didn't he? That those.
He said some of it?
Yes, yeah.
Yeah, see, we did go into some of it.
Go ahead, then. I didn't mean to.
No, that's quite all right. And can you tell us, based on the interview, what things you saw that could cause Ryan to be subject to those psychological pressures?
So can I go into the specific
Yes.
things? So minimization, things like the agent saying accidents happen, we're not making you out to be a monster, things happen, you've been hard on yourself, you're helping people. Those kinds of comments are part of minimization and is associated with sometimes people acquiescing in that interview to what the agent has in mind.
Okay. And what about interrogation tactics?
So, can I talk about guilt presumptive?
You can.
So it turns out that denials sometimes trigger confrontation, and so should I be specific in this case? For example, when the officer asked if he took anything from the house, he said no. And then there were more and more questions, and he ends up saying, well, he must have or probably grabbed her purse and that sort of thing. And so there were denials, but then there was an eventual acquiescence to what the officer put on the table. The issue of, for example, being surprised in the house and Miss Grinstead surprising him, and he hit her with one blow and killed her. the officer said he wasn't a Hulk and seemed to dispute that and offer issues like choking or strangulation. And I've got to be careful where that came from. Right. And so it seemed that he...
I informed him he couldn't say anything that Bo said.
I'm sorry?
I had informed him that he couldn't testify as to anything Bo had said. So that's why he said that.
But I can say strangulation,
Yes.
even though it came...
Yes.
Okay. And so in that way, confronting his initial statement moved him, he seemed to move in response to the agent towards what the agent was talking about.
And what about denials triggering confrontation? Can you tell us a little bit more about those factors?
Yes. And so when Mr. Duke said some things that seemed to be inconsistent with common sense or evidence, such as denying that he took anything, there were more and more questions, more confrontational questions. When he talked about the one-blow murder that the agent found very unlikely, he softened and moved towards some other, maybe more likely possibilities. And can I bring up the glove?
Yes.
The agent brought up the issue of the glove, and so Mr. Duke affirmed that there was a glove, and then when he asked about it, said he probably didn't put it on or use it or anything like that. And so the officer then, not Duke, but the officer brings up, well, did you bring it to hide evidence or to prevent being discovered? And he...
Did you bring it what? I couldn't hear you.
I don't have the quote. To prevent evidence. He didn't use the word evidence, but to prevent evidence from being discovered. And he...
Is that why you brought the glove?
Is that why you brought it?
Right.
And he basically says, could have been yes. And so again, moving more towards affirming information that Mr. Duke didn't bring up or say, but that the agent brought up.
Okay. And Judge, those are the things. What I had instructed him previously was so that we could only go into generals, that he wasn't allowed to testify about specifics about Ryan's statement, but based on the state's cross-examination, I think it's appropriate that I can ask him those specifics.
Thank you, Ms. Hart. Ms. Hart, I'll hear from you.
Ma'am, would I ask a question? You've never taken any read technique classes, correct? I mean, classes that teach you how to do a read interview.
No.
And you talked about going to a seminar. When did you attend that seminar?
I should be able to tell you with precision, but I can't off the top of my head. October 2016.
Of when?
October of 2016.
Okay. And that particular seminar, the entire thing was dedicated to read techniques?
No.
How
I thought we were dealing with whether or not we should be going with the proper, or whether or not we can ask the questions, not disqualifications on read technique. That's a great issue.
They go hand in hand, Judge.
Well, I don't think, listen, he's not qualified on the read technique. Whatever he's read about that, I mean, he said he's not, or learned about that. I think maybe in connection, like Ms. Merchant said. Here's the deal. As I understand, Ms. Merchant, you're taking the position that the state has somehow opened the door that somehow authorizes his opinion that this is a false confession. I don't think it gets near that, okay? That's just not past the reliability test. She didn't ask him if it was true or false or anything. So as far as some of the questions you were just asking him, I got no problem with. As far as it relates to what he observed about this guy. Now, comparing the read techniques to those things, we just have to take it one question at a time, and I'll rule on them as they come up. That's all I can do.
That's
But,
fine.
but there's nothing about the cross that I believe has opened the door to a topic that the Supreme Court of Georgia says is not reliable enough to be introduced. I mean,
So-
I don't think that's even close. Go
Sorry.
ahead.
Judge just specifically said that we don't get the jury back out and have to leave again. My objection to some of this is the words he's using, minimization and guilt presumption, and I don't remember what the last one was. Those are specifically things that relate to allegations that they're saying, claiming the Reed technique causes, or they're things that the Reed technique may employ. That's why I'm objecting to the use of that, because that's not something that he commonly uses in his world of psychology. So that's why I'm objecting to those specifically, because I did not, in fact, my entire cross of him related to Reed is the fact that I don't think he knows what Reed actually is. And so to be able to allow him to talk about minimization and presumptive guilt and those sorts of things without a foundation that he actually knows Reed is what I'm objecting to as well. Obviously, I agree with the court. I don't think I opened the door to false confessions, but I still do not believe he's qualified to discuss even the idea of minimization. I know as much about minimization as he does, and I don't think I'm an expert in it. So.
Well, are those otherwise psychological terms? Is what I understood Ms. Merchant to say. Those terms, minimization.
As it relates, I mean, minimization is a word generally, but as he's using it in this context, and you can ask him, but as he's using it in this context, which is to minimize what someone actually did, or to minimize their involvement, or to minimize the results of their involvement, is related specifically to interviews and interrogations, Judge.
I mean, people do that every day, don't they?
Well, I agree with you, but as he's using it as it relates to the interview technique is the part that I'm objecting to.
Right. You undertake your cross-examination or your redirect. You object when you believe it's over the line, and that's the way we'll handle it.
May I ask a couple of questions, and then I don't care if it's on the record or not, about some things he has up here that I...
Do you want?
Okay.
I just want to know where this came from. Did you produce that yourself?
I did.
Okay. And when did you produce that?
Yesterday.
I just want to cross-examine on that later.
Okay. All right. You need a break, Ms. Merchant?
Hi, guys.
So does this lady. All right, take 5 minutes. Back.
All right, ask the jury to join us, please. Ms. Watkins. Thank you for bringing that up, Ms. Merchant. Outside the jury's presence. Okay, Ms. Merchant, you're up for redirect. Thank you.
Dr. Tolitsky, the state asked you when you had last seen Ryan's interview, and you testified that it was 2 years ago.
Right.
Did you take notes on that interview?
I did take notes, and I also reviewed a transcript of that interview.
And so, did you feel the need to rewatch that interview before you came here to testify?
I didn't.
Great. And you testified, the state asked you about Ryan having an actual diagnosis. Is it common in your field that people are diagnosed and then come to you for other types of treatment?
Yes, and it's also common in certain kinds of forensic evaluations not to provide a diagnosis. That's not the purpose of it.
Okay. And I know the state asked you a little bit about the difference between psychiatry and psychology. So can you just tell the jury a little bit about that since they brought that up?
Sure. So a psychiatrist is a medical doctor. Typically they prescribe medications and do other things, but they are a physician who specializes in psychiatry. Psychology is a doctoral level profession, so I'm a psychologist, which means I have doctoral level training, but I'm not an MD, I'm not a doctor in that respect.
Is one more likely to do testing than the other?
Sure. So although psychiatrists do certain kinds of testing, psychologists are it's one of the main things psychologists do, and it's one of the key aspects of the profession.
Okay. And do you often work hand in hand with psychiatrists?
Yes.
In this case, do you believe that there were certain techniques used in the interrogation of Ryan that affected him?
Yes.
Can you tell us what techniques you believe affected him?
Sure. So one of the techniques that appeared to me to be in the interview was minimization.
Again, I'm going to object to his talking about a technique related to interview techniques. There's
You'll just lay a foundation as it relates to the psychological aspect you're talking about.
Sure, Judge. Are there psychological effects that certain interview techniques have on a suspect?
Yes.
Okay. And are you trained in reviewing those techniques, and do you have the ability to comment on those techniques and how that would affect someone who you've evaluated?
Yes.
Okay. In this case, what techniques did you see come about?
Yes. So one of the techniques that I believe I saw being used was minimization. So it's one of the things that is frequently done in certain interviews when there's a terrible allegation such as here is to minimize the emotional impact on that. And the idea there is to help that person speak about it. And so I did see what I thought was minimization, things like comments, accidents happen. We're not here to make you out to be a monster. You've been hard on yourself. Be empathic. You've been helping people. Those kinds of comments are part and parcel to minimization.
What effects can minimization have on Ryan's interview?
So in this particular case, with this guy, with this man, with agreeableness, it could be one of the issues or techniques in combination with that way of being, that psychology, to acquiesce, to agree with things that the agent might say.
Okay. Were there any other things or techniques that you saw in your interview of Ryan?
Yes.
Okay, tell us about those.
So another technique that I saw was confronting him. So sometimes denials, when an interviewee denies something or says something that might not make good sense, either from a practical perspective or based on other known facts, sometimes they're confronted. And I believe that happened here on a number of occasions. And in combination with Ryan's psychological makeup, could very well have induced him to move along on that continuum and more agree with what the agent had to say.
Okay. Just one moment, Judge. Do you have any examples of minimization in this case?
The minimization were things like accidents happen, we're not here to make you out to be a monster, things happen in life, you've been hard on yourself, you're helping people.
Okay. And do you have any examples of the confrontation denial that you talked about?
Yes, yeah. So one, and I'll just start chronologically from the beginning, was about how'd you get here? The question was generally, how did you get here? And Mr. Duke basically says, I don't know, I don't remember. And so then information was presented that I don't know wasn't really accepted in the sense of, well, how about a truck? And so in the course of time, the truck that the agent put on the table, not that Mr. Duke put on the table, was seemed to be adopted. For example, what happened in the house, and Mr. Duke says he was startled, and with one punch he hit her, Miss Grinstead, and killed her. And the officer or agent confronted that at various points, saying you really weren't a Hulk, that could happen, but really just not very likely, and offered other kinds of possibilities. And and Mr. Duke started shifting towards what the officer or agent was saying. Another one was about a straightforward question, did you take anything from the house or something close to that? And he says no. And the officer narrows it down. What about, did you take her purse and keys, that kind of stuff? And he says no. And then more information is presented, and Mr. Duke says, well, maybe I did. Maybe when I ran out, I took these things. And so again, we get a shifting, a moving of the narrative towards what the agent is talking about, rather than what Mr. Duke himself brings up or explains. Another one was certainly the glove. So the issue of the glove, Mr. Duke did not bring that up himself, and the agent asked about it, and he said, sure, that he has gloves, and it was his glove. But then Mr. Duke said, but he didn't really use the glove, and so then the officer at some point makes what's called, in terms of questioning, a leading and suggestive statement. Well, did you use it so that you wouldn't leave anything behind, or along those ways? And he moves in that direction, just says yes to it. And so those are specific examples how denials or information can be presented and then confronted, or not believed, or not left on the table, and other information presented. And I think that Mr. Duke's emotional and psychological status, he swung towards what the agent was saying.
Okay. You said leading and suggestive questions. Is Ryan particularly susceptible to leading and suggestive questioning?
I believe, based on his personality, yes.
Okay. And I think I said it wrong. It's denials trigger confrontation. So because I think I said it the wrong way, that means that if someone denies something, then they're confronted. Can you explain that?
Yeah. So, for example, when everybody goes into an interview, when I interview somebody, I have some idea of what the issues are, what's going on. And so if a person, an interviewer, brings that out and the person denies, says no, that isn't it, that isn't the way it went, or something like that. Confronting that can have it can have favorable or unfavorable effects. And so the unfavorable effects are that a person might just acquiesce just because of the pressure of getting confronted, either with information. Now in this interview, it wasn't emotional confrontation. It wasn't a white light and harsh statements, but it was information that was confronted. It was statements that were confronted and pressed, which creates a situation that can be emotionally difficult for an interviewee.
Is that of particular relevance with a person like Ryan who hates confrontation?
Of particular relevance.
I sustain that objection.
How is that
Please rephrase.
Yes, Judge. How is that particularly relevant to Ryan?
So some people are more resilient to that kind of pressure than others. It was my impression that Mr. Duke was more likely to acquiesce than just the average person.
Great, thank you. On direct, the state asked you, you said that you testify for the defense about 10% of the time. Who do you testify for the other 90%?
So the vast majority of my testimonies has been for the Department of Family and Children Services. I mean, hundreds. So,
and that's the state of Georgia?
That's the state of Georgia. So I've been doing that my whole career. That's juvenile court. And but in Superior Court, then there are testimonies. For example, last week, 2 weeks ago, about child custody. So that's Superior Court, and so it's court appointed. So my client was the court, and so there's a number of those kinds of cases and testimonies. Not infrequently, I am asked by a defender like you or a public defender to review a case, to do some testing, competency, or those kinds of things. And the vast majority of those assessments, though, do not result in testimony.
So when you said that you testify for the court, so can you explain to the jury whose witness you are in that instance?
Sure. So in that situation, the court, that is the judge, appoints somebody. In this particular case I'm talking about, and I've done this basically my whole career, the court will say in a child custody situation sometimes appoint somebody to assess everybody, a psychological assessment. And so it's not that one or the other parents or contestants is my client, and because the court is my client, so I'm testifying on behalf of the court. And so in that way, it's not for mom or dad or grandparent or that sort of thing.
Okay, thank you. And the last thing I want to talk to you about is the state asked you a lot of questions about your evaluation and Ryan being self-reporting.
Right.
Do you recall that? Is there any difference in the self-reporting for your investigation and self-reporting to the police? That's a self-reporting interview as well, though.
Right. So, is that all you're
No,
asking?
continue. Yes.
So, the kinds of questions that I use in that kind of interview are typically open questions and have a different emotional tone oftentimes than an investigative interview that might use harder confrontation. Now, it doesn't mean that I won't ask more specific questions or say, hey, I'm not quite sure that this makes good sense, but so the emotional tone, I believe, would be quite different.
Why do you find it important to use open-ended questions?
Yeah, so there's a lot of research about interviewing, the best techniques for interviewing, and when I say best techniques, I mean the best way to get valid and reliable information from the person that's across the table from you. And so in the field, there's a generally accepted sense of a hierarchy of questions, that is, a range of types of questions, ranging from very open questions to more specific, to more direct, to sometimes yes-no questions, to then more leading questions or suggestive questions where information is brought to the table. So it's a very different thing in terms of questions if you say to somebody, tell me everything that happened, versus, well, I understand that that you hit her. Now, how hard did you hit her? That'd be very leading and inappropriate kind of question.
So you were talking about being a witness for the court.
Right.
When you do that and you don't have a side, is it more important to be neutral and ask those open-ended questions? Can you talk to us about that?
So it's always important to be neutral. It's always important in an interview to ask open-ended questions. And by the way, if the court had appointed me, I'd have the same testimony.
Thank you. And in this case, or in your practice, when you testify at those hearings, it's over custody of children often, right?
Typically, yes.
Okay. And so when you go into those interviews, you want to get the most relevant and most accurate information?
Objection, leading.
What type
Please
of
rephrase.
I'll rephrase it. What type of information do you like to get when you go into those interviews?
So it's very important in a forensic interview, in a forensic evaluation, to get objective information. And the best way to get information that comes from the person, the episodic memory, and let me unpack that a little bit. So in an interview, it's ideal to have the person speak from what's called episodic memory. There's all kinds of different ways memory works, but episodic memory is the way memory works for stuff that we personally experience. I can tell you where my car is parked. I've got a mental map. I see it in my mind's eye, and when I leave, I'll bet you I'll be able to get to that car easily. That's my episodic memory. But if I tell you where my car is, that's not your personal memory. So there's different ways memory works. In a forensic interview, it's important to help create the conditions for a person to access, to get to their own experience, and then relay that experience, their own episodic memory of the event or what happened.
How does someone's suggestion during an interview play into the subconscious process of the mind?
So that's the thing. Suggestive questions. There's lots of research. Suggestive questions can taint what happens, and taint is a technical word in terms of what happens in interviews and for memory. It can change what people might say or think or think they remember. So it's really important to be very careful in terms of the types of questions that are used.
Just 1 moment. Nothing else, thank you. Thank you, Doctor.
Ms. Hart, any recross?
I do, thank you. Now, you moved into discussing what you refer to as forensic interviews, not forensic psychological interviews. So I want to be clarified. When you're talking about episodic memory and these forensic interviews, are you talking about forensic interviews of children, or are you still talking about your psychological interviews that you do?
Both.
Okay. Because you do often testify for the defense related to forensic interviews that have been done with children in child molestation cases, correct?
Yes.
And you would agree with me that when a forensic interview of a child is being conducted, there's a very specific way that's supposed to be done versus when you're doing a psychological interview for a specific purpose.
A protocol.
A protocol.
I think is what you're referring
Okay,
to.
so again, there's something different that you're doing. Those are two different types of interviews.
There are two different types, but look, the issue of question and question type are good interview techniques, so they cross over.
Okay. But again, as you relate to children and children being suggestible.
I would object. There's nothing in this case about children interviews. It's not relevant.
You know, he brought it up when he started about forensic interviews.
No, he didn't. He said in forensic interviews. She asked about it being children.
I overrule your...
In your forensic interviews of children that you're talking about, children have a whole different idea of suggestibility than adults, correct?
So children tend to be more suggestible than adults.
Okay. May I approach, Judge?
Sure.
We earlier saw there are a couple of things you had up here. The first, when you start talking about that you had a transcript, you did not prepare this transcript, correct?
Correct.
In fact, this was provided to you by the defense?
Correct.
And you've been using that to testify?
I've been referencing it, yes.
And you used it to prepare your report?
No, I don't. Actually, I think I did reference it. I actually listened to the recording and looked at the transcript and used both.
Okay. So then when you were doing that, did you go through and mark the differences of what you heard and what's in that report or what's in that transcript?
I don't think I marked the differences.
Okay. But you would agree with me, sitting here today, you can't tell the jury that the transcript you've been looking at and referring to today is a true and accurate transcript of the interview that you've heard, right?
There might be some detail differences, but the key things are the same.
Well, but we've just been talking about details. The way you ask a question can be an important detail, right?
Yes.
Okay. And I also have here something that I just received. I saw it during the break that you prepared. This appears to be several pages worth of what you were prepared to testify to today. Is that correct?
It's an outline.
It's an outline. Right. This is an outline of what you prepared to be able to testify to today.
Yes.
And you specifically in that reference certain portions of what the defendant said during his confession, correct?
I believe you're referring to the interview, the agent interview. Is that what you mean?
Correct, yes, during his confession.
I didn't know if you meant the written.
No, I mean during the interview itself.
Yes.
You pointed out specific times in which you believe there was indications of what you've referred to as minimization, correct?
Yes.
And you've pointed out specific times in which you believed there was this, I think the defense counsel referred to it as confrontation denial.
Confronting denial.
Okay, confronting denial. You've pointed out specific times in this in which that occurred, correct?
Yes.
Okay. Show me in this that you prepared today one time where you noted a non-leading question that did not contain minimization.
I didn't highlight those.
Show me one place in that report where you noted a question that was asked by Agent Shadell that you did not believe contained this confronting denial type of question.
I can tell you some, but it's not in the report.
In your report?
Or, excuse me, outline.
Your outline. Is that right? It's not in there.
Right.
And that's because in preparing to testify today, you were prepared to talk about the things that supported the conclusion you were hired to make.
I was hired to evaluate this man.
Okay.
And let me be clear, and I'm looking at her, I mean, the deal was I would get in and evaluate him, but there was no guarantee on the result of that. And had it perhaps come out differently, I was certainly prepared. That was it. And that happens in the work I do. I'm hired to provide a report. You know, you do an evaluation, and then the attorney takes that and makes some decisions about what happens next.
But you told this jury that you would have testified just the same if the court had hired you, but not one place in your preparation to testify today did you indicate a question that you thought was a good question that Agent Shadell asked, right?
I didn't outline the good questions.
You only outlined the bad stuff. Fair enough?
I outlined what I saw as problematic questions.
Okay. So then let's look at, we're going to use your copy of the transcript you've been provided by defense counsel. Agent Shadell's question. I didn't ask you yesterday, but I guess we didn't get around to it. Do you have any idea why I've asked you to come down here today? You would agree with me that that is not a leading question, correct?
I agree.
You would agree with me that that is not a minimization question, correct?
Correct.
And you would agree with me that that does not involve any confronting denial, correct?
Correct.
In fact, that is about as open-ended as it can get, correct?
Good question.
And in response to that, Ryan Duke said, I've got a pretty good idea. It's about Miss Grinstead. That's a good question and a good answer, right? We're okay with that?
Well, if you really want a response to that, my understanding is the recorder turned on after an interview had already occurred.
And that's information you received from Mr. Duke?
Yes.
So if this jury has heard that that absolutely didn't happen, then we're going to stick with what the jury's heard in the courtroom, okay? So my question to you is, that's a really good question. You're good with that, right?
That's a straightforward question.
Okay. What about this? What makes you think it's about Tara? That's a good question, right? Open-ended.
That's fine.
His response, I was involved in it, man. That's a perfectly good question, right? And a good answer.
It's a perfectly fine question and answer.
Okay. Now, I will point out, because it's not in your transcript, do you know that there is actually a question and an answer that's in there that you're missing from this transcript?
No.
Okay. So, again, we can agree this is not a verbatim transcript. This is what defense counsel gave you, correct?
Okay.
Okay, tell me what happened. Open-ended question, right?
Open-ended question.
Not anything about that that's confrontational, right?
Right.
Not anything about that that's suggestible,
That's
correct?
a good question.
And not anything about it that minimizes his involvement.
It's a good question.
And his response was, I used to break into people's houses just to steal money. You recall that, right?
I do.
And not at one point, anywhere during that 3 hours worth of interviews with Agent Shadell, did the defendant ever change his story that he used to break into people's houses just to steal money, correct?
That's correct.
He goes on. I was a drug addict. I've been drinking. I was high. I don't remember everything clearly. I was stealing from her purse and she snuck up on me. Again, that's a response to an incredibly open-ended question, correct?
It is.
And at not one point during these 3 hours of interviews did Ryan Duke change his version of events from saying that he was in her purse and she snuck up on him, right? That stays consistent.
I don't remember him changing that.
Okay. And feel free to refresh your recollection with the transcript. And I hit her. I didn't mean to. It was reactionary. Again, that's in response to an open-ended question of, tell me what happened, right?
Yes.
And at no point did Ryan Duke change his version of events to say that he did not hit her, correct?
I don't remember him ever saying he did not hit her, but to put that response in context. So one of the issues is corroboration, and corroboration of what a person says can be common sense. And the agent clearly suggested that he's no Hulk, that it sort of didn't make sense what he said.
And even when he confronted him, he stuck with, all I remember is hitting her, right?
He actually went to confusion. He said, I don't remember.
Doesn't remember. And Agent Shadell asked him multiple times if he thought he may have strangled her, correct?
He talked about strangulation and choking.
And in fact, Ryan Duke, the closest he got to that was saying, I don't know, man, I just don't remember that.
That's about right.
Okay. So while he may have been moving closer when he was confronted, he stuck with, I hit her throughout the interview.
He didn't, he never, that I heard, said that he did not, I don't think he retracted what he said. He didn't say that, I said this, that's not really what happened, something else happened.
Now, defense counsel has talked to you about minimization used by law enforcement. Let's talk about minimization used by suspects. Ryan Duke is already minimizing here, correct? I didn't mean to. It was reactionary.
So maybe you and I use minimization in a different way, but that, is possible to be a correct self-report.
Okay, so it's possible, even though it sounds like you kind of agree with Jason Shadell that he's not the Hulk, but now you're saying it's possible that it could have just been reactionary?
Yeah, so I wouldn't really characterize that particular statement as minimization.
Okay. That was
in that moment, I hit her, but it wasn't that bad. Now, that would be minimization.
Okay. He then says, but I ran and I didn't know what else to do. Again, throughout the entire course of that interview, he never changes the fact that he says that after he hit her, he ran away.
I don't remember him disputing that or changing that he ran.
Okay. So these are all things that were in response to an open-ended question, correct?
Yes.
That did not involve any of the tactics or techniques that you've talked about today, correct?
Yes.
And in those, Ryan Duke has confessed to entering Tara Grinstead's home with the purpose of stealing, correct?
So if we're going to talk about entering the home, yes, that's exactly what he said. He said he was a crook and he went to get money for drugs.
Okay. And he admits to that he struck her, correct?
Yes.
And he admits to the fact that as a result of him striking her, she was fatally wounded.
Right. He also said that he broke into the door.
Okay.
And that doesn't seem to fit with other kinds of evidence.
The evidence you've been shown by defense counsel, right? To be clear, you've not heard a bit of testimony in this trial, correct?
No, well, I'll tell you what, this is covered extensively in the news. It's almost impossible not to see some of it, but I haven't.
Have you watched testimony?
No.
Okay. So again, other than what the news has told you, you've not watched one single bit of testimony in this
I
case.
didn't live stream it or whatever. No, I did not.
Okay. So anything you know about the case is what defense counsel has told you, or the defendant.
In the documents, the discovery documents.
And those would be the discovery that they wanted you to have.
It's what I received.
Okay. Here are some other things that Ryan remains consistent on throughout his interview. He remains consistent that he does not remember her ever being naked in the time period he saw her, correct?
That's correct.
And Agent Shadell asked him that multiple times in multiple different ways, correct?
That's correct.
And he stays consistent that he does not remember her ever being naked.
That's correct.
Agent Shadell even tries to give him alternative theories of, well, maybe her clothes were off because she'd been out there for a few days. And he continues to say, I don't remember her being naked, right?
That's correct.
We already talked about it earlier, but don't know if it's in your copy of the transcript, but we talked about earlier that when he said, and y'all went back to the house, Agent Shadell corrects him and says, no, I went alone. Do you remember that better
I do.
now? Okay. What about when Agent Shadell talks about the defendant getting the keys out of Bo's pocket, and he specifically says he stole the keys? You recall that?
I do. But if you put that in context, and that's what happens here. He initially said, Mr. Duke said, about how he got there. He doesn't remember.
Yes, sir.
And then in fact, this is pretty close to a quote. I don't remember getting the car. And then the agent introduced the idea of a truck. And then comes the issue of getting the truck, stealing the truck.
Okay. You would agree with me, when you're doing your evaluations, you don't leave there and try to go find physical evidence to support or deny what the people tell you during your evaluations, correct?
During the evaluation.
What they tell you during the evaluation, do you leave later on and go and find physical evidence to support or deny that?
Police do.
You.
It depends on the case. So for example, if I'm doing a child custody case, somebody says dad's a drug addict, and dad says he's not a drug addict. Sometimes I'd reach out to the guardian and say, hey, is dad a drug addict? I mean, do we have other information that tips these scales? So not typically, but under those kinds of situations, seeking out corroborating information is done.
And in fact, corroborating information of someone's statement, whether it's to you or to law enforcement, can be a big part of going into the evaluation of their statement.
Yes,
correct?
it can.
Even when you're doing your evaluations, you would agree with me that you ask the same question in different ways in order to see what the person is going to say.
I mean, repeated question with similar content and that kind of thing. Yeah, sometimes.
And I mean, that's a psychological tool that is used to see essentially if someone's going to contradict themselves one time for the next time, correct?
Well, typically repeated questions are not used as a lie detector test, but
that wasn't the question I asked, but go ahead.
Well, you asked me about it, and so typically repeated questions are to help flesh out information, to help that person, assuming you have their episodic memory going, to help them fill it out, whatever the situation or event might be.
When you do evaluations such as the one you talked about here with the 5 personalities,
Sure.
Built within those specific evaluations are the fact that questions are asked, the same question in different ways.
There are some that do that. The NEO 5-factor personality inventory doesn't exactly do that, but it has similar themed, for example, extroversion and introversion, but it's not a reliability test.
You would agree with me that one of the indications that someone is having an episodic memory is when they, without being told to, act out a scenario, correct?
So it could be, yes.
Okay. So if, for instance, someone, as they're talking about carrying a body out of a house, holds their hands like this and begins crying as they're talking about it, that certainly could be an indication they're having an episodic memory of that.
Could be.
All right, any redirection?
Did we get you everything you asked for in review? Was there anything that you wanted from our file that we didn't get you?
No.
And if the state had reached out to you, were you willing to speak with them?
Sure.
Were you willing to review whatever they might have provided?
Absolutely.
Thank you.
Anything further, Ms. Hart? Dr. Taliski, thank you for your testimony, sir. You're welcome to stay. Go. Any reason he shouldn't be excused to go on about his business from the state? Appreciate your testimony.
Thank you, sir.
The only thing I'll ask you is don't discuss the testimony you've given here today with any other witness to the case until the case is concluded, okay?
I will not discuss it.
Good deal. Have a good day.
Thank you, sir.
Call your next witness, please.
Sorry, protect the car.
Okay.
Sorry, what do you? I already gave you that.
Bill Barr.
Bill Valor. Okay. It's marked as 3.
Good afternoon. Come on, have a seat. Detective Barr, I'll remind you, you've been previously sworn and still under oath in this case, okay? Go ahead and have a seat.
May I approach the witness?
Sure.
Thank you. Hi, Detective Barr. Thank you for coming back. How are you?
I'm good.
I'm going to show you what's been marked as Defendant's Exhibit 3. Can you take a look at it?
Sure.
Thank you.
Okay.
Does that appear to be a fair and accurate depiction of Ms. Grinstead's door on the day that you were there?
Objection leading.
Overrule that objection.
Yes.
Thank you. Judge, I move to admit Defendant's Exhibit 3 in evidence.
All right, any objection or order?
Yeah, of course. I gave you a copy earlier.
No objection.
All right, that's admitted without objection. Thank you.
Thank you. May I publish, Judge?
Sure.
Great. So we've already got in, I'm going to show you something that's already in evidence first.
You'll help us there, Ms. Watkins.
Oh, I'm sorry.
We got it.
I'm going to try to show you. Sorry. Give me 1 second. So is this Ms. Grinstead's front door? I'm referring to Defendant's Exhibit, I'm sorry, State's Exhibit 76.
Yes, ma'am, it appears to be.
Okay, and so this side, do you see where my finger is?
Yes, ma'am.
That's the, is this the, what I just admitted? That is the continuation of that door?
Corresponding side, yes, ma'am.
Okay, the corresponding side. Okay, great. And I'm going to, it's really hard to see on the Elmo, so I'm going to hand it to you.
Okay.
If you could take a look at that area right there. Does that appear to be the corresponding deadbolt or, I guess, hotel lock to this?
It appears to be, yes, ma'am.
Thank you. No further questions. Thank you so much.
All right. Anything, Mr. Rigby, can you follow up?
No question, John.
All right, thank you. Detective Barr, thanks
Yes, sir.
for your testimony. Don't discuss this testimony either until
Yes,
the
sir.
case is concluded. Thank you,
you,
sir.
sir.
You be excused. Call your next witness, please.
All right, Your Honor, this is called John.
I'm sorry.
John Adam Harper.
All right, John Harper. Come on down this way, please, Mr. Harper. Thank you. Good afternoon. If you'll step up right there, please, sir. Before you're seated, please give your attention there to Mr. Gibbs. He'll swear you in and direct your testimony.
So please raise your right hand. And do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated, sir. Want some water?
No, sir, I'm good.
Okay, thank you. Give your attention to Mr. Gibbs.
Would you please state your full name for the record?
John Adam Harper.
And where do you currently
Will you
live?
please speak up a little bit, Mr. Gibbs, and give us some signals from the jury? Thank you.
Where do you currently live, Mr. Harper?
132 Pin Oak Circle.
And is that in Fitzgerald?
Yes.
Where do you are you currently employed?
Yes.
And where do you work?
Horse River.
Have you ever met the defendant in this case, Mr. Orion Duke?
No.
Have you ever met an individual named Bo Dukes?
No.
Were you interviewed by GBI agents in this case?
Yes.
And were you truthful during those interviews?
Yes.
Did you previously live on Park Street here in Ocilla?
Yes, I did.
Did you live there in October of 2005?
Yes, I did.
Was that house across the street from Miss Tara Grinstead?
Yes, it was.
Did you have a roommate when you lived there in October 2005?
Yes, I did.
Who was that?
John Olmsted.
Did you personally know Miss Grinstead before she went missing in October 2005?
Yes.
How did you know her?
She was a teacher, my teacher.
Did you have any classes with her?
Yes, I did.
What class did you have with her?
History, first block.
Did you know her at all outside of school?
Not really, no.
Your house on Park Street, were you able to see her front door when you were coming and going from your house?
Yes.
Were you able to clearly see her carport?
Yes.
You remember what kind of car Miss Grinstead drove?
A white 3000 GT.
Was that sort of a memorable car?
Yes.
Did it stand out?
Yeah, sports car, yeah.
Did it stand out in Ocilla?
Yes.
And what color did you say the car was?
White.
Were you at your house on Park Street the last day that Miss Grinstead was seen, which was Saturday, October 23rd, 2005?
Yes.
Did you see her outside during the day that day?
Yes, I did.
What was Miss Grinstead doing when you saw her?
I believe she was taking a dress over towards Mr. Portier's.
Speak up for us, please. Thank you.
She was taking a dress over to Mr. Portier's house, walking the road over to his house.
And who was Mr. Portier?
The neighbor.
It was her neighbor?
Her neighbor, yes.
Did you see anything unusual out of the ordinary around Miss Grinstead's house any time that Saturday?
No.
The next day, Sunday, October 24th of 2005, did you leave your house or anything that day?
Yes.
What time did you leave approximately your house that morning?
The morning I left around 8 or 9 o'clock and went to G&G, the store, right down the road.
And you walked to the store or did you drive?
I drove.
When you left your house, was Miss Grinstead's car parked at her house at that point?
I didn't see it that morning.
At some point later that day, did you leave your house again?
Yes.
Do you remember where you went that afternoon?
I think me and John went to Wendy's and got something to eat.
Please speak up, Mr. Harper. I'm sorry.
We went to Wendy's, and me and John went to Wendy's and came back.
About what time did you get back to your house that Sunday afternoon?
I would say it was just before dark, because I remember it was starting to get dark outside.
Would that have been in the evening around 7, 8 o'clock maybe?
Probably so, yes.
And when you returned, was Miss Grinstead's car back under a carport at that time?
Yes, it was.
So Miss Grinstead's car was not at her house earlier in that day, but it was back there Sunday afternoon, evening?
Yes.
I'm going to allow that. Overrule that.
Did you see anybody return the car?
No.
Did you see anyone come or go from her house at all on Sunday?
No.
And you gave all this information to the GBI in 2006 and 2008?
Yes.
No further questions?
Okay. Ms. Hart or Mr. Rigby?
Mr. Harper, you didn't actually speak with law enforcement until March 29th of 2006, correct?
I'm not sure of the date.
Okay. So you're not sure of the date that you spoke with law enforcement for the first time? It's okay if you aren't. I just want to clarify.
I can't remember exactly what day it was.
Okay.
I know when I got home that day there was law all in my yard and everywhere, and I can't remember if it was that day or the next day I went and talked to somebody at the sheriff's or the police department.
So, do I understand that you're saying that you actually spoke with someone at the police department within the first 24 to 48 hours after she went missing?
I believe so, yes.
Okay. And you're familiar with the fact that GBI is actually the investigative agency in this case?
Yes.
You spoke with GBI, correct?
Yes.
Okay. Now, defense counsel, in preparing you to testify today, did they give you a copy of the summary that you gave to the law enforcement made of your interview back then?
Yes.
Okay. And that would be something that came from the GBI, correct?
Yes.
They didn't show you a report from the police department, correct?
No.
And understandably, sitting here today, you probably don't have a clear memory of what occurred back in 2005, right?
No.
So your testimony here today is based on having had your having had your memory refreshed by rereading that summary, correct?
Not all of it. I do remember, like the car and everything. I do remember that.
Okay. So may I? May I correct, Judge? Sure. Okay. Don't read this out loud. I apologize. I thought I had a printed copy, but I don't. But I'm going to ask you to take a look at that first paragraph and see if that refreshes your recollection as to whether or not the first time you spoke to GBI was on March 29th of 2006.
Yes.
Okay. Now, you would agree with me that between the date that Ms. Grinstead was reported missing and the time that you spoke with this GBI agent, there were a lot of rumors going around Osceola about her, correct?
Oh, yes.
There were a lot of rumors going on around Osceola about if a vehicle had been seen at her house or had not been seen at her house, correct?
Well, I don't know if there was that talk going around.
Okay. There was a lot of rumors around Osceola about whether or not her vehicle was home during that time period or whether it was not, correct?
Correct.
Okay. So, and in fact, the way that you wound up speaking with law enforcement or to the GBI is because they originally interviewed your roommate, correct?
Yes.
Now, your particular residence, the jury has had a chance to see Miss Grinstead's house. Where was your house in connection to her front door?
Straight across.
Straight across, okay. And how old were you in 2005?
Oh, my God. 22, 23? I'm not sure.
Okay. You told law enforcement that on the Saturday of the pageant that you saw Miss Grinstead at the portier's residence between 8 and 9 a.m. Is that right?
Yes.
Okay. So would it surprise you then to learn that testimony has shown that she didn't actually go to their house until sometime that afternoon?
I saw her that morning walk from her house over to their house.
Okay.
With a dress on her. I think she was carrying a dress.
Okay. You would agree with me, though, that she visited in the portier's home frequently?
Yes.
And you would agree with me that she frequently had dresses because she did pageants? Or
Yes.
she helped people with pageants?
Yes.
Okay. Now, you also indicated that you stayed home the entire day of Saturday, October 22nd, is that right?
Yes, probably so.
But you can't tell this jury how many cars pulled up to her house that day, right? No?
No.
You can't tell us what kind of cars those were, right?
No.
You can't tell us what time she left her house that day in her vehicle, right?
Yes, correct.
And you can't tell us when she got home.
Correct.
And then on Sunday, and I'm not using specific dates because I know you probably don't know the specific dates anymore, but to be clear, on Sunday is what you've been called to testify. You indicated that you stayed home all day except to go to the G&G convenience store around noon?
No, it was earlier in the morning when I went to G&G.
Okay. So taking a look at the statement you gave, or the summary that GBI wrote from the statement that you gave, refresh your recollection on what time of day it was?
Ma'am?
We've taken a look at the summary the GBI wrote after they spoke with you back in 2006. Refresh your recollection about what time of day it was you went to G&G.
Maybe.
Okay.
I know it was morning time when I went.
Don't read this out loud for me.
But if you can read that paragraph to yourself.
Yes.
Okay. So I asked you earlier if it was around noon, and you corrected me and said no, it was the morning time. Is that right?
I'm pretty sure it was the morning time.
Okay. And now I don't want to get nitpicky. Around noon can actually be in the morning time. But
Yes.
sitting here today, do you have any clear recollection of telling law enforcement that it was around noon?
I could, yes.
You could have, but you don't remember that clearly. And it's okay. I don't expect you to.
I'm pretty sure it was in the morning when I went.
Okay.
Because usually when I got up in the morning, I'd always go to the store.
Okay. And you said when you usually get up in the morning, you go to the store?
Yes.
But you didn't on Saturday, is that right?
I didn't Saturday, no. Okay. Well, I may have Saturday. I mean, I don't think I did.
And again, that's really kind of my point, is sitting here all these years later, do you have a clear, distinct memory in your brain of what happened over that weekend?
Somewhat.
Okay. And again, to be fair, until you found out Tara Grinstead was missing, was there anything unusual about that weekend?
No.
No. Now, just want to make sure again, I'm going through this. You indicated you were only gone from your house for a few minutes when you went to G&G, is that right?
Probably 15, 20 minutes.
Do you recall telling law enforcement that you actually don't recall seeing any vehicles at her house on that Saturday?
Oh, no.
Right. If you had, I guess sitting here today, do you remember if she had vehicles at her house that day?
On Saturday?
Yes.
Her car was there Saturday.
What about other people showing up?
That I don't remember.
You don't remember that?
No.
Okay. Is that something that you think would have stuck out to you if there were a bunch of people showing up?
Yes. Yes, because our kitchen window was facing right towards her house. If I walked up there, I could see, anybody.
Okay. And you said this, the way you said it, I want to clarify. What I thought I heard you say earlier was you said you don't remember seeing her car at her residence on Sunday when you went to the store. Is that right?
I didn't see it.
You definitely did not see it.
I did not see it Sunday morning.
You didn't see it Sunday morning when you got up and went to the store?
Correct.
Okay. But then you indicated that you did see the vehicle back at the residence around 8 p.m. when it was dark outside. Is that right?
It was getting dark, yes.
Okay. So is it your testimony to this jury that you believe her car was gone from sometime in the morning until 8 p.m.?
It's possible, yes.
Okay. But you don't know?
I don't know when the car came back.
Okay.
I just know that morning it wasn't there, and later on that afternoon it was there.
Okay. And again, since you said the morning, I want to kind of be very general about that. Would it surprise you to learn that a person by the name of Cindy Sutton indicated to law enforcement that they saw the vehicle at her house around 10 a.m.?
Yes, hearsay.
I'm asking if it would surprise him, Judge.
I think she's introducing hearsay through the question.
No, Your Honor, I'm not. I'm asking him if it would surprise him.
I will rule that okay.
Would it surprise you to learn that a lady by the name of Cindy Sutton indicated she saw Miss Grinstead's vehicle at her home around 10 a.m. that morning?
It could have been.
Okay.
Because like I said, I didn't see it till later on that afternoon. It could have came back from when I got back from G&G. It could have came back from then till 8 o'clock.
Okay. So do you think that you went to G&G before 10 o'clock in the morning or after 10 o'clock in the morning? Before. Okay. So then, would it surprise you to learn that someone by the name of Wileen McNatt indicated that at 9:30 a.m. she saw the vehicle parked under the carport?
Overrule that objection. As long as she has a good faith basis for it, I think she can ask.
What was the question?
Would it surprise you to learn that someone by the name of Wileen McNatt indicated that when she went to church at 9:30 that morning that she saw the vehicle under the carport?
She could have.
She could have. Okay. So do you think that you went to the G&G before or after 9:30 that morning?
I want to say before.
Before?
Yes.
Okay.
So I usually don't sleep late.
You don't sleep late?
I don't sleep late.
Okay.
Do you recall telling law enforcement, again, back in '06, that you had not woken up until between 11 and noon on October 23rd?
No, I don't sleep that late.
I'm sorry?
I don't sleep that late.
Okay, Matt, approach Judge. And again, feel free to scroll through this. I apologize for not having it printed, but I'm going to scroll up and make sure that we're looking at the right one. I'm gonna get there. So looking at this, again, this appeared to be the summary from your interview.
Yes.
March 29th of '06.
Yes.
Okay, I'm going to scroll back down to where we were then. Okay, so again, don't read this out loud.
Okay.
But if you can read that line right there.
I usually don't sleep that late.
Okay, so I know I'm sitting right here, but everybody else has to hear what you're saying.
I usually don't sleep that late.
You usually don't sleep that late.
Yeah.
So I guess my question to you then is, even though you usually don't sleep that late, do you think your memory back in 2006 would have been a little bit more clear than it is now?
Yeah, but I mean, from what I can remember, I got up early that morning.
Yes, sir.
And went to G&G, did not see her car. When I came back, I did not see her car.
Okay. So I know you're saying that you don't think you slept till 11 o'clock or noon, but I want to ask you, based on your prior statement, I do want to ask you a few more questions, okay? I did have yours printed, I'm sorry. Now, did you drive a Chevy Silverado truck back then?
No.
No, I don't have yours printed. I have a different John Harper. Do you recall telling do you recall her dog barking that weekend?
No, right off I don't.
Do you recall telling law enforcement that you did not hear her dog barking that weekend?
No, I don't. Her dog usually didn't bark unless my roommate's dog was outside.
Yes, sir.
Then they would both start barking.
If there's a recording of her dog barking at around midnight from Sunday night into Monday morning, would that surprise you?
No.
Okay. But you don't remember hearing him bark?
No.
So I guess my question is, given that you did not, well, let me ask this differently. You recall going to speak with somebody at the police department when you first found out she was missing, is that right?
I'm not sure if it was the same day or it may have been a couple of days. I mean, I'm not exactly sure what day it was. Okay. But I do remember going to the police station and talking to somebody.
And do you remember who you spoke with there?
It was a black officer.
Okay.
I don't remember his name.
Okay. But you would agree with me that the only report you've been shown to get ready to testify today is one from the statement you gave March 29th of '06, right?
Yes.
Okay. And your memory here today is clearly different than what you told them back then, is that right?
It's possible. Like I said, it's been, 17 years?
Thank you. I appreciate it. No further questions.
Can you follow up, Mr. Gibbs?
Was Ms. Grinstead's Carter house Sunday morning?
No.
Was her car there that evening?
Yes.
No further questions.
All right.
I do. What Sunday was that?
Couldn't tell you.
No further questions.
What was your response? I'm sorry, sir.
Sir?
What was your response to the question? I couldn't hear.
What was the question?
My question was, what Sunday was that? And his response was, I couldn't tell you, Judge.
Yeah,
Oh, I'm sorry.
the date wise, I couldn't tell you.
Okay. Anything further we need to ask Mr. Harper?
No further questions.
All right. Mr. Harper, thank you for your testimony, sir. You're welcome to stay, go, whatever you'd like to do. Let me ask you, however, please don't discuss the testimony you've given to this jury this afternoon with any other witness in the case until the case is over, okay?
Yes, sir.
Thank you so much. Have a great day. You be excused. Call your next witness, please.
Defense calls John Olmsted.
All right. Thank you. Mr. Olmsted, please. Y'all okay? Anybody need a break? I should have asked. Yes? All right. Stop, Mr. Olmsted. Let's take a 5-minute bathroom break, ladies and gentlemen. You'll adjourn to the jury room.
We need to wait for Miss Merchant. Okay. All right. All right, now we're ready for the next witness. Mr. Gibbs? Great. Mr. Olmsted, please. Morning, sir. Good afternoon. Excuse me, guys. Yeah. Before you're seated, please give your attention there to Mr. Gibbs.
Thank you. Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can be seated.
Sir.
Okay, if you would, start by stating your full name for the record.
John Adam Olmsted,
And where do you currently live, Mr. Olmsted?
Sycamore, Georgia.
And how old are you?
43.
And where do you currently work?
Cordell Metalworks.
Okay, what's your job?
Draftsman.
Have you ever met the defendant in this case, Mr. Ryan Duke?
No, sir.
Have you ever met an individual named Bo Dukes?
No, sir.
Were you interviewed by the GBI about this case in 2006, 2008?
Yes, sir.
Was your memory of events from 2005 better in 2006 and 2008 than it is now?
Oh, yeah.
Were you truthful during your interviews with the GBI?
Yes, sir.
Did you previously live on Park Street here in Osceola?
Across the street from Miss Grinstead. I don't know the address or anything.
Did you live there in October 2005?
Yes, sir.
And your house, was it directly across the street from Miss Grinstead's house?
Yes, sir.
Did you have a roommate when you lived there?
Yes, sir.
And who was that?
Adam Harper.
Did you personally know Miss Grinstead before she went missing in October 2005?
No, sir.
Could you clearly see her house when you were coming in and out of your house on Park Street?
Yes, sir.
Were you able to clearly see her front door?
Yes, sir.
What about her carport?
Yeah.
What kind of car did Miss Grinstead drive?
A white Mitsubishi Eclipse or something like that.
A white sports car?
Yeah.
Did you have a dog when you lived across the street from Miss Grinstead?
Yes, sir. I had a black lab.
And did you regularly take him outside for walks when you were at the house?
Yes, sir.
Did you walk him on a leash usually?
Mm-hmm.
When you'd walk your dog, was Miss Grinstead's house usually clearly in sight?
Sometimes depending on the route I took.
We were at your house on Park Street the last day that Miss Grinstead was seen, which was Saturday, October 23rd of 2005.
Do what now?
Were you at your house on Park Street the last day that she was seen alive on Saturday, October 23rd?
Yeah, we were there all weekend.
Did you see her outside that Saturday at all?
I really can't recall. I think we seen her that evening or something. I remember seeing some girls in like dresses. I think a pageant was going on that day or something.
Did you see anything unusual out of the ordinary that Saturday?
No, sir.
Did you tell the GBI in 2006 and 2008 that you took your dog out for a walk late in the night?
Overrule that, Judge. Let me hear the rest of the question. If you'll please restate your question.
Sure. Did you tell the GBI in 2006 and 2008 that you took your dog out for a walk late in the evening on Saturday, October 22nd?
Yes, sir. I walked him that night.
About what time was that?
It was late. I was about to go to bed, so it was probably around 11 midnight.
Did you see Miss Grinstead's car parked at her house that night when you walked your dog?
No, sir. That car was not there.
And you're certain the car was not there that night when you walked your dog?
Yeah, I'm certain.
The next morning, Sunday, October 24th, 2005, did you take your dog outside when you woke up?
Mm-hmm.
Was that your standard?
Yes, sir.
Yes, sorry, yes, no.
That's your standard routine, take your dog out when you first got up?
Yeah, I just woke up, got to take him out.
Was Miss Grinstead's car parked at her house at that point?
I do not recall seeing it. I don't believe it was there at that time. No, sir.
At some point later that day, did you leave your house?
Yes, sir. Went to Fitzgerald to get something to eat.
And about what time did you return to your house? I'm going to Fitzgerald.
I really don't recall. It was probably late in the evening, 5, 6 o'clock.
It was about dusk, sounds like?
Yes, sir.
Was Miss Grinstead's car back under her carport at that time?
Yes, sir. The car was back.
So just to restate, earlier that day when you were walking your dog, her car was not there, but it was back under her carport when you returned that evening?
Yes, sir.
Did you see anyone return the car?
No, sir.
Did you see anyone else come or go from her house that Sunday?
No, sir.
The next day, Monday, October 25th, did you leave your house for anything that day?
I had to go to work, left early for work, like I normally do.
You remember about what time you left your house?
Probably 6:30. Got to be at work at 7.
When you left, did you see Miss Grinstead's car parked in her carport?
Yes, sir.
And did you come back to your house some point later that day?
Took my lunch break around 11, came home.
Did you see anybody at Miss Grinstead's house when you came home for your lunch break?
Saw some kids peering in through the window.
Anybody else?
No, sir.
After she was reported missing, did you see people going in and out of her house sometimes?
Well, that same day, that Monday, it was lunch. I was going back to work, and I seen, I guess they were teenagers, little kids. The next door neighbor came over and had let them in, and then I went back to work.
Do you know who the individual, the neighbor that let him in, do you know who that was? Did you know him?
I didn't know him, no, sir.
And did you give all this information to the GBI during your interviews with them back in 2006 and 2008?
Yes, sir.
Okay, no further questions.
All right, Mr. Rickett, any questions for Mr. Olmstead?
Yes, Your Honor. Mr. Olmstead, you were living with Mr. Harper at that time at the residence across the street, is that right?
Yes, sir.
Now, you remember that Saturday seeing a lot of girls there at the residence about the pageant, is that right?
I remember seeing a couple women, and they were wearing dresses, yes, sir.
And you saw a lot of cars coming and going from the residence that day?
Probably, yes, sir.
Probably. Not really sure?
Not really sure. I mean, it wasn't like I was looking through my blinds or anything. It was just, I was probably going to the store when I happened to see the ladies in the dresses, you know.
Right. And did you see, I think you even told the GBI, now you were interviewed by the GBI actually in March of 2006, correct?
Yes, sir.
So some 6 months later when you actually talked with the GBI. Is that,
yes, sir.
Thank you. So 6 months later, you talked about this day where you remember the pageant. Is that right?
Mm-hmm. Yes, sir.
And did you actually, did you see Miss Grinstead actually go over to Mr. Portier's house with a dress?
I really can't recall right now, sir.
You didn't see that?
Yeah, I don't know.
Did you ever tell the GBI you saw her go over to Mr. Portier's house?
Possibly in my first one, the one I gave in 06, yes, sir.
You may have, you just don't. Do you remember that happening, or do you remember if you told them or anything like that?
Not really. I can't recall. It was so long ago.
I understand. So you don't really remember whether you saw her go over to Mr. Portier's house or not.
Mm-hmm.
And yes, that's a
yes.
yes.
Sir.
And you don't remember telling the GBI that in your statement either. When you gave it in 2006, you don't remember seeing it, nor do you remember telling them that.
Well, whatever I told him in 2006 is what I recall.
Okay.
Right now, what you're asking me, I don't really recall.
You don't recall. So looking at your statement that you gave the GBI, refresh your recollection about what you remember maybe having seen back in 2005?
Yes, sir.
Now, I'm going to direct your attention, I want you to just read this to yourself. I'm going to direct your attention to page 2, and if you'll read that line to yourself, and then once you've read it, you'll just let me know.
Okay.
All right. Is your memory refreshed?
Well, I mean, I said it. It must have happened, sir. So.
Okay, but you have no recollection of that today as you testify in court?
No, sir. I mean, I really don't remember.
And you don't even remember telling the GBI that, do you?
No, sir.
Now, do you recall on that Sunday morning, do you recall what time your roommate, Mr. Harper, got up that morning?
No, sir. I know I didn't get up to around lunch, so I don't know. Okay. He always got up before me.
All right. So you don't know if he went to the G&G Supermart or not, do you?
No, sir.
Okay. And that wouldn't be something you would know, correct? Is that loud?
Yes, sir.
In fact, you told the GBI that you and Mr. Harper actually went to Wendy's that afternoon about 4 p.m. Isn't that true?
Yes, sir.
And you and Mr. Harper went to Wendy's, and when y'all came back, y'all didn't see the car at that point. Isn't that true?
Well, when we came back from getting food later that evening, that's when we noticed the car was back.
So you and Mr. Harper noticed the car after y'all came back from Wendy's?
Yes, sir.
And that's what you told the GBI?
Yes, sir.
And I believe you told them that was about 6 p.m. when you got back from Wendy's with Mr. Harper, and y'all didn't see the car at Ms. Grinstead's residence.
We did see the car at her residence when we got back from Wendy's.
And that would have been at 6?
Well, yes, sir. Whatever time we got back, yeah.
Okay. Did you remember telling the GBI that was about 6?
I assume. I mean, you know, we kind of had a schedule. Usually about 6, we'd go get something to eat, so I assume.
Are you familiar with a Miss Susan Luke that lived on the same street that you did?
No, sir.
You're not familiar with Miss Luke, who was also a neighbor of yours on Park Street?
No, sir.
Now, would it surprise you that Miss Luke actually saw the car there earlier that day?
I mean, no, it wouldn't surprise me.
You familiar with Bryson Boykin?
No, sir.
And that they saw the vehicle there that day when you said it was not there. Would that surprise you?
No.
Thank you.
Mr. Gibbs, any follow-up?
Only 2 questions. You recall earlier today on Sunday, the car was not there.
That morning it was not there.
And that evening, the car was there.
Yes, sir.
No further questions?
Anything further? Mr. Olmstead, thank you for your testimony, sir. You're going to be excused to go on about your business. The only thing let me ask you to do, please, is don't discuss the testimony you've given to this jury this afternoon with any other witness in the case until the case is over, okay?
Yes, sir.
Thank you so much. Have a good day. Call your next witness. All right, Jerry Williams, please. Good afternoon, sir. Just step around here, thanks. You can go ahead and be seated, sir. Ms. Merchant, you can proceed.
Thank you. Good afternoon. Can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Great. Can you state your name for the record?
Jerry Williams.
Okay, Jerry. How are you related, or how do you know Ryan Duke?
Just through the family.
Through the family, okay. Are you related, or do you have a relationship with someone in the family?
Yes.
Okay, can you tell us who that is?
That'd be Linda.
Linda, okay. And what is Linda to you?
My significant other.
Okay. And what is Linda to Ryan?
Her.
Well, do you know if they're related?
Yeah, they're what's that? Uncle, aunt.
Okay.
I think. Yeah.
And what's Linda's full name?
Linda Marie Bullington.
Okay. Can you hear me?
Yeah.
Okay, great. Just let me know if you can't, and I'll try to speak up, okay?
Okay.
Just repeat, approach for just a moment.
Sure.
Mr. Williams, have you ever given an interview to law enforcement in regards to this case?
No.
Okay. Did you own a trailer back in October 2005?
Yes.
Okay. Can you tell us where that trailer was?
Over across from the hospital.
Across from the hospital?
Yeah.
Okay.
Yes,
And what?
if you can speak up a little bit for me, Mr. Williams.
Oh, okay.
All right. Thanks very much.
Sorry, we want the jury to be able to hear
Okay.
you.
Over by the hospital.
That lady in the back corner back there.
I can stand over here for a
Okay,
while.
gotcha.
Okay, I'll stand over here. So.
Okay.
Okay. The trailer that you just talked about, what town was that in?
Ben Hill.
It was in Ben Hill County?
Yeah, across from the hospital.
The hospital. Okay. Can you,
Hospital.
can you tell me the road, if you remember?
Where is that road going? I don't know. What's that road that runs right there in front of the hospital? Whatever that road is, runs in front of the hospital.
Okay. All right.
I can't remember right now.
That's quite all right. I
I'm
understand.
sorry.
Who did you let live in that trailer back in October of 2005?
I let Fred, that would be Linda's brother.
Okay. Fred Duke?
Yeah, Fred
Okay.
Duke.
Is that Ryan's father?
Yeah, Ryan's father, and Ryan and Steve,
Okay.
brother. They were brothers.
Ryan and Stephen are brothers?
Brothers, yeah.
Okay, great.
But Fred, I let live there. Yeah.
Okay, so you let the three of them live there?
Yes.
Do you recall the weekend of October 22nd and 23rd?
Yes, I do. Yeah.
And why do you recall this weekend?
And just, I apologize, I hate to interrupt you, but will you approach for just a moment?
All right.
ladies and gentlemen, step back to the jury room. I'll be right back with you. Thank you. It's two. Yes, ma'am.
So I apologize. He is on the one that we were given on pay this May, but however, he's not on the alibi notice, and apparently now they aren't going to introduce him as an alibi witness. So I would just like to clarify: if he's testifying as an alibi witness, we've not been given notice of him as an alibi witness. Although I am corrected, it is on the one from May. I couldn't find it. I called myself looking, but it's on the very last stage of that.
Okay. Thank y'all. Excuse me. I'm standing up.
Oh, no, please stretch. We filed the alibi notice properly. We filed him as a witness properly. We don't have any statement from him. They could have called him. His information's accurate on the witness list. I don't.
Well, so you're saying that he is identified in the alibi notice?
No, I'm saying he's on the witness list. He's number 44 on the witness list. When we approached earlier, I said I wasn't sure because I didn't have it in front of me if I hadn't listed him on an alibi notice or on a witness list. But now that I've looked, he was provided as number 44 on our witness list.
Okay.
It was filed and provided to the state. So he was provided.
Are you saying you don't have to notify the alibi?
I don't have to notify what a witness is being called for. No, I do not have that requirement, Judge. There's no requirement that we notify who's being called for what purpose.
But except for the alibi witness, right?
No, I have to give notice of alibi. If there's an alibi, I have to give the place and the time, and I can go find the alibi notice, but we complied with the law as far as the date and the time and everything on that.
May I, Judge? Judge, OCGA 1716-5 specifically says that upon written demand by the prosecuting attorney, within 10 days after arraignment or such time as the court permits, stating the time, date, and place in which the alleged offense was committed, the defendant shall serve within 10 days of demand of the prosecuting attorney or 10 days prior to trial, whichever is later, upon the prosecuting attorney a written notice of the defendant's intention to offer a defensive alibi. Such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names, addresses, dates of birth, and telephone numbers of the witnesses, if known to the defendant, upon whom the defendant intends to rely to establish such alibi, unless previously supplied. In this case, Judge, they did supply us with some names of persons who were going to be alibi witnesses. In fact, one of them was Stephen Duke, his brother, and we called him at the trial of Bo Dukes because he was known as a potential alibi witness. At this point, the alibi notice that I've been given, which again I've pulled up from the clerk's file, I do not see this gentleman's name listed.
And your position is you don't have to give it to him?
Well, two things, Judge. He's not actually an alibi, so it's kind of awkward because it's an imperfect alibi. So he will testify that he was there until, I believe.
Let me ask you, so you don't intend to argue or refer to him as an alibi
No, I
witness
don't.
to the jury?
No, not at all. I don't intend on using those words at all because he wasn't with him on the day that they've charged in the indictment. They've charged in the indictment that the crime occurred on October 23rd. He was with him on October 22nd. He was not with him on October 23rd.
So that's the nature of his testimony. I know where Ryan was on the 22nd, but nothing about the...
Nothing on the 23rd.
23rd. So
He has
what
no
about
knowledge
the
of the
time, up to what time on the 22nd?
The evening, his testimony is going to be until I don't even,
10.
10?
10:30, 11,
Yeah.
somewhere in there.
All right, I'm not, I'm not inclined to prevent the testimony, but you want a minute to speak with Mr. Williams?
if he's willing to speak with you.
I guess at this point, I mean, I don't mind speaking with him, but I guess then at that point, if we're talking about the 22nd and not the time of the murder, we'll just have to see whether it's relevant or not. But if they're saying this is not an alibi witness for which they're going to claim that this is a reason they should get an alibi charge to the jury, then I think we've been given sufficient notice for a regular witness.
We're not doing the alibi thing for that. I just was trying to give an abundance of caution, and when they asked for the alibi, say exactly where he was that night, because I didn't know what they were going to allow.
Thank you. Ask the jury to join us. You got some more?
Yeah, I got something. Should we talk to that? Watch my lady back there.
Thank you for your patience with me, ladies and gentlemen. Ms. Merchant, you can continue.
Thank you, Judge. Do you recall the weekend of October 22nd and 23rd?
Yes.
Okay. On October 22nd, why do you recall that weekend?
That was the weekend that well, we had a double move in our family, and that was the weekend that Brett had already left, and I had a call. Well, Linda told me that we had a call. She let me know about some trouble over at that trailer that we'd been having with a certain person. And I had to go over there. Well, the air conditioner broke, for one thing. I definitely remember that. I was trying to fix that, and I had a problem with a person staying over there that wasn't supposed to be over there.
Okay, who's
and
that?
I needed to go over. It was Bo Dukes. I had to go over there and make sure that he left.
Okay. And so had you received any complaints?
Yes, we had.
Judge seemed hearsay.
Yes, we had.
I didn't ask what
I'm going to object. Any
This-
complaints he
Hang on a
would have
second, Mr.
received.
Williams. Yeah, hang on just a second. Thank you, sir.
Any complaints he would have received would have been from someone else that would constitute hearsay.
All right, Ms. Merchant.
Yes, Judge, I didn't ask what the complaint was. I asked if he had received any complaints.
I'll allow that question.
Thank you. Had you received
Overrule that
any-
objection.
Thank you, Judge. Had
Yes.
you received any complaints?
Yes.
And who were those complaints about?
And then Judge,
Not what did they say?
I
but
sustain
who were
that
they
objection. Thank you.
I'm not asking you what those people said. What I'm asking you is who the complaints involved, not what
Judge.
anybody said.
you just sustained that
I
objection,
sustain that
correct?
objection.
Judge, I'm asking who the complaints were involving, not what anybody said. That's not hearsay.
How did you find out who the complaints were involved in?
Through next door neighbor.
I sustain that objection.
What did you do in response to the complaints that you received?
I had to go and figure out what was going on.
You went over to figure out what was
Yes.
going on. Okay, great. And where did you go specifically?
To the trailer.
To the trailer. What happened when you got to the trailer?
I walked in, the air conditioner was off again, it was broke again, but I done told them they had to leave, they had to move anyway.
You told
Brett, I had told Stephen was gonna move anyway, but I told Stephen and Ryan both they had to move,
Okay.
because of the complaints
Okay.
and because of the noise, and, it was time for them to go. I'll just leave it at that. It was time for them to go, it was time for all of them to go. It
Had you
was
received
too
any
noisy.
complaints about Ryan?
Judge, I'm going
No,
to object.
I just
That
had
goes into,
the one.
I'm going to
Hang on
object.
just a second, Mr. Williams.
Who the complaints were about goes into the content of what the complaints were.
No, they don't, Judge. It does not go into the content. It's not hearsay. I'm asking who he received, if he received a complaint about Ryan. That's not calling for any hearsay at all.
Judge, it's
Well, one way it does, one way it doesn't, but I'm gonna sustain that objection.
When you got there, who was asleep?
Stephen was asleep in the back. I didn't get to talk to him. When I walked in the trailer, Bo was standing there in the kitchen, and Ben was sitting on the sofa.
Okay, and just so we're specific,
Second,
can
yeah.
you tell us last names?
Who?
Bo who?
Oh, Bo Dukes, and Bo was there. Bo Dukes was there, and Ben McMahon.
Okay, and where was Ryan when you arrived?
Ryan was in the bathroom.
what state was he in?
Passed out.
Okay. Were you able to wake him at all?
No. I did make sure he was breathing. This boy was passed out. And I've seen passed out before. I've done it myself.
Okay.
Sorry, but I have. But I've seen passed out before. He was gone. He was done.
Okay.
He was laying in the floor. His face was facing the toilet, the base of the toilet, and he was gone. I mean, he was just died. It looked like he threw up a little bit right there before. So I picked him up by his belt like my brother done me before and dropped him a little bit. And he groaned, and I just, excuse me, that just ticked me off pretty bad.
Okay.
So I went back up there and I told, I didn't ever see Stephen. I guess he was gone. I left the light on and nothing back there. I didn't hear anything back there. But I went back up there. I turned the radio off. I'm sorry, radio was on. When I came in there, I turned it off and I asked for Bo and I asked Ben to leave.
Okay.
Which Bo kind of bowed up at me a little bit, but he didn't want to bow too much. But he did. He kind of bowed up at me a little bit, like he didn't like that too much. But I asked him to leave. I asked both of them to leave right then and not to come back. I said, don't let me catch you back over here. And that was it. They walked out. I walked out. They walked. They parked there. I don't know if it was a black truck. I don't know if it was, I think it was Ben's truck. I think he had a black truck. But anyway, they had parked it, the next trailer over, down at the end, but there wasn't a trailer. I don't know why they parked it over there for, but anyway, they parked the truck there, and they got in the truck and they left.
Do you remember about what time that was?
That was about 10:30 or 11, somewhere in there. Yeah.
And you saw Bo and Ben both leave together?
Yes.
Leaving?
Overruled that objection.
Yeah, they were living.
Sure.
When they left, was Bo angry?
Yeah, he's a little mad at me, but no big deal. I could have it. I'm a big boy.
Had you given him permission to stay in the trailer?
No.
And
I never had gave him permission to stay in the trailer, which, again, we had heard of problems, so we went over there to take care of it that night.
And were you, did you see Ryan leave with them?
No.
Was he still
Ryan
passed out?
wasn't leaving with nobody. Ryan was back there in the back passed out.
All right, thank you.
But I'd like to say too, I would have gone back to check on him later, but his father was coming in about 2 or 3 that morning. Fred was coming back, so I didn't go back to check on him.
Okay.
Ryan, after I left, I didn't go back and check on him.
So Ryan's dad was coming back to the trailer?
He was supposed to be coming back. If I remember correctly, this has been a minute now.
Right, I understand.
If I remember correctly, Fred was coming in about, I think he would have been in there about 2 or 3 that morning. He would have came back. Yeah.
Thank you. Well, you weren't there when that happened though, right?
No. I'm just saying.
Sorry, any questions, Mr. Williams?
No, he should have come.
Sir, you knew that Bo had been staying with Ryan for a while at the point this occurred.
Did not.
So you're telling the jury that you had no knowledge that Bo had actually been living at that residence?
No, I had a knowledge, one that I had got.
That day?
No, not that day. That last week.
That last week?
Yes.
Okay. So that night, you're telling the jury you went over at 10:30 at night?
When I left, it was 10:30 at night. If you need to listen to me now, I got over there about 8:30 or 9.
So you're saying you were there for 2 hours?
Yeah, working on the air conditioner, trying to get it to work. The whole time, Bo was there, and Ben was there, and Ryan was there, passed out in the bathroom.
And for the whole 2 hours you were there, you never saw Stephen?
No, Stephen never came out of the room by then.
And you didn't tell Ben and Bo to leave until after you fixed the air conditioner?
No, never did fix the air conditioner.
So you let them stay there for an additional 2 hours?
They stayed there for additional 2 hours, yeah.
Okay, even
While
though-
I was talking to them, yeah. I wanted to know what they were up to.
Okay, I'm going to ask a question, and
Okay.
when you're done answering, you let me know, because we're
Okay.
talking over each other, and that's going to upset our court reporter, okay?
Okay, we can do that.
Okay, so,
Yeah.
you're telling this jury that you were there for 2 hours trying to fix an air conditioner.
Okay, roughly, I guess.
Okay.
Maybe it was an hour. Maybe it was an hour and a half. It's been a while, lady.
That's kind
I
of
mean,
my
it's
point.
2000, okay.
That's kind of my point.
All right, so you want to get down to it. Let me see. Let me figure. We moved that day. So I'm going to figure, see, 7. We got 70, about 8. About 9. Maybe 9:30. 9:30, maybe 9:45, somewhere in there. I don't know. 9:30, maybe. I don't know.
And from 2005, when that happened, until your nephew was arrested in 2017, how many times did you talk about the fact that you kicked Bo out of that house with somebody?
I never talked to anybody about kicking
Okay.
Bo out of that house.
But sitting here today, you can tell this jury without a shadow of a doubt that that was October.
And what do you mean by
23rd.
kicking somebody out of the house? I told him to leave. I don't know what kicking and leaving means. You ask somebody to leave, which is what I did.
You told him to leave forcefully, right?
No, I said leave the house, yeah.
And
Now,
he
I don't
never
know.
blew up at you.
Well, I mean, kicking to me is grabbing your butt and throwing your ass out the front door. I mean, that's how I got kicked out when I
Okay.
was growing up.
Well, you said he wanted to fuss with you, though, right?
What?
You said he wanted to bow up
No,
at you,
he stood up like he wanted to bow at me, but he didn't.
and he didn't
But
want
he had
to.
this kind of, no, he just had this kind of weird look on his face. I don't
Okay.
know.
So it's fair to say this wasn't a pleasant conversation you had with Bo, though, right?
I don't know about pleasant, but I don't see where it got out of hand. He understood what I was saying.
Okay. And sitting here today, you can tell this jury without a shadow of a doubt that that was on October 23rd of 2005.
22nd, I think it was. 22nd, 23rd, whatever. Yeah, it was that weekend, whatever that weekend.
It was that weekend.
Yeah.
And you remember it was that weekend because you documented fixing the air conditioner
Yeah, and moving.
and moving?
2 families, yeah.
Okay. And so you must have brought that documentation with you today.
What document?
Well, you just said you documented fixing the air conditioner on that date, right?
Oh, you talking about documentation like I wrote it down?
Yes, sir.
No, I didn't write it down.
Okay. So,
Well, why you want to use words like that and mess me up for? I didn't write it down while I went over there and fixed the air conditioner.
but you're telling this jury, all these years later, you're sure of that date.
Yeah, I'm sure.
How are you sure of October 22nd?
It was the weekend before Halloween.
It was the weekend before Halloween.
I love Halloween.
Of what year?
5.
And how do you know it was 2005?
Because it was 2005. I don't know how to tell you that, because that's when Fred was coming back, when he'd come back from Alabama, and there was a whole thing there. So I remember.
Okay.
Which
And-
you wouldn't know, and I couldn't hardly tell you, to be honest with you.
Was that before or
Fred was
after?
coming back from, I couldn't, we could sit here all day if you want me to try to figure that out. I got plenty of time. I'm
Sir, I got plenty of time too, but
Okay,
I
but I don't
Hold
understand,
on.
you
I get to ask the questions.
Okay.
Judge, let him finish. Judge, he's not answering the question. It's non-responsive.
I overrule that objection. Yeah, y'all just talk one at a time, okay, please? Thank you. Go ahead, Ms. Hart.
Linda Bullington is your wife, right?
No.
She's not your wife?
No.
She's your significant other?
Yes.
And y'all lived together how many years?
A few.
Linda Bullington has very strong opinions about me personally, doesn't she?
Yes.
She never talked to you about it?
Never talked to me?
She never talked to you about what she said about me or Mr. Rigby when she was on jury duty recently?
No.
She never talked to you about the post that she puts on Facebook about this case?
Sweetheart, I don't keep up with all that. I'm sorry.
So that's a no.
No.
You don't ever talk to Linda Bullington about this case?
I don't talk to her about any of this case. I've never talked to her about anything.
And you never talked to law enforcement about this case either, did you?
Not that I know of. Are you going to tell me I did?
I'm asking you, did you talk to law enforcement about this
Yes,
case?
I did.
Well, wouldn't you
But
remember?
Who are you going to tell me I did? Well, who would be? Would it be an undercover cop? I mean, an undercover cop or something like that?
You would remember if you talked to law enforcement about Ryan Duke being charged with murder, wouldn't you?
Oh,
sir?
yeah.
Okay. You've never talked to
No, I
law
haven't.
enforcement. Let me finish my question.
Hmm.
You've never talked to law enforcement about Ryan Duke being charged with murder, correct?
Not that I know of.
And you've never told anybody in law enforcement that on October 22nd that you saw Ryan Duke passed out, correct?
No, I didn't see him. I saw him passed out. Yeah, but I didn't see him pass out. I wasn't the reason why he passed out. If that's what you want. Is that
I
what
don't
you
think, no, that wasn't the question I asked. I said you
I
saw
don't
him
know what
pass
you
out.
asking, Lane. You messing me up.
Well,
you need to talk to me plain. I went to the 9th grade, lady. Okay, help me out here. You playing with me here?
Do you know what the word passed means? Pass out, the phrase?
Yeah. I know.
Isn't that the phrase you used just a few moments ago?
Yeah, when Ryan was passed out.
And you said you saw him on October 22nd.
Passed out, yeah.
Passed out, correct? And you never told law enforcement about that, correct?
No.
And you don't have a clue what Ryan did after you left that day.
Not even no. I do not.
No further questions.
Thank you.
Any follow-up, Mr.
No,
Williams?
thank you.
Mr. Williams, thank you for your testimony, sir.
Yeah.
I'm going to excuse you at this time. Only thing I'll ask of you is don't discuss the testimony you've given here this afternoon with any other witness until the case is over, okay?
Okay.
All right. You got any questions about anything?
No, I'm good. There's
All right. Thank you,
strange
sir.
people in this world. I'm telling
All
you.
right. Take your time.
Oh. Yeah.
Y'all please disregard that, ladies and gentlemen. Got a short witness?
Linda Williamson, yes. Should be the same time as that. Yes.
Thank you.
Thank you.
Good afternoon, ma'am. Thank you for your patience. Before you're seated, please give your attention there to Ms. Murphy.
Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I sure do.
Okay, great. Thank you. And we're trying to make sure that the juror in the far back can hear you, so if you...
They probably won't have a problem.
Okay. Just want to make sure. Can you state your name for the record, please?
My name is Linda Bullington.
Okay. And Miss Linda, where do you work?
I work at Plaza Cleaners in Fitzgerald.
Okay. And how are you related to Ryan?
Ryan is my nephew on my brother's side.
And who's your brother?
Fred Duke.
And Jerry Williams, is he your significant other?
Yes.
Great. Have you ever been interviewed by law enforcement in regards to this investigation?
No.
And did you and Mr. Williams own a trailer in Fitzgerald back in 2005 in October?
Yes.
Who did you let live there that fall?
Well, originally my brother was living there, Fred and Stephen. And then Ryan moved in when it's during the time he was in the Ranger, and he had come back and he was living with Stephen and Fred.
Okay.
And they were the three of them living there at the time.
Do you recall the weekend of October 22nd, that Saturday, and October 23rd, that Sunday?
Yes.
And why do you recall that weekend?
Because that's the weekend that we had bought a house, and we had a double wide trailer. We bought a house, and my mother was going to move to the double wide when we moved to the house. So we was going to move that weekend. We had planned on moving, and Fred had moved to Alabama during this time, and Ryan and Stephen were the only ones left living in the trailer. And Fred had moved to Alabama, but he was going to come home that weekend to try to help with the moving, because my mother insisted that we get this done. She was rushing us, so to speak. She was ready to move. And so everything around that weekend I can remember, because we was doing, this. We had all this to do.
Right, okay. And so on that day, on that Saturday, did you go with Mr. Williams to the trailer?
Yes.
And when you got to the trailer, did you go inside and see Ryan?
When we got there, I intended to own it. But the reason, can I say why we went?
Yes.
The reason we went over there was because we had been there the week before a couple times during the air conditioner was messing up. So Jerry went to try to fix it, and while we were there, the neighbor, because you're talking about from here to that table, trailers apart. You know, they was just back in there pretty close. And we went over there because while he was working on it, someone come outside and
Just don't tell us what's You can tell us what happened. Just don't tell us what someone else said.
The neighbor come over there and was complaining.
Don't tell us what they said.
Hearsay.
You can just say that they complained, but you don't need to tell us what they said.
Okay, the neighbor came over there and complained.
Thank you.
Okay.
I'm sorry.
That's okay. And that was the weekend before?
Yes.
And then did you all come back that next weekend, the October 22nd?
Yes.
Okay.
That was the week before. Park, because we didn't think anybody was there to start with, because the only vehicle we saw was Stevens.
Okay.
And so when they left, when they was coming out, and Ben spoke to me and I spoke to him, and they walked over to the side, and I was thinking, where are they going? And they had parked over to the side, and they got in, I think it might have been Ben's truck. It was a black truck.
Okay. And you saw them leave?
Yes.
Do you remember about what time that was? I know it's been a while, but about.
I'm thinking it was between 9:30, quarter to 10, 10 o'clock, somewhere in there. It wasn't real late.
Did you see Ryan come out or functioning at all that evening?
No.
Thank you. The state may have some questions.
Okay.
Hey, Ms. Bullington, how are you?
I'm good.
Good. Now, Ms. Bullington, the information that you have, you believe is very important to come in and testify about today, isn't that right?
Yes.
And your nephew was arrested in February of 2017, isn't that right?
Yes.
Now, and you would agree with me that right now today, that this is some 5 years after your nephew was arrested, isn't that right?
Yes.
And never once in those 5 years did you ever go to law enforcement and say, I need to tell you this is what happened over at that trailer that night, did you?
No.
Because that wasn't important for you about your nephew.
Because I had the dates confused.
Okay. So your dates were confused.
Yes.
So now you've got them all straightened out.
Yes.
And once you got the dates straightened out, you still didn't go to law enforcement and tell them anything about that, did you?
I did.
Who did you talk to?
I talked to Miss Ashley.
You talked to Miss Merchant.
Yes.
Because you believe she was in law enforcement.
Well, that's when I figured it out.
Okay. So you figured it out for Miss Merchant?
No. I figured out my dates were wrong whenever I was talking to her.
So you had several phone calls with Miss Merchant?
Nope.
How many phone calls did you have with Miss Merchant? Just one phone call. And so with that one phone call with Miss Merchant, you figured out
I don't think
your
it was
dates.
even a phone call.
So what was it? Did you meet with her in person?
No. I think I had texted her about something, about my brother or something, I don't remember. But then she said, oh, I do too. I do remember now. She was asking me the address of the trailer. And I told her, I said, that is not where they were living at the time this happened, because it was the next, because Jerry made them leave. He told them they could not stay there.
But you didn't hear that. You didn't hear him tell them that, right? Because you didn't go inside.
This was after that. He told them they had to leave.
But
yeah.
you did not go inside the trailer that night. You already told us that, right?
Right.
And when he told them that, you weren't there.
I was standing outside.
Okay.
I heard everything.
Okay, so you heard everything?
Yes.
Okay.
But I always thought that the Sweet Potato Pageant was on Sweet Potato Day, which is the last weekend of the month. And I told my brother, I would say, if it would have happened the weekend before, we'd have known where Ryan was. But it didn't. It happened the last Saturday. Sweet Potato Day is what I always thought.
But for the longest time, you had your dates mixed up, right?
Yes.
And you didn't get your dates figured out until you talked with Miss Merchant.
Until she was asking me the address.
And my point was, you never once went and talked to anybody in law enforcement about that, did you?
Well, I did after I figured out that day.
You talked to law enforcement after you talked to Miss Merchant?
No, I told her.
You told Miss
I said,
Merchant?
wait a minute.
So do you believe Miss Merchant is law enforcement?
I thought she was important enough for me to, when I got my date straight, I said, wait a minute.
You understood that she was representing your nephew?
Yes.
So that's the
when I
person you told?
That's when I figured out the date was wrong.
But you did not tell a police officer any of that information, right?
No.
Okay. You didn't think that would be something you need to do?
No, I still don't.
Still don't.
Because when they were asking...
I'll ask you a question, okay? And according to your testimony, you and your husband left there, and you saw, I'm sorry, let me make my question a little better. You saw Bo and Ben leave at 9:30.
Between 9:30 and 10.
Now, how long were you and your husband at that residence that night?
20 minutes.
So it wasn't an hour and a half or 2 hours that y'all were there?
No.
Thank you.
Ms. Merchant, any read?
You know Ryan's reputation in the community.
Everybody likes him. They don't know anything different.
Okay. And what about his reputation for being peaceful or kind? Do you know that?
Oh yes, he's very kind. He's never been a troublemaker. He's never been loud. We never had a problem over there.
All right, thank you.
Can you follow up, Mr. Reed?
Okay,
Just 1 month.
Sure.
Now, you're familiar with Ryan's mother, aren't you, Miss Karen O'Neill?
Mm-hmm.
All right.
Is that
Now,
Yes, I'm sorry.
She's taking everything down. That's all right.
and you were aware that Mr. Duke was arrested for DUI here in Ocilla, weren't you?
Yes.
And that, in fact, you were aware that his mom went and bonded him out for those offenses?
Objection. It's not anything his mom did. It's not in her personal knowledge.
If she has personal knowledge, she can answer the question.
Just a second.
Were you aware?
Please repeat your question.
Certainly. Were you aware that after Ryan was arrested for DUI here in Ocilla, that his mom came and bonded him out?
No.
Okay. You weren't aware that his mom then took him home?
No.
Were you aware that, in fact, his mother called the police on him after that?
She's not.
Just a second.
I'd object. She's already said she's not aware of any of this. He is testifying, and she's not aware of any of the information about what the mother did. It's not inside of her knowledge.
Well,
I can ask the question, see if she has one.
question.
Were you aware that after the DUI arrest, that his mother bonded him out and she called the police on him for his behavior to come back and get him?
No, I was not.
Thank you.
Mr. Merchant?
Does driving under the influence of alcohol in and of itself make you a murderer?
No.
Does it make you an untruthful person?
No, it does not.
Thank you.
Any further, Mr. Ms. Billington, thank you for your testimony, ma'am. I'm going to excuse you at this time. The only thing, don't discuss the testimony you've given to the jury here today with any other witness in the case until the case is concluded, okay?
Thank you.
Thank you, ma'am. You'll be excused at this time, unless everybody else be excused pretty quick. Give me just a second. Y'all want to stand up and stretch? Let me see the lawyers up here for just a minute. Day, sing back time, something like that. 9 o'clock in the morning. We'll see y'all. Please, on time like you always have been. Y'all been very good about it. Don't discuss this case with anybody. Don't talk about it among yourselves. Same drill. Y'all have a great evening. We'll see y'all at 9 in the morning.